Lordship, subject to your Lordship's leave. Lordship, these
Mr. Thor, mention on Mondays only.
Lordship,
So that I can refuse easier.
These and Jalpaiguri matter, Lordship. On last Thursday, 21st July,
Wait for the Jalpaiguri bench. It will soon happen.
Lordship, only thing is illegal construction is going on by criminally remove me from my land, Lordship. They are doing the construction without any order under Section 14 of the SABYASACHI Act, Lordship.
Hand over.
Lord, may I have your Lordship's kind leave to mention one matter for inclusion in the list. It is under
Deeply
the maintenance of the Senior Citizens Act. Lord, the parents have given their property to their children. Now
wait till one day.
They are willing to dispose of the
wait till one day. Call on the list.
Circuit bench, Jalpaiguri, item number 1.
Lordship.
Yes. Thank you. Yes, Mr. Thor, what is the matter?
Lordship, in this matter, Lordship, the auction notice is issued and tomorrow
You have
is.
served on the other side.
I have served upon the Deputy Solicitor General and Bank also, Lordship, through mail, Lordship.
Where is this affidavit, sir?
Lordship, in course of day, I will file. In course of the day before yesterday, I served, and 3 days back, I served upon the Deputy Solicitor General. 3 days back.
Yes, what is the matter?
Matter is, Lordship, without going into the merit of the matter, this is the surface matter. The petitioner's residence is involved in the matter. Only 20 lakhs claim is there. So petitioner want to deposit rupees 5 lakhs at this stage with by installment. So Lordship, the auction may be stayed in the meantime.
When is the auction scheduled?
Auction schedule is, Lordship, that is annexure P2, that is page 18. Page 18 and page 19 is the date.
What is the ground, Mr. Dhar? That is not a sufficient ground. Did you apply before the,
Yes.
you are the borrower?
I'm the borrower.
So you should have applied before this.
No, Lordship.
No, you should have applied before the tribunal. That is, there's a
No,
release
this is
there.
below 20 lakhs, Lordship. So tribunal don't have determination on jurisdiction on this matter, Lordship. That is my arguable point. And the second thing is this, Lordship, there are 3 notices issued. First notice issued, then I submitted the 13-2 application. That was not 13-3 application for consideration of my representation. That was not considered. Second notice issued. And after second notice, by third notice, Lordship, they are revoked the first notice. So these are my.
Why should a 13-4 has been taken out? 13-4 notice has been given.
13-4 notice has been issued.
Then see your remedy lies wherever, because
no, because Lordship, that DRT don't have a pecuniary jurisdiction, Lordship, because it is up to 20 lakhs.
Demand is of 20 lakh 58,000.
15,000 including interest, Lordship.
Even then, you can go before the DRT. So no relief here.
Lordship, I just want to settle the matter, Lordship.
Settle it. 5 lakh is not a settlement. 20 lakh is the entire amount. 20 lakh 58,000. 5 lakh is nothing. If you are agreeable to pay the entire principal amount
within 2 months, Lordship, I will pay the.
No. We cannot stall the sale like that. Learned counsel for
Lordship, at least some time may be given
no,
so
Mr.
that
no.
10 to 15 days, Lordship, at least.
No.
At least within 15 days, I can.
Auction sale won't be stopped. Learned counsel for the petitioner argues that the petitioner is agreeable to pay the dues by installment, the first of which shall be rupees 5 lakh, and the rest by equal monthly installments or easy installments. For sub next para, it is further argued that since the jurisdiction of the debts recovery tribunal is up to rupees 20 lakh, the matter does not fall within the jurisdiction of the tribunal, and as such, no application can be made by the borrower before the tribunal. For sub next para, however, it appears from paragraph number 8 of the pleadings that the demand made is of rupees 20, 58, 653.61 paise, which is above the jurisdiction, above the minimum limit for invoking jurisdiction of the tribunal, full stop, as such, comma, the question of jurisdiction is answered against the petitioner, comma, since the tribunal does have jurisdiction to take up issues pertaining to the said demand. Full stop, next para. Insofar as the argument regarding the agreeability of the petitioner to put in the amount by way of installments, comma, the petitioner ought to have approached the respondent bank on such count previously. Full stop, at the fag end, comma, when the auction sale is fixed tomorrow, comma, such relief cannot be granted to the petitioner. Full stop, next para. Accordingly, WPA 1377 of 2023 along with Can 1 of 2023 is disposed of without any interference, comma, with liberty to the petitioner to approach
Lordship,
the
kindly,
concerned debts recovery
Lordship,
tribunal,
only one
comma,
thing.
if the petitioner so chooses.
Lordship, only one thing, that I have applied under 33, my representation till not considered. It is in the courts, Lordship. It is
Maybe
not
the
considered.
law will take its course, Mr. Dharno. রিটটা নেই প্রথম লাইনে একটা অ্যাড করে দিন, since in view of the urgency, since না in view of the urgency involved, comma, the তাহলে দেখলাম কি রিটের give a copy of the writ, Mr. Dhar,
Lordship,
right now.
copy of the writ annexed in the application, Lordship.
Acha, very well. Since in view of the extreme urgency pleaded by the petitioner, comma, the matter is taken up for hearing as a motion, full stop, due to non-availability of the main writ petition, comma, the copy of the same annexed to the can be treated to be the original writ petition for the purpose of passing orders, full stop, the writ petition is deemed to be deemed to appear in the list. Full stop, তারপর যে অর্ডারটা দিলাম, the আরেকটা লাইন লাস্টে দিয়ে দেবেন, the petitioner shall file the affidavit of service, comma, as per undertaking given by learned counsel for the petitioner, comma, during the course of the day. Thank you.
And, Lordship, with liberty to.
Liberty
settle-
has been given.
Lordship,
শুনুন, যদি রিট পিটিশন না থাকে আপনি আগে বলে দেবেন আমার, হ্যাঁ?
আজকে affidavit of service টা করে দিন।
Item number 2,
But I am appearing for the petitioner, my lord.
Yes, so Jalpaiguri also you have
Yes, my lord.
again educational loan.
This is
If education loan, I'll
same,
reject.
same.
Any other education role
But,
of you, Mr. Bose, I'll reject.
Why, my lord? Your losses.
Too many matters.
That, my lord.
I'm jealous of you, that's why.
No, not at all, my lord.
You're making it a cottage industry, as I told you. No, you have served on the other side.
Yes, my lord. They have received. That is affidavit of service.
Very well.
But the respondent number 7 will
Respondent number 7 is to be direct.
instead of 6.
Despite service, none appears for the respondents. Full stop, next para. The innocuous prayer made in the writ petition is that the petitioner's application for educational loan has not been considered by the respondents. Full stop, next para. Hence, comma, WPA 1537 of 2023 is disposed of by directing respondent number 7, comma, the branch manager, comma, Central Bank of India, comma, Sitai branch, comma, to decide on the application for educational loan filed by the petitioner, comma, a copy of which is annexed to the present writ petition, comma, as expeditiously as possible, comma, positively within 3 weeks from the date of communication of this order to the said respondent. The parties shall act on a server copy, no arrest to cause urgent certificate.
My lord, grateful, my lord. Your lordship is here, my lord. I am getting this.
So anybody will pass this order.
My
Even if you put a bamboo pole here, that will pass. The order.
Yes, my lord. Grateful,
Thank you.
my lord.
Yes.
appellate side matter for judgment, item number 1.
Yes. After that, thank you. You have to respond. My lord. In view of the above observations, WPA 16614 of 2023 is disposed of by setting aside the impugned order dated June 23, 2023, passed in miscellaneous case by Chief Judicial Magistrate Alipur, The petitioner and its authorized officer, however, are restrained by an order of injunction from dealing with and or parting with and or creating any encumbrance on the movable articles, properties lying in the secured assets, possession of which has been taken over by the petitioner through its authorized officer, till appropriate orders with regard to the movables are passed by the tribunal. Liberty is given to the petitioner to approach the concerned tribunal for urging its cause of action on the movable articles on the basis of any hypothecation agreement or otherwise. At the same time, liberty is also granted to the respondent borrower to approach the tribunal where its application under Section 17 of the 2002 Act is already pending, with appropriate prayers regarding the said movable articles. If so approached, the tribunal shall decide such issues in accordance with law upon giving opportunity of hearing to all concerned as expeditiously as the roster of the tribunal permits. Till any such order is passed by tribunal with regard to the said movable articles lying in the immovable properties, that is the secured assets, the injunction order passed above on the petitioner and its authorized officer shall continue. Such injunction, however, shall be subject to any order which may be passed by the concerned tribunal. Relevant issues regarding immovable properties shall be decided by the tribunal upon being approached to do so by either of the contesting parties or both of them independently and in accordance with law. I'm sorry, this should be movable. The relevant issues regarding movable properties shall be decided by the tribunal upon being approached without being unduly influenced.
One indulgence, my lord.
Yes.
Because I have not invoked surfacey in
No, you
respect
have
to the
not.
movables. So I have
I've given you that
agreement.
liberty.
I have an arbitration agreement. I can approach the arbitration to take possession of the movables. There is a deed of hypothecation and the loan agreement contains an arbitration clause. So in that case, I can file a Section 9 application to take possession of the movable articles and to deal with the same. That liberty may be.
I'll make this liberties given to the petitioner to approach the concerned tribunal and or invoke any other remedy if available to it in law.
My lord.
এইটা যেন আপলোড না করে, এই কারেকশন গুলো করে আমি রিসেসে কি সই করে দেবো। থ্যাংক ইউ।
To be mentioned, item number 2.
Lord, I was supposed to put in my written notes of argument. Lord, because of my personal difficulty, could not prepare it. Lord, I need 7 days more time.
7 days?
7 days. But I'm really passing through a very bad phase of life.
My lord, Mr. Banerjee told me
Yes,
yesterday.
he indicated also on the last one.
It is genuine, my lord. I will not stand in the way at all, my lord. Maybe just
absolutely no.
file and exchange simultaneously, lordship, whenever lordship.
Lord, 7 days more, my lord, I will do it.
On the prayer of learned counsel for the respondents, the time for filing affidavit time for filing written notes of arguments by the parties is extended for 7 days. Full stop. The matter shall next be listed under the same heading on August 8, 2023. A little more than 7 days. August 8. এটা একটু সরিয়ে দাও তো অ্যাঙ্গেল করে আমি দেখতে যেতে পাই। হ্যাঁ, থ্যাংক ইউ।
Extension of interim order, item number 3.
I appear for the petitioner.
My lord, Mr. Rajashah is appearing for respondent number 2, 3, and 4. My lord, I'm praying for short possible.
I'll extend the interim order.
The interim order was granted on 9th of June, my lord. It was till 31st.
It was due to expire when?
31st July, my lord.
Yes, you're there. The interim order granted earlier is extended till September 15, 2023 or until further order, whichever is earlier. Full stop. The matter shall be listed on August 28, 2023 for hearing.
The time to file the affidavit in opposition be also extended.
Then very well. Arekta line add kore din. The time to file affidavit in opposition is extended for
3 weeks, lordship.
For 3 weeks from date. Full stop. Reply, if any, shall be filed on the next returnable date.
Grateful, lordship.
Item number 4.
Item number 4, I am appealing for the petition.
I am appearing on behalf of the respondent number 9 and 10, Malda District Central Cooperative Bank Limited.
The
issue that was to be adjudicated was left for
State
adjudication.
and election commission were appeared. They had to.
On the prayer of the election commission, today's date was fixed.
Yes, right.
Perhaps they appealed.
What is the dispute, Mr. Mayor? Just remind me, please.
Well, the dispute was regarding the requisitioning of employees of this cooperative society for election purposes.
Oh, yes.
They had undertaken, they had performed their duties, but whether the state election commission at all has the right to call for somebody or some group of persons who does not qualify as government servants or even
Yes, you
public
said
servants.
they're willing to participate, but this is be subject to this writ
Yes,
petition.
well, because they are
This should be
being-
decided
yes,
finally.
because they are being recurrently deployed.
Every year, yes.
That should be put to rest.
Yes. You are for
Election Commission.
election commission?
Behalf of Sunil Sinha.
What is your argument? Whatever the court pleases.
So their purpose has served. The election is over.
No, this has to be decided.
Decided.
You make your arguments, Mr. Banerjee. I'll
Hello.
close the arguments.
Well, the
Just
only-
remind me the arguments. You made your arguments
Yes,
on the
well,
last.
kindly glance, takes a glance. The only one point was left for consideration. Because one government nominee director acts as the CEO of this cooperative society. The claim of the state was that
You were supporting his contention.
My lord.
not really.
Last occasion, my
Not
lord
really.
order dated 5th July.
He is a cooperative society.
Cooperative bank.
I'm sorry, bank. Yes.
Number 9 and 10. My
Right.
lord, short report, statement also produced before this court, honorable court, my lord, 6 July.
Yes, yes. That report, what did you say there? Just even.
Along with.
Oh,
my lord,
government deputed CEO exercises powers and his duties as prescribed such and such.
along with
This
my
was
lord,
the point.
Audited statement, balance sheet as on 31st March 2023, my lord.
Now, Lordship, may I make my
I'm just,
My
I'll
lord.
just come back to it. This was produced for what purpose? This audited balance sheet?
My lord, last occasion,
Yes.
the
yes.
petitioner paid the total expenses incurred by the bank and also many questions raised before. this
You
court,
say
my
that
lord.
the bank, the government also puts in something here.
They had asked me 5% stake only.
Acha,
just to clarify the point that this bank does not receive any grant or aid from the
From the
government.
government.
Only 5% share capital are invested in the shares. 5%. They own 5% shares.
that is the stand of the bank.
That is the stand that as is forthcoming from the report.
Then they're
That is-
supporting you.
Yes. And that was my claim. I had put in the averment because I am an employee. I know this fact. But still, as they were appearing, your lordship had called
Who
for
wants to
stop.
lose their employees to election purpose?
But perhaps somebody are injured, but they're alive.
No,
Some of them have been-
this time they're alive.
They are-
Luckily, yes. Anyway, Mr.
My lord,
Banerjee, let us
just to
conclude
distinguish,
the arguments.
my lord, the only point that was remaining for consideration was whether this government deputed CEO will stand in the way or not of that being a government undertaking or not.
Yes.
My lord, I had cited one judgment of SS Rana. That is already on record, my lord. Lordship, has it? SS Rana versus.
Yes, Rana was right. Right.
Lordship, kindly takes paragraph 4 at page 2 once. Well, this judgment considered the scope of the Societies Act of State of Himachal Pradesh.
Right.
Now, these exact paragraphs of that act has been reproduced from state paragraph 4 onwards. Kindly see 35B at the last of page 2.
Yes.
Appointment, powers and functions of managing directors. Now, there also, there was a provision for government nominee director. And this is a mandatory requirement of the statute, same as was the case in Himachal Pradesh Act. The same is this case in the West
Your
Bengal.
case is governed by West Bengal.
West Bengal Act also contains a provision that is section 32. 32. May I place the act then, my lord?
No,
Cooperative
if it
Societies
is
Act,
similar for the time being, need not.
similar, and the exact provision is section 32.
This is the West Bengal Cooperative Society.
Cooperative Societies Act.
Right.
2006.
I've just noted the corresponding section. Yes.
My lord. And the corresponding rule is rule 56(1) of the cooperative societies rules, which say that he has to perform his duties as CEO. He will be designated as a CEO. The designation as mandatorily requires that he will be the CEO. The government appointed nominee will be CEO.
Yes.
And section 32 specifically provides that whenever government buys the shares or anything more than 5 lakhs, invest in the company or the entity more, if the investment is more than 5 lakhs or the buying of the shares amount to more than 5 lakhs, then the government has the power to put in one nominee director. And that nominee director, as per the rule, shall act as the CEO. This is the mandatory requirement. And the judgment specifically deals with this one government nominee, because this cooperative bank maintains the salary of the employees from its own funding. No grants from the government, no control over the company, just the nominee who performs statutory duties. Now, if your lordship sees the exact part, page 8, my lord. Page 8, fourth line from the top. It has not been shown.
Page 8 of
The SS Rana judgment.
yes.
Paragraph 5, it is. The fourth line from top, it has not been shown before us.
Yes.
It has not been shown before us that the state exercises any direct or indirect control over the affairs of the society for deep and pervasive control. The state, furthermore, is not the majority shareholder. The same is the case here, 5% share. The state has the power only to nominate one director, the same case. It cannot thus be said that the state exercises any functional control over the affairs of the society in the sense that the majority directors are nominated by the state. Because here also, out of 13, only one nominee director. Rest are elected. 14 are elected. Now the 4 tests have been laid down, as was the case in the Ajay Hasia. Ajay Hasia, thereafter, the same has been distinguished, and it has been held that one director will not stand in the way, and they cannot be termed to be instrumentalities of the state. They will not qualify.
Right.
So this probably deals with their point. One more thing, section 2, subclause 2 of the West Bengal Cooperative Societies Act specifically says that the state shall not interfere.
Read it out, Mr. Banerjee, and just hand over. Just read out for the time.
Well, I haven't read it. The state shall not interfere in the
Section 2.
Section 2, subsection 2.
Yes. Right.
There is a statutory bar. Except as provided, that is the appointment of the nominee director and
Yes.
functions of the rules.
Irreferative.
And relying upon this SSJana, this High Court has delivered several judgments, my lord, on this point, that they do not come on the ambit of Article 12 or the instrumentalities of state or any other authority under Article 12 definition. All. Order.
Yeah, this is all. Yes, you want to add anything? Heard learned counsel for the parties. Although the election process, although the panchayat election process, for which the members of the petitioner society were requisitioned is already concluded, the larger issue as to whether the state is entitled to engage employees of such a cooperative bank as the present one was kept pending, the writ petition was required to be heard on merits. Next para, heard learned counsel for the parties on merits. Hearing is concluded, judgment is reserved. Thank you.
My lord, kindly add on.
It a particular.
Paragraph, my lord.
Yes.
For audited financial statements, my lord, of the bank as on 31st 2023, my lord, the government of West Bengal holds 55,480 shares of rupees each, 100 each, totaling about rupees 55.48 lakhs. Other shareholders holds 982,030 shares at the rate of rupees 100 each, totaling to rupees 982.03 lakhs. Total share capital of the bank is 1037.51 lakhs, my lord. My lord, in the light of the above, the bank is not in a position to determine whether it can be termed as government-aided bank or run under the government control. The question remains open to the decisions of the Honorable High Court upon reference to the above mentioned rules of the Cooperative Acts and rules of the state.
Thank you.
That
Yes.
amounts to 5%. Comes to
Anyway, I'll decide.
grateful.
I am paid to decide. You are not paid to decide, so I'll plead.
I comply, my lord, order, my lord. I serve the all.
What order?
Already on
respondent.
record.
Audited report, audited report. Last occasion, my lord, order. I comply, my lord.
Should I keep it on record?
No, one copy is there. My lord, kept in record.
আচ্ছা
Already
এটা রেকর্ড রেখে দিন মাধববাবু একটা লাইন অ্যাড করে দেবেন the receipt filed by learned counsel appearing for the bank be kept on record.
Much obliged.
Thank
Grateful.
Item number 5 and 6.
Yes, 5 and 6. Yes. Yes, Mr. Hoda.
I appeal for the petitioner, my lord. Lordship had
Copy served.
Lordship,
Yes.
Copy
respondent
served,
number
right.
6.
Please take your seat, Ms. Ghosh. I'll just see. Yes, Mr. Hoda.
Sir, my lord. But as I was my lord, placing yesterday, my lord, that before my lord going or taking your lordship through the documents, my lord, may I, my lord, very briefly, my lord, state the facts of the case, my lord. My lord, for the reason that there are 2 writ petitions, my lord, and I will not be pressing one of them, my lord.
Yes.
My lord, petitioner before your lordship, my lord, is my lord a hospital, my lord, being run, my lord, in my lord Uttar Dinajpur, my lord. My lord, I have a license, my lord, to run the hospital as well as my lord the diagnostic center, my lord, in the hospital itself, my lord. The writ petition, my lord, pertains, my lord, only to the diagnostic, my lord, and not the hospital, my lord. Now, my lord, for the purpose of running a hospital, or my lord, I'm sorry, for the purpose of running this diagnostic in the hospital, my lord, I have to have certain licenses, my lord, which, my lord, I had, my lord, and still I have, my lord. And apart from those licenses, my lord, I also have an agreement with respondent number 6, my lord, for the purpose of disposal of my biomedical waste, my lord. My lord, this being the situation, my lord, in 2020, my lord, my hospital was requisitioned by the state of West Bengal for the purpose, my lord, of using it as a COVID-specific hospital, my lord. Now, for this period, my lord, there is dispute, and for which, my lord, there's a writ pending, my lord, for the purpose of, my lord, dues, which, my lord, the state owes to the hospital, my lord. Now, my lord, since respondent number 6, my lord, had provided services during this period as well, my lord, so respondent number 6, my lord, issued, my lord, a demand notice upon me, my lord, asking me to make payment of certain, my lord, amount, my lord. My contention is, my lord, that the amount mentioned in the notice is arbitrary, my lord, and is overstated, my lord, primarily because of the reason that I am not required to pay for the period that, my lord, my hospital was requisitioned by the state of West Bengal for the purpose of, my lord, using it as a COVID-specific hospital, my lord.
Respondent number 6 is a private entity.
Is a private entity, my lord.
So does the writ lie?
No, I have no praise against, my lord, respondent number. I'm coming to the point, my lord. My lord, in this situation, my lord, since, my lord, I did not make payment, my lord, admittedly, I did not make payment as per their demand, my lord. They, my lord, send me a notice of termination, my lord. My lord, terminating the service agreement that respondent number 6 had with the petitioner, my lord. In this situation, my lord, I am served with a show cause notice, my lord. Although, my lord, the notice specifically does not say show cause, but, my lord, it's in the nature of a show cause notice, my lord, asking me to, my lord, sorry, my lord. In the meantime, my lord, first I make an application for renewal of my clinical establishment license, my lord. Since, my lord, it was about to expire, but I make, my lord, the application much before the expiry, at least a month before expiry, my lord. But while this is, my lord, pending, my lord, I get a letter, my lord, a show cause, which I'm saying is show cause, my lord, asking me to, my lord, submit the agreement that I have with respondent number 6. The service agreement with respondent number 6.
Your contract was terminated because you did not pay up the respondent number 6.
Yes, respondent number 6.
That's one of the clauses.
That's yes.
That can be done.
My lord, so, my lord, I am asked, my lord, and the specific, my lord, they are specifically named in the agreement that my lord, as if, my lord, I have to have an agreement with respondent number 6, my lord. Respondent number 6 is a private entity, my lord, and, my lord, I can have an agreement with X, Y, Z also, my lord. Or the purpose should be served that the biomedical waste should be disposed, my lord. So, my lord, I come up, my lord, in a writ petition before this honorable court, my lord, challenging the show cause notice, my lord, that how can you ask me to have specifically to have an agreement with 6, my lord? In the meantime, my lord, while this writ petition was pending, my lord, I am served with a notice of, my lord, rejection of my renewal license, my lord. Therefore, my lord, my first writ petition, my lord, becomes, in my, my lord, knowledge, my lord, my lord, humble submission, my lord, it becomes infructuous because I had challenged the show cause. The show cause has culminated into, my lord, a notice of termination, my lord. Therefore, my lord, this second writ petition is filed. So, my lord, item number 6 is the
Give me
first.
the petition numbers,
My lord, the first writ petition number, my lord,
which is infructuous.
Yes.
13843.
13843.
That is infructuous.
That has become infructuous, my lord, because they have already terminated my license, my lord, because of non-renewal, my lord.
That was challenging the show cause.
That was challenging the show cause, my lord.
Yes.
Now, my lord, what has happened is because, my lord, the reason why, my lord, my renewal application was not allowed or cancelled, my lord, the only reason being, my lord, I did not have an agreement with 6 or, my lord, with 6. So, my lord, in the meantime, my lord, I now have an agreement with 6, my lord. I now have
That
an
was
agreement
entered
with
into between the show cause and the termination.
No, my lord, after the termination, my lord. But that, my lord, that is the point, my lord. But be that as it may, my lord, today, as on date, my lord, I have an agreement with 6, my lord. 6, my lord, is already has, my lord, is ready to provide services to me, my lord. That is, my lord, the sum and substance of the writ petition, my lord.
So
And
then
my lord,
every time after a contract is terminated for your non-compliance of some term, you will do this. No.
my lord, I can be penalized
No
for that.
cases at all, Mr.
I can be penalized for that. Let's
Subsequently,
say, for example, because I'm not running the hospital now.
show me that you could not be terminated for this.
My lord, I will be, my lord, relying on the clinical establishment rules, my lord, for that, my lord. One of the,
First, show me the clauses of your contract under which it was the show cause was issued or this termination was issued.
my lord, I should, my lord, make directly, my lord, lordship has, my lord, understood the, my lord, facts of the case. May I
Not
directly come
exactly.
to,
I want to see the termination clause.
yes, my lord, lordship will kindly come to, my lord, the notice of termination. That's the last annexure, my lord, page 95. That's the cancellation, my lord. And if I may take, my lord, to page 67, my lord, first.
Oh, they are relying on the rules themselves.
Yes, my lord.
67.
And here also, my lord,
No, they terminated you under any particular clause.
my lord,
Or under the rules
termination,
generally.
lordship is talking about termination of respondent number 6, my lord, who now has an agreement with me.
No, the last cause of action.
The last
Your
cause of
contract
action, my lord, is cancellation of my renewal application.
Oh, achha.
That's cancellation of my renewal application, my lord, by CMOH, my lord.
But there is no bar if your previous you are given a show cause. Show
I
cause
was-
for what?
Show cause,
Showing
my lord.
cause, yes.
I'm saying it's a show cause notice. Show cause was, my lord, for the purpose of, my lord, supplying the agreement with respondent number 6.
Oh, that was regarding the renewal agreement. You had
Yeah.
applied for renewal at that point of time.
Yes.
Well,
My renewal application was prior,
get
my
your
lord.
point, yes.
Renewal application was prior in time, much prior in time, my lord. In April 2023, my lord.
So under which provision can they do it?
But I say, my lord, they cannot do it because I will just show, my
Show
lord,
me their best clause first.
one of the rules, my lord.
Because they will in any event show it. So show it before that. What is there?
They do not,
There's
my lord.
nothing.
No, there's nothing, my lord. If your lordship will kindly, my lord. Well, this is the West Bengal Clinical Establishment Rules 2017, my lord. Now, your lordship will kindly come to, my lord, Rule 21, Sub-Rule 4, my lord.
Yes.
This, my lord, keeping in mind that, my lord, the reason why, my lord, my renewal license was not accepted or rejected, my lord, is because I did not have an agreement for disposal of, my lord, the clinical waste, my lord. Now, 21.4, if may I read, my lord? In order to ensure the sanitation and hygiene, the clinical establishment shall either obtain the
So, Mr.
authorization.
Huda, would it suffice if you are given a liberty to apply for again for a renewal, now showing that you have entered into this agreement, if they consider you? Because otherwise, what would be the utility of adjudicating this writ petition? If this, because at that point of time, undoubtedly this was not there. Or do you want to say that
But
provision is not there at
that
all?
provision is not there, my lord.
Very.
If may I read, my lord, 21.4, my lord?
Right.
Because I had a no objection certificate, lordship, I had shown on the very first day, my lord. It says, my lord, 21.4 says, in order to ensure the sanitation and hygiene, the clinical establishment shall either obtain the authorization, license, no objection certificate, which I have. and which is still valid from Pollution Control Board under the Biomedical Waste Management and Handling Rules 1998, and shall submit a copy of such along with the application for new clinical establishment renewal thereof. So, my lord, all this was done, my lord. They have harped on, my lord, of for having an agreement. My lord, even the rules does not anywhere say, my lord, that I have to have an agreement with, my lord, a third party for the purpose of, my lord, disposal of my biomedical waste, my lord.
Is there anything regarding disposal of biomedical waste in these rules? They have
This
also
is
referred,
about this is it, my lord.
no, they have also referred to the 2016 rules. Biomedical waste management rules.
Yes.
Read with, they have said. In their notice, they have stated regarding
Yes, the-
2016 rules also. Show me from that also, what are the requirements there?
The 2016 rules, I'll show, my lord. Even that, my lord, does not speak of any agreement, my lord, which I should have with, my lord, a third party for the purpose of disposal, my lord.
So you say there is nothing on
There is
nothing.
nothing as such,
So
my lord.
let them say what
Yes,
there
if
is.
they can show, my lord. But, my lord,
In
as I
reply,
said,
you'll answer yes.
yes, my lord. As I said, my lord, as on date, my lord, I have an agreement with them, my lord. I have an agreement with
That
respondent
at least
number 6.
entitles you to make a new renewal application. Nothing more.
That too, my lord, only, my lord, elongate the whole process, my lord, because ultimate result perhaps would be the same
Very well.
if
Let us hear them.
it's a hospital at the end of the day, my lord.
True.
Which,
Diagnostic center.
Without a biomedical waste disposal.
but with a no objection certificate, my
The
lord,
entire neighborhood will become a
I
hospital.
have no objection certificate. I'm doing it myself. As of now,
No
I'm doing it
objection is like a car pollution thing. Cheat.
but the
We
the
can
rules,
see the exhaust gushing out black smoke, but there is a certificate.
but the rules say so, my lord, and we've been handling it, my lord, as on date, my lord.
You have
But
to
in
have
fact, my lord,
some system in place for waste disposal.
No, in fact, my lord, as on date, my lord, we are not running the pathology.
Can you let
because
us
of
hear
that.
them on
Yes,
what they
yes,
like?
yes.
Yes, Ms. Ghosh, on what
I am appearing for the respondent number 6, your lordship.
6 does not. Have you served on the state?
Yes, sir.
What is your stand in the matter?
Last annexure, agreement not valid. Page 95, annexure page 16, your lordship. Last paragraph, however, you have failed to submit the valid agreement with CMBT, approved WC alternative arrangement.
What are you placing? Oh, it's a page
Page 95, annexure page 16, your lordship, rejection H.
Yes, yes.
Last line, your lordship, we have failed to submit the valid agreement.
Valid agreement, that is for waste disposal.
Yes, and next thinking, your lordship, wastage generated of WC till date.
Yes, that is what I'm asking you. Can you do that? Under which provision can you do this? If they don't have such an agreement, can you terminate them? Show me that provision. That if they don't have such an agreement, you can terminate them. Or it's mandatory. Only show me that.
So lordship, kindly give me instruction till you.
No, no.
No, lordship.
You don't record any instruction for law.
Lordships, West Bengal Clinical Establishment Registration Regulation transfer 2017, your lordships 17.
Yes, that was handed over by a lawyer.
Section 7, your lordship. Conditions for registrations and licensing.
No, my lord, I
Section
have handed
17.
over the
Section
rules, my lord.
7E.
My learned friend is referring to the act. I have
Oh,
handed
acha,
over
acha.
the rules. He is referring to the act.
Have you got a copy of the act?
I have a copy of the act.
Section 7E, your lordships. Criteria, your lordship, fulfill the conditions.
This is 7, not 17.
7.
7E. Yes.
7.
Here it says that no license shall be granted in respect of a clinical establishment. E says unless it has made arrangement for disposal of biomedical waste as may be prescribed. Have you prescribed anything in the rules? Show me from the rules that this has been prescribed actually. Something must be there. Prescription must be by rules. You are not at all prepared in the matter. Why do you represent the state? You don't have a right to represent the state. You are not at all prepared in the matter. You have just come here to take your fees. Absolutely. Very sorry state of affairs, I must say. You should not be in the panel. You're wasting court's time. On the last occasion, you are not prepared. Today, you are not prepared. Why do you appear for the state? This is the reason why your state is in such a condition. Not advocates like you.
In this regard, so let's kindly.
You're not at all in the matter. Your lawyer friend is helping you out totally. And he also reading rules. You are citing something which says as per prescription, as prescribed. You are not showing anything to say that it is prescribed. Yes, these are the rules. Every act, like section 2M of this act, every other act also says prescribed means prescribed by rules made under this act. Show me from the rules, where is the prescription? Get your order. 1 minute matter, you are asking for instruction from your client on law. I'm surprised. This is the basic. You only needed to do 10 minutes research work. You did not do that also. And you come up here to represent the state of West Bengal. If the court has to find out anything, what is the reason of appointing you? Don't live here. These are the rules under this act.
What I could find, my lord, is
21.
21. And if I may, I show, my lord, the NOC, my lord, which 21 refers to in the writ petition, my lord.
Yes.
It's at page 25, my lord. It's from the, my lord, West Bengal
এই
Pollution
বইটা
Control.
আনিয়ে নিন বাবু, এই বইটা আনিয়ে নিন একটুখানি। বইটা আনিয়ে নিন।
And my lord, it's from the West Bengal Pollution Control Board, my lord.
Page
25, my lord. Lordship will see on the top, my lord, West Bengal Pollution Control Board. And my lord, if your lordship turns to, my lord, page 28, my lord,
L
2810.
26L is also there.
26.
You have to maintain an update on day-to-day basis the biomedical waste management register. That has to be anyway. 28, which one?
28, my lord, I just wanted to show, my lord, the validity of my NOC, my lord, which is, my lord, up to 30th of November 2028, my lord, clause 10.
Yes.
And I have shown, my lord, rule 21, my lord, sub rule 4, my lord, which says I have to have an NOC, my lord. Either an NOC, my lord, or a license, my lord. So I have.
আছে আমাদের কাছে আছে আমাদেরটা 19-এর এটা ফেরত দিয়ে 22-এর নিয়ে আসতে বলুন ততক্ষণ ওদের বইটাই দিন আমার 22-টাই দিন
And my lord, if I may say, my lord,
Yes.
after this notice at page 95, my lord, I have, my lord, stopped my, because this says, my lord, that with immediate effect, so I have stopped my diagnostic work, my lord. Now that I have an agreement, my lord, and this writ petition is filed where I have made prayers for this, my lord, if, my lord,
No,
I
Mr.
can be allowed.
Huda, there is a specific provision in the act. As per prescription, you have to do it as prescribed. Under section 7E, that is
Prescribed,
there.
but prescribed, my lord, in the act also, I could not see any, if I have to have any agreement with a third party for the purpose of.
Agreement is not there, but if there was no agreement, there was no arrangement also. You have to show something to prove your arrangement.
NOC, my lord, NOC. I have
NOC
the
is not an arrangement for waste disposal. 7 says conditions for registration and license. No license shall be granted in respect of a clinical establishment unless it has made such arrangements for disposal of biomedical waste as may be prescribed. They are entitled to insist that you produce something to show that you have an arrangement, something at least.
So either
Agreement is the only thing you can show.
either I have to have an arrangement with a third party, or I can arrange it myself. This does not say that arrangement.
Did you produce any document in that regard?
I
No,
don't,
as may be prescribed there, as may be prescribed comes in. That is the difficulty.
Lordship, herein, if I may be allowed. to
Yes,
say,
yes.
Lordship, if your Lordship may very kindly remembers me doing other matters, there was a zone 1, zone 2. So this is for the zone, your Lordship, wherein this is the only biomedical waste treatment facility. And they have to have an agreement with me. There is no option to have with anyone else. And Lordship, the rules provide
That
in
will
Rule
only
20.
come in if there is something prescribed for this. I mean, if it is not a mandate of the statute, then they cannot terminate this person. No?
Lordship, the rules in Rule 29 provides for validity and renewal of license. The rules which has been handed over to your Lordship. Rule take 100.
This does not pertain specifically to any waste disposal thing.
Lordship.
This is, my lord, clinical establishment license, my lord, which I have applied for.
That
my
is
lord.
different.
Yes.
May I hand over this rule?
এটা কি দিলেন স্যার?
Biomedical rules.
রুলস নিয়ে কি হবে?
Biomedical.
বায়োমেডিক্যাল রুলস নিয়ে তোমার লাগবে না তো কাছে, ওটা বায়োমেডিক্যাল রুলস তোর কাজে লাগবে না।
The difficulty is this is under the Environment Protection Act. But here the definition of prescribed in your 2007 Act is no, as in every act prescribed under section 2M of the Clinical Establishments Act of 2017. Prescribed means prescribed by rules made under this act. It has to be under this act. And this act 7E says made such arrangements for disposal of biomedical waste as may be prescribed. So this prescribed means under this act, under the 2017 Act. This is under a different act which you are relying on. This is under the, it's written here. Then now, therefore, in exercise of the powers conferred by sections 6, 8, and 25 of the Environment Protection Act 1986. And this is by the government of India. This is a state act.
Yes.
How can rules be framed by the central government under a state act? What are you saying?
I found and print out these petitions, your Lordship, sex action, set these petitions. I found out this.
So, Huda, probably you are not required in this matter for the petition.
I'm sorry.
State is sufficient for the petitioner. State is sufficient for the petitioner. You are not required probably also.
2M, my lord, is one that I have.
No,
handed
there
over.
must be some rules.
Yes, my lord, 2017, which I have
Something must
handed
be
over.
there.
If your lordship sees, my lord, M prescribed means prescribed
I'll
rules
keep
made.
this judgment reserved. I'll find out something against you, whether there is something against you in the
Your
rules.
lordship wants, of course, your lordship.
No,
will
no,
give
no,
it.
because
That
I
is
want.
sure, my lord.
If there is anything, I'll find out. If there is nothing, then I cannot find out. Then we'll go without waste management.
No, I have an agreement now.
Now you have an agreement after your termination.
But
Then you have to apply again by satisfying the authorities that yes, that agreement is there. That I can do right now. No, Mr. Huda, this has to be decided also. I'll take 1 or 2 days. I'll just go through these rules for this only. Maybe I'll take the weekend. I'll pass my order on Tuesday.
May I say this, my lord, subject to whatever, my lord, your lordship feels, my lord. Lordship had also suggested this, my lord. Lordship will kindly, my lord, ask them to, my lord, consider this, my lord, within a period of 7 days. Why I'm saying a week, my lord, because it's a hospital at the end of the day. But now that I have, because the only reason why they terminated is, the only reason is because I did not have an agreement, which admittedly
No,
I have.
Mr. Huda, you don't get this. If there is no mandate in law, then there is no compulsion on you to have this also.
That's
But
true.
that
my
is a
lord.
very precarious situation.
That's true, my lord.
Maybe we'll have to read this act into this rules into this. But there has to be an order of court then.
That's
There's no
the
precedent
only-
is cited.
The only prejudice that I'm facing is, my lord, I'm unable to run, my lord.
We need to
my
file the writ
hospital.
petition. I'll check up.
Well, as well, very soon after.
June 23,
No, no.
That is the first.
date of affirmation at least is June 23. Oh, that is the earlier writ petition.
Earlier, my lord, this was
10 days back, yes. You are not operating this hospital now.
no, I had to stop, my lord, because after this page 95 notice, my lord, pathology I had to stop, my lord. I could not operate, my lord, my pathology department without, my lord, the license. 17th
Mr.
of
Huda,
June.
this has to be decided. I'll keep the judgment pending. In the meantime, if you approach them, they can do it. That will be without prejudice. I'll give you liberty in the meantime before I pass my judgment. Even you can approach them by annexing the new agreement with them. And if they feel, they will allow you. Then I'll just make this. That will make this infructuous only. But this requires to be decided. My judicial conscience does not permit me to let this alone.
By now,
Not for
my
any
lord,
other reason, Mr. Huda. It cannot be that there is no rule just because there is no prescription. This can go scot-free.
no, no.
Without any
No.
biomedical waste disposal management, you will be running a hospital or a clinical establishment. It cannot
My lord,
be.
that's-
Sir.
under this act, my
Not be.
lord, under
Under
this,
the Environment Act, there is.
no. My lord will kindly see, my lord. Lordship has already read, my lord. I'm just repeating what your lordship
7E.
said. E, my lord, and then M. M says prescribed. Prescribed means
Yes.
prescribed by rules made under this act.
This is
act.
that rule.
No, yes, 2017.
These rules are pretty thick. You have only placed one provision of that. I'll go through the other provisions, Mr. Huda, if I'm not clear still.
Yes. By now, my lord, I know your lordship. My lordship.
I'll go through all
Conscience
the
has
other
to be
provisions.
clear,
I'll
my
try
lord,
to find out something
Yes, I know
which
that.
goes against you so that the act has a meaning, Mr. Huda. Act has to have a meaning. Act says, as prescribed, you do it. Then I don't prescribe. Can it be? If that is so, that chink has to be filled up.
Well, my understanding
That's
is,
why, Mr. Huda, I'll keep this matter
Yes,
pending,
yes.
reserved for judgment. But in the meantime, I'll permit you to apply for a fresh renewal by annexing their agreement with them, and they can allow that. If you want an interim order, I'll grant stay of all further proceedings.
what interim can I ask? My lord, I have myself said
Nothing will be done in the meantime regarding your hospital. Status quo regarding your hospital. You can ask for that also. In some cases, that is also asked.
then I'll ask for it, my lord.
There's no
At least,
purpose of that.
Because
Lordship, I'm appearing for the respondent number 6. We have already renewed their agreement. Your
Yes,
Lordship.
yes.
এটা
আচ্ছা একটা order record করুন। এখানে waste time waste হয়। Learned counsel for the petitioner contends that despite there being no specific provision for entering into an agreement for waste disposal management on the part of a diagnostic center, comma, the respondent authorities refuse to renew the license to the petitioner to run its diagnostic center on the ground of absence of any such agreement. Full stop, next para. It is submitted that in the meantime, comma, although after the refusal, comma, the petitioner has in fact entered into an agreement for waste disposal management with the respondent number 6 and comma as such, comma, is now prepared to apply for a fresh renewal by annexing such agreement. Full stop, next para. It heard learned counsel for the parties, full stop. It transpires upon hearing learned counsel for the parties that the corresponding provision in the rules framed under the West Bengal clinical establishments within bracket registration, comma, regulation and transparency, bracket close rules, comma, 2016 does not speak specifically about the mandate to have an agreement for waste disposal management. Full stop, next para. Although Rule 21 of the said rules refers to sanitation, comma, hygiene, comma, safety and security, comma, it is apparent that no specific provision as to such agreement regarding waste disposal management finds place in such rule. Full stop. However, comma, the larger issue which remains is comma, how the state of West Bengal has given effect to section 7 within bracket small 7 within bracket 1 within bracket small p of the 2016 column 2017 house to the 2017 Act, insofar as the said provision stipulates that the licensing authority shall not grant a license to a clinical establishment unless it has made arrangements for disposal of biomedical wastes as may be prescribed, and comma, whereas section 2 within bracket small m of the Act provides that within double inverted prescribed means prescribed by rules made under this Act, comma, there is no such corresponding rule prescribed under the Act with regard to waste disposal management. For sub next para, although learned counsel for the state seeks to place reliance on the biomedical waste management rules, comma 2016, comma, it transpires from the notification dated March 28, 2016, comma, handed over by the state, comma, that the said rules were framed under sections 6, 8 and 25 of the Environment within bracket Protection bracket closed Act, 1986. Full stop. If that be so, strictly speaking, the said rules do not come within the purview of section 7 within bracket 1 within bracket small e, read with section 2 within bracket small m of the 2017 Act, and as such, a question arises as to whether the same can be applied to the instant case. Full stop. Since such larger issue remains, hearing is concluded and judgment is reserved on the said issue. Full stop. However, it is made clear that even during pendency of the writ petition, if the petitioner approaches the respondent authorities afresh for renewal of its license to run its clinical establishment / diagnostic center, by annexing a copy of the fresh agreement entered into between the petitioner and the private respondent for waste disposal management, the respondent authorities shall consider the same, and if other provisions of law and formalities of law are complied with, the respondent authorities shall be at liberty to grant such renewal in the meantime. Full stop. Such renewal, however, shall be subject to the outcome of the writ petition.
Grateful to you.
এই বইটা এটা ফেরত দিন। So 22 I am keeping the copy of these rules.
May I say this, my lord?
Page 26 is relevant.
Seen that? Which one? Seen entire 26. Which one? Tell me. The closest is probably maintain and update on day-to-day basis biomedical waste management register. That does not pertain to this issue. They will maintain their register. They'll tomorrow, if I direct Mr. Huda, they'll produce their register. They'll show that yes, we are maintaining it.
But may I very humbly say this, my lord? Lordship in the end, my lord, has, my lord, observed that, my lord, my renewal, my lord, if in the meantime, if it's allowed, my lord, that will be subject to this writ petition. My lord. But perhaps, my lord, perhaps not subject to.
What is that? You have already handed over a copy.
Water pollution.
What is?
My lord, what I was saying, my lord, because, my lord,
It will be subject to the outcome.
but, my lord, writ petition, my lord, is whether I require it or not. And, my lord, the renewal, which your lordship has given me liberty, my lord, will be, my lord, subject to whether I
I
have.
say it's not required at all. Then respondent number 6 case goes.
It's a win-win situation for me in that case.
Do you understand what I'm saying?
Yes, my
This
lord.
agreement becomes irrelevant.
Yes, my lord.
Ms. Ghosh's client loses then. Even if you don't win.
A bit late, but I've now understood.
Follow next.
Grateful to you.
ওনাদেরটা এমনিতেই ফেরত দিয়ে দিন।
Now, lordship has given a
এটা বয়স এই সময় ফেরত দিন।
lordship has given a time frame, my lord, within which period, my lord, it should be.
We shall pass this order.
No, 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 no.
They will pass the order.
Yes, yes, my lord. Renewal, my lord, for renewal.
No,
If your
before
lordship,
that, probably the judgment will come.
if your lordship could, my lord, kindly could. No.
Got it.
Item number 7.
7, yes.
I am for the petition. Well, I'm married to a Bangladeshi national lady.
Right.
2019. Under the Special Marriage Act. Thereafter, she came to India with me on a valid passport and visa. She stayed here. In the meantime, I was working in the USA. I went to USA, came back. Now, there was some matrimonial dispute, and I found that my wife is unscrupulously.
You are for the wife of the state.
No, I am for the Union of India.
Union of India, I'm sorry, not the state, yes.
She has procured voter ID card of India.
Have you implemented your wife?
Yes, I've served the copy local address which they have provided.
Served to your own address?
No, no. The address of the father which they have claimed.
Very well, yes.
And not only she has got the voter ID card, she has also got the PAN card, which I have subsequently got the PAN number after filing of the writ petition. And she has opened a bank account at Canara Bank. Now she has probably applied for the Aadhaar card also. So in this way, she is trying to get the citizenship of the country without any valid. That is my case.
So instead of a divorce, you want extradition. Divorce in the form of extradition.
Divorce can be granted also subject to that one of
You
the
don't
ground is
require a divorce if she is extradited.
subject to lordship. The thing is that
We used to joke in our advocate days that you need not require a divorce for a foreign national. Just get an extradition and that suffices.
but
So this is precisely such
my
a
case is that that intention.
What is
of
your locus standi to say that?
being a citizen of India, it was my duty to point out.
Oh, malafide application.
But this cannot be allowed, lordship, because there is no.
On
such
malafide,
provision.
it can be dismissed.
No, this activity, unscrupulous activity of procuring documents in India, showing to be as an Indian citizen because I've annexed the document of
So
her
what is the
passport.
effect if somebody's? Are you divorced with her? No.
No, no, no.
Then she's your wife.
But I'm
By
thinking-
virtue of that, she's
no,
applying.
she
for-
cannot because she has to stay here for 7 years.
She has
I
not
see.
stayed here. per se.
No. She has to be the citizen. She has to stay with 7 years. Section 5C of the Act, Citizenship Act.
So why do you wait for so long to complain?
No, there are other disputes also. I'm candidly admitting. So we are thinking of divorcing my wife, but this activities like procuring a voter ID card, procuring Aadhaar card, making a opening an account in the National Bank,
Locus standi.
PAN number.
Yeah, as a citizen of India, go and file.
As a citizen of India, lordship, I have complained to the FRO. At least this is
That
what
is too general.
they have to have the duty, bonded duty under the rules to monitor and to see any foreigner staying here after the expiry of the visa period.
She could not have become a citizen of India.
She cannot.
Yes, what do you say?
Well, this is what if it is he is staying.
Use the microphone.
But
Yes.
if he says staying here, my lord, then one of the duty cast upon the office by local administration officer in charge who shall make an investigation. So, my lord,
So I'll direct you to make an investigation on this.
They have been also approached. The
But
local.
this is very malafide.
well, that
Very malafide.
actually passport authority has no role to play.
We have also approached the local administration. Also, we informed them.
Well, if
Nothing
it
is happening.
If they procured some voter card or anything that is offense, my lord, then that will be investigated by the officer in charge or any police authority.
Lordship, the Foreigners Act, there is an offense. Then the Citizenship Act, Section 17. These are the offences which have been taken care of. There has to be some investigation. Something has to be done. One after another, we are
It will
lodging complaints.
State is the competent authority to say. such.
State, we have complained.
Which authority should investigate? Tell me.
Lordship, this is Bidhannagar police station.
The inspector in charge, is one number 5, my lord.
Respond number 5.
Very well. The petitioner married a Bangladeshi national, allegedly married a Bangladeshi national, that is the private respondent number 6. First up thereafter, comma, it is candidly admitted that the petitioner's relationship with the respondent number 6 deteriorated. First up next para, although the marriage is still subsisting on paper, comma, the petitioner contends that the respondent number 6 has been applying for Aadhaar card and other proofs of her citizenship of India, comma, whereas she has not yet resided for the mandatory period required for getting such a citizenship. Full stop. The present writ petition has been filed by the petitioner challenging the inaction of the authorities on such illegal acts being committed by the respondent number 6. Full stop. Next para. Heard learned counsel for the parties. Full stop. Learned counsel for the Union of India is justified in submitting that the Union of India has no direct role to play in it. Full stop. However, comma, in the event it is discovered that the respondent number 6 is applying illegally or unlawfully for documents pertaining to citizenship of India, comma, it is for the investigating agencies concerned to take appropriate steps. Full stop. Next para. Although, comma, otherwise, comma, the writ petition has an undertone of malafide on the part of the petitioner, comma, since the petitioner has only approached the court and grown wiser after his relationship with the respondent number 6 became strained, comma, it cannot be denied that the petitioner has a right, comma, as a citizen of India, comma, to invoke the jurisdiction of Article 226 of the Constitution of India to point out some alleged illegal act being permitted by the respondent authorities. Full stop. Next para. Hence, comma, the purpose of the writ petition would suffice if the respondent authorities are directed to look into the matter. Full stop. Accordingly, WPA 2437 of 2023 is disposed of by directing respondent number 5, comma, the inspector in charge, comma, Bidhannagar North Police Station, comma, to look into the complaints lodged by the petitioner, comma, over and above, treating the present writ petition also as a complaint, comma, to inquire and investigate into the issue as to whether the respondent number 6, comma, respondent 6 is a Bangladeshi national and, comma, being so, comma, is trying to get documents regarding her purported citizenship of India, comma, despite not being entitled to do so. Full stop. To enable the respondent number 5 to make a comprehensive inquiry, comma, the petitioner shall make himself available, comma, if so required by the respondent number 5 for the purpose of such inquiry. Full stop. The petitioner shall also serve a copy of the writ petition afresh on respondent number 5, comma, along with a server copy of this order, comma, to ensure compliance by respondent number 5 of the directions given herein. Full stop. The parties shall act on such server copy without insisting upon production of a prior certified copy, nor less to cause certificate.
Grateful.
Thank you.
Item number 8.
May it please your lordship.
I beg to appear for the respondent.
Well, in this matter, my lord, I am for the added respondent, Food Corporation of India.
Lord, Food Corporation of India was added, Lord, in terms of order dated 20th March 2023. Lord, before I take your lordships, Lord, to the papers, my lord may have a look at the order dated 20th March. Lord, the stand of the Lord, the West Bengal Warehousing Corporation, Lord, would be clear from that order. Lord, I'm placing that order, Lord. The petitioner's claim relates to payment of dues with reference to the security deposit and certain invoices for supervision charges for a project in Kharagpur where the petitioner was engaged as a contractor. The petitioner's letter to the Central Warehousing Corporation for who the petitioner was engaged is the 2nd September 2022 and tabulates the claim. Learned counsel appearing for the Central Warehousing Corporation claims that Clause 16C of the terms and conditions governing the contract, which provides that the payment shall be made by the corporation after realizing the amount from the concerned depositor, which in this case is the Food Corporation of India. Council submits that FCI has not released any payment to the corporation, and hence the corporation is not in a position to make any payment to the petitioner. So, my lord, the principal ground of defense was that since I did not get it, I cannot pay you. But I have filed an application. My lord will kindly have a look at it. Can 1 of 2023. Lord, now page 14, 16, 17 and 18, it says that FCI has released an amount of around 61,63,000. My lord has kindly got it, not the application. 61,63,000 in favor of warehousing corporation. Lord, now I tell you, Lordship, what is the exact dispute? Not
What
my,
is your dues tentatively?
Lord, page 193, that includes, Lord, that is more than a crore, that includes the security deposit, the bank guarantee. Those are lying. So there's no question of getting that from the FCI. So that will be released automatically. On the billed amount, Lord, my lord, may my lord take side by side page 193 and page 14 for a second, Lord, so that it becomes, Lord, easier for your lordship, Lord. Page 193 of the writ petition, just have a look at it. Lord, the second tabular chart in page 193, second tabular, the first tabular chart relates to item number 9.
Right.
Second is not, kindly have a look at it. Security money 43 lakhs. So that is not to be get from FCI. March, April supervision charges, that is not to be paid by them. 61 lakhs were the bill from 1st of February to 18th of February. Then kindly tally this with page 14 of the supplementary affidavit. They have referred about the similar bill, 1st of February to 15th of February, then 16th of February to 18th of February. Total, Lord, an amount of 61,63,000 has been paid. So this should be released immediately.
And Mr. Chakraborty, please show me your 16, that clause, which was referred
Yes,
to by
yes.
Justice Bhattacharya.
Yes, yes. 16C. Just a second, Lord.
Yes, warehousing referred to that also.
Yes, yes, they referred to it, 16C. Just
Right.
a second.
Page
Yes,
82.
page 82. The bold portion.
What was the nature of your job?
Lord, I was Lord engaged as a contractor, handling contractor in the food corporation, Lord, the warehousing corporation's warehouses. My Lord, may have a look at page 45, the scope, 34, the scope and nature of job. I have annexed the NIT. Page 45 describes the job, Lord. Lord, my father was actually engaged. He died, Lord, on 18th of February. After his death, Lord, they terminated the contract since he died, because the clause says that it cannot be assigned or given to a legal heir. So they are right on that. I did not challenge that. Then in the termination letter, they said that if the legal heir wants money, they will have to get, Lord, a succession certificate.
But as per 16C, Mr. Chakraborty, the entire payment shall be made after realization. There is no breakup regarding this due, that
Lord,
due.
the entire payment, I here, in my humble understanding, Lord, means the bills, not the security deposit. I will show you, Lordship, under what situation they can hold the security deposit.
Right.
I will show that. Lord, your Lordship has seen page 45. Now kindly take
Yes.
note page 58 for a moment. First take page 36, the amount of security deposit is mentioned there, 43,28,000. Then kindly come to page 58 and 59. Page
Yes.
58, the clauses of security deposit starts, 59, Roman 7 and Roman 8. The security deposit shall be refunded to the contractor only after due and satisfactory performance of the services and on completion of all obligations by the contractor under the terms and of the contract and on submission of a no demand certificate, subject to such deduction from the security as may be necessary for making up the corporation's claim against the contractor in the event of termination of the contract envisaged in clause 10. The regional manager shall have the right to forfeit the entire or part of the amount of security deposit by the contractor or appropriate security.
Next page, clause 7 is the important thing that has been completed.
Yes,
The
clause 7, page 59.
Shall be refunded on the contractor.
Yes, if the termination is not under clause 10, they can hold it. Kindly have a look at the termination clause, page 78. What clause 10
There was a
says?
termination here.
Because of the death.
Oh, yes.
Because of the death. Page 78, clause 10 empowers them to hold on to the security deposit if there is a summary termination on the ground of breach of contract. Now I'll show you the termination was on the ground of death of my father. Kindly have a look at clause 10. So they are entitled to hold on to security deposit only if there is a termination on the ground of breach of contract. Now kindly have a look at the termination of contract, page 161. Lord, initially their defense was that I will also show that initial defense thereafter it changed when the matter was taken up. Initial defense was, they wrote a letter to us. I'll show that, my lord. It's my duty to show your lordship. Kindly come to the page 161, the termination letter first.
Yes.
The handling and transportation contract of food grain Central Warehousing Corporation, Kharagpur, was awarded to Mr. Swanso for a period for 2 years from 19th February 2020, by the letter to Swanso, extension of 3 months or till finalization, awarded to you with effect from 19th February 2022. White letter mentioned with reference to other. This office has been intimated by warehouse manager CW Kharagpur via email dated 18th February that the sole proprietor of the said firm, Mr. Swanso, has expired on 18th February. As per H&T contract, clause 5, clause 5 is at page 69. I have marked it. My lord, may I have a look at it? In case of individual, they have quoted, in case of individual or sole proprietor, the contract comes to an end with the death of the contractor, individual, or the proprietor or sole proprietor firm, and the contract should not be awarded to his legal heirs. Hence, the handling and transporter contractor, food grains CW Kharagpur, white letter dated Swanso, any person claiming to be the legal heir, deceased contractor, individual, or the sole proprietor firm seeking desirous of their movable assets cash pending amount is required to get succession certificate from the competent court and produce the same. Lord, in compliance with this, I obtained a succession certificate. Lord, I will not trouble your lordships. That's the order of the district judge. It starts at page 181, ends at page 192. There's a succession certificate. Now, I made a representation that you asked me to do that. I have produced. Page 198 is the impugn letter. Kindly have a look at it. Page 190 was the stand when I filed the writ petition. Then before Justice Bhattacharya, they said I did not get, so I could not pay. It is a matter of fact that Mr. Swanso was the handling and transport contractor at CW Kharagpur for the period 19th February 2020 to 18th February 2022. And CW Sarul, Surul is the next matter. Surul is the next matter. There was another warehouse, so we filed 2 writ petitions. Further, you are also aware that shortage of stocks has been reported at CW Kharagpur during the period, and subsequently police and vigilance investigation is under process. In reference to the above, as the subject matter has been taken up with the concerned authority and the outcome is yet to be known, therefore payment will be released on receipt of outcome. Lord, I have annexed the FIR. In the FIR, there is not even a single line allegation against me, against my deceased father. Kindly have a look at the FIR. It starts at page 200. The formal complaint is at page 202. But kindly allow me to place the entire thing, because if I miss something, so that they could point out, because this is the, perhaps they refer to this because there is no other FIR. Because perhaps they refer to this, the amount is admitted. There is no dispute about the amount. There is no dispute about my entitlement. Initially, they said you come up with succession. I went there. They said there may be some inquiry. I am showing that in the inquiry, I am nowhere involved. Now, kindly have a look at it. First paragraph, that amongst others, the Food Corporation of India, one of the depositors, my lord may skip over this, kindly take 203. That sometime in March 2022, Lord, contract ended in 18th February 2022, my father died. So after the death of my father died on 18th of February 2022, the contract was till 19th of February 2022. And this FIR is lodged on 1st of April 2022. No, 21st of April 2022. So the allegation starts that sometimes in March 2022, this office received information that about 20,000 bags of wheat and 500 bags of rice were missing from the said stock, and as such, on the report received by the office, from the Office of Food Corporation of India, District Office, Midnapur, an internal committee was formed comprising of the concerned officials of the office, and an internal departmental investigation was duly carried out. From the peripheral physical inspection, it was found that there was gross lapses and latches of duty on the part of the official posted at the said central warehouse in Kharagpur, which has been duly recorded in the investigation report annexed and enclosed therewith. That it was also found that proper procedure for maintaining the necessary records were not duly followed, and as such, due to the patent dereliction on the part of the officials posted in the central warehousing at Kharagpur, the aforesaid loss has incurred. The details of dereliction.
Mr. Chakraborty, it was their personnel, the
Yes.
personnel in collusion with probably a food corporation.
They named them, not only in collusion, they named in para 5, in para
collusion
6.
is also hinted in para 6.
Yes, para 6, collusion And nowhere it is stated the contractor was in any way remotely involved. So, my lord, I say, my lord, today before your lordship, my lord, since the claim is admitted, since the claim is not disputed, none of the letters they said that, no, this is not the amount, X is not the amount, Y is the amount. You are not entitled. So, my lord, in view of my lord, ECGC, my lord, ABL versus ECGC and my lord, Surya Construction, I can approach your lordship's court for the admitted payment. And secondly, the stand taken by them before my lord Justice Bhattacharya, my lord, was that they did not get it from FCI. Now they have got the money. And with regard to the security deposit, FCI has got nothing to do. The work is over. There is no complaint that I did not perform the work. My father did not do it. Now, my lord, this amount of 42 lakhs, which is the security deposit, not which this should be released. And the bill that they have received, they have no right to hold on to it. This is not my submissions as
Let
of
me
now.
hear the FCI, then I'll come to you. You are for warehousing. I'll hear the FCI. Let them speak against you or in your favor, then I'll come to you. Yes.
Well, I am neither in favor of him, CWC or the petitioner, my lord.
Have you paid or not paid?
Yes, my lord. And that is the question, my lord. Today.
That is a question to you also.
Yes, because today only, my lord, I have received the my lord, CAN application regarding the so far the payment made
You
by
have said that at the inception when the matter was being moved. Now I won't give you time.
my lord, CAN application I have received only today.
You have
my
not,
lord.
if FCI has not paid, you will pay from your pocket.
My lord. But I do not have that much of money for my life savings, my lord. My role is very limited.
What is
my
your life savings? Anyway, let us continue. Yes.
My lord,
So they have made an allegation. What about
yes,
this?
my role is very limited. I am the principal employer. I have hundreds of godowns all over India. Where, my lord, I do not have any godown in any particular place, or I have the excess stock, my lord. Then I hire the godown of CWC, Central Warehousing Corporation, and I have an independent contract with the CWC as regards the role and liability of the CWC as well as myself, my lord. So as far as petition is concerned, I do not have any PBT of contract. That is admitted fact. Now the thing is this: as far as the release of payment is concerned, the CWC gets the bill from the contractor, and after the verifying the authenticity or the entitlement, they forward the bill to me. Thereafter, I verify the bill, and accordingly, I find out whether there is certain deduction or recoveries to be made or not from the CWC. There may be certain latches, my lord, on the part of the CWC. So accordingly, I, my lord, made the recovery or the deduction, and thereafter
They have placed a bill. What is your
Yes,
stand?
yes.
CWC has not placed that bill before you.
From the writ petition, Mala, we are not clear. From it is a running account bill. From time to time, they send the bill. As far as the claim of the writ petition is concerned, readily, Mala, I cannot say how much money we have released on that particular account. If the CWC is directed to furnish the bills, my lord, on account of the writ petition, certainly, my lord, I can file a report on affidavit. Yes, this much of amount has been released. So that will help the writ petitioner as well, my lord. What I understand, because I cannot question his entitlement. Certainly not.
Wait, let me hear this.
But what will solve the problem is there are my learned friend appearing for the petitioner. They have annexed 2 sanction orders.
Please take the microphone, sir. Yes.
Well, in support of their claims, they have filed 2 sanction orders. They have filed an application annexing 2 sanction orders. If these 2 sanction orders come from the FCI, my lord, that will be clear as to which bills this payment pertains to. My lord, there are actually 2 issues. Number one is one relating to the warehouse at Kharagpur, the other is Sarul. As far as Sarul is concerned, deducting our charges, we are ready and willing to disburse the amount.
That's the next matter.
No, the security deposit was total of 43 lakh and odd.
Yes.
Out of that, there were several components in that. Which was the page, Mr. Chakraborty? That
193. Security is 43 lakhs 28,000.
Yes, yes. Mr. Chaudhary, if you please come to page 193 once.
193.
Read it.
Now, these were the components. Please come to Kharagpur or Sarul, any of them.
My lord.
Because he has placed Kharagpur, I'm just placing that. I'm just asking you to look into that. Now, security money for CWC in Impura, that is an independent component. That does not, why should that depend on the bill paid by them?
I tell you,
Bill
lordship,
component is only this.
my lord, as far as Kharagpur is concerned, my lord, my learned friend has already showed to your lordship there has been theft. Investigation is pending. Now, I tell you, lordship, whatever is in our knowledge that we had put in the FIR, but it has to be investigated, my lord. If the police now finds, the difficulty is, had the contractor been alive, we would have recourse to recover the amount. The contractor is dead. He's the heir of the contractor. Now, tomorrow, my lord, if there are any recoveries to be made, we cannot recover it from him.
For that, you cannot withhold payment.
And that was the
It's not
only
a law.
reason why in Kharagpur the amount has been withheld. As far as Sarul is concerned, my lord, we are willing to disburse the amount, deducting our charges.
Your charges means?
My lord, there is a component which is marketing facilitation charge. That has to be deducted. That is 8% on the total receivables, which is 1.
That is as per the contract also.
Yes, my lord. That is as per contract. So after deducting that, we are willing to release.
So then I'll dispose of both the writ petitions, but you win, he wins. Because for that you cannot withhold charge. I'll make it an order of the court office.
My lord, then.
And regarding your bill from FCI, you can wait indefinitely whenever that is paid.
But my lord, the difficulty is unless and until we recover from them. But
No, Mr. Chaudhary, you also you should also know, because the application annexes certain documents.
Yes, my lord.
Those documents show payment to you.
Yes, my
This
lord.
is
It does.
RTI reply.
It does.
Oh, that is FCI reply.
That
RTI
does.
reply.
That is the reason why, lord, why I'm saying that Sarul, we are willing to disburse the amount. Let the sanction order be brought on record, madam. By
Sarul is the
FCI.
next writ petition.
Yes.
The next petition.
What is the number of the দুটোই board একটু দেখিয়ে দিতে হবে।
It is 3966.
এই 9 এর
3966.
ফাইলটা
Item number 9.
ওটা ফাইলটাও দিন।
This is 396.
3960 is Kharagpur.
Yes.
No, 3966 is Sarul.
63 is Kharagpur, which is your lordship is now hearing. 66 is Saru.
Then let me dispose of 66 first immediately.
Very well.
And I'll ask them to clarify on this within a week. Do that, please.
2 weeks, my lord, only 2 weeks.
We'll do it within 2 days. I'll start with 2 days then. Come back within a week. It requires one telephone by you and one email by them. And in the meantime, probably half an hour will be taken by the officer who is sitting tight over the matter.
Officer dealing with me and the case part.
Your officer who has to ascertain.
That is one in the district office, my lord. So there is some coordinations to be made between the regional office. with
How
the
do you coordinate? Generally, the special messenger goes from your office.
No, my lord, I call the regional office. They, my lord.
No, do it within a week.
10 days, my lord.
Both the writ petitions are taken up for hearing, since they relate to different components of a similar claim for work done by the petitioner for the Central Warehousing Corporation. Full stop, next para. With regard to WPA 3966/2023, learned counsel for the CWC, in his usual fairness and on instruction, submits that the said respondent is agreeable to disburse the entire amount of dues in favor of the petitioner, after deducting the charges which are deductible by way of expenses of the CWC as per agreement between the parties. Full stop. Accordingly, WPA 3966 of 2023 is disposed of by recording the above observations, directing the respondent number 4, that is 4 or 3, whom should I direct? Chairman or regional manager?
Regional manager.
3.
By directing the respondent number 4, that is the regional manager of the Central Warehousing Corporation, to ensure that the entire claim of the petitioner for work done by the petitioner for the CWC, for work done by the concern belonging to the petitioner's deceased father, as expeditiously as possible, preferably within 3 weeks from date. Full stop, within 3 weeks.
3 weeks. My lord, but this will not cover the security deposit, because security deposit, there is a compliance which needs to be made. That is, there has to be a no due certificate from the warehouse manager. That has not been submitted. And there is an affidavit in a pro forma. That has also not been submitted.
I will comply with the formalities. In the
Subject to the petitioner complying with due formalities for refund of the security deposit, which shall be done by the petitioner within a week from date.
My lord.
Full stop, next para. Insofar as WPA 3963 of 2023 is concerned, the petitioner has raised a question as to whether the CWC can withhold the due amount to the petitioner's deceased father, by way of security deposit, on the pretext that the Food Corporation of India, that is the added respondent, did not pay the bills of the CWC. Full stop. Learned counsel for the petitioner places reliance on the annexures to the interlocutory application filed in connection with the writ petition to argue that the FCI has already disbursed the concerned bills in favor of the CWC. Full-stop. With regard to the other components of the amount to be disbursed is concerned, comma, being the security money for CWC Nimpura, comma, KGP, comma, and the payments for February 2020, comma, March 2020, comma, April 2020, comma, August 2021, and January 2022, comma, there is no impediment on the part of the CWC to release such amounts. First up, it is argued that the amount pertaining to the bill payable by the FCI, comma, in any event, comma, relates to the bill period from February 1, 2022 to February 18, 2022, comma, which amounts to rupees 61, 55, 723, comma, as indicated in the communication of the petitioner dated September 2, 2022, annexed at page 193 of the writ petition. For sub next para, learned counsel for the petitioner further submits that the other pretext taken by the CWC for non-payment, comma, being the pendency of a criminal investigation regarding certain goods of the CWC having been stolen, comma, neither the petitioner nor the petitioner's deceased father or the concern of the petitioner's father, comma, which was the contractor, comma, are named as accused persons in the complaint or the FIR. Hence, comma, the said ground also pales PLES into insignificance. Next para, learned counsel appearing for the CWC submits that although the petitioner or the petitioner's father were not specifically named therein, comma, the outcome of the investigation will only show as to whether the petitioner or his father were involved in any manner with the instance of theft. If so, comma, a premature disbursal of the entire dues might ultimately lead to the investigation being frustrated. Next para, that apart, comma, it is submitted that although certain documents have been annexed to the interlocutory application, comma, it is for the FCI to clarify as to whether such payments were made in the context of the present bills. Next para, insofar as the first defense of the CWC is concerned, comma, regarding the ongoing investigation on an allegation of theft, comma, the same cannot be a valid ground for withholding payment to the petitioner. Since the payment is for work already done by the petitioner's deceased father, comma, to whose estate the petitioner is entitled as an heir, comma, and there being no allegation whatsoever, even in the complaint of the CWC regarding the involvement of the petitioner's father or the petitioner in such instance of theft, and since certain named persons already find place in the documents pertaining to such criminal investigation, comma, who are personnel of the CWC itself, comma, the CWC cannot be permitted to withhold legitimate dues of the petitioner on such score. However, comma, insofar as the clarification which is due to come from the FCI is concerned, comma, the CWC is justified in making such submission. Accordingly, let the matter stand over till August 9, 2023. I'm giving you 2 weeks. August 9, 2023, when learned counsel for the FCI shall file specific written instructions on behalf of his client, the added respondent, indicating as to whether the amounts paid, comma, as shown in the interlocutory application filed by the petitioner, comma, pertain to the relevant bills of the CWC. Next para, the matter shall next be listed as directed above on August 9, 2023 fairly at the top of the list for passing orders.
Lord, one little indulgence, Lord. With regard to 3966, which your Lordship Lord has passed order and disposed of perhaps the matter. But there, would your Lordship be kind enough to record that there lies no dispute and they are agreeable to pay only on completion of the formalities. So that.
That is what I have directed. They are agreeable to pay, but subject to compliance of formality. I put that in my order. That subject to compliance of. Please, Mr.
Yes,
Chaudhary,
they will
ensure
intimate
that
the formal.
let them be intimidated as to what
Yes,
are the exact
that's what I
formalities,
was saying.
Very good.
That's what
so
I
that
was
this can be smoothly carried out by
saying.
hopefully
will-
by 9th.
Lord,
Yes, my lord.
I'm requested to, Lord, ask this by Mr. Das, Lord, kindly, Lord, direct respondent number 3 also.
Two?
3 and 4 to do this exercise, 3 and 4 both, because
My lord, three
then it
not
will be
the
surely
relevant authority.
compliant. I leave it to you, Lord. I'll leave it to you.
I'll come back for the next matter after
Ah,
10
great.
Hmm.
Item number 10.
My lord, I am for the petitioners.
Yes.
I am for the respondents. This is the evidence satisfied.
All have been served? All have. Yes, for this matter, please.
Hello, petitioner invested some amount, 15 lakhs rupees in the post office through their authorized agent. And when the matured amount was matured, they told that this passbook is fake and they are not giving the money. This is the case, my lord. Petitioner made representation before the authorities. Page 54 and 58, my lord.
But this requires a criminal investigation. What can the writ court do here?
My lord, kindly see the page 52 and 53 for settlement. After giving this note letter, my lord, 52 and 53, last para, my lord.
Yes.
Therefore, you are requested kindly look into the matter personally and take immediate necessary action towards settlement of the case.
So you say this should be acted upon.
My lord. My lord, this fraud is committed in the year 2020. My lord, thereafter it was informed to the department and department immediately lodged an FIR, my lord. In the
Your
year
own
2000
assistant director of postal services
uh,
asks you to settle the matter. So why shouldn't you do that?
My lord, I don't know whether he can at all settle the matter in this way. It is a criminal offense, my lord.
No, the
Not-
criminal allegations remain. Those have to be resolved in due process of law.
Yes, in the year 2002, my lord, the criminal offense is lodged against that person, and also that person not is party added here. The person is the Minoti Das. He is also not made party here, my lord.
What was the nature of the fraud? I mean, it was entirely fake.
Yes.
No
But
amount
he
was
also-
deposited, but amounts were deposited with you.
No, amount was not deposited. A fraud document is created and handed over to him, according to their own FIR, my lord. Their own FIR. Post office.
Show me that FIR.
At page 65, my lord. At page 67, the it is stated against Srimati Minoti Das, Patho Das, etc. Also, only using genuine all forged documents which were known to be forged, which were totally misappropriation.
This is page 67.
67 onwards. 68, para 2.
Post
Para
office
4.
is libel. This is
It's a
my
criminal. It's a criminal offense. He also made an application for
No, I'll come back to you. Yes. Yes.
also made application before the Consumer Forum in the year 2006. That has been dismissed. Thereafter, appeal 2017 that is also dismissed. Then, my lord, the choosing of forum, my lord, before lordship, my lord.
No, this Mithali Das was your authorized agent.
At that point of time, in the year 2003, he was removed from that authorized. Page 35.
If she was an authorized agent,
At
then you
that point
cannot disown the liability for that.
Yes, but it is a criminal offense, my lord. I understand, my lord. Because
Then why should you settle? You can settle.
my lord, careful. And going.
I'll direct you to act on this and try to settle the matter. This is hard-earned money of middle class people.
Yes.
Why should they suffer and move the writ court also? I mean,
Also,
your agent swindled them. At that point of time, she was your agent.
lordship, immediately after giving information, if I lost and also his agency was cancelled.
They are ultimately at the receiving end. The writ petition has been preferred, alleging that the petitioners were swindled of their hard-earned money by an authorized agent of the postal authorities, full stop, on giving the impression that the amounts paid by the petitioners were being invested in a deposit with the postal authorities, comma, the said money was misappropriated by the named agent. Full stop. Next para. Subsequently, the petitioners, it is alleged, have been running from pillar to post and have lodged complaints with all forums possible. However, despite the Assistant Director of Postal Services within bracket 2, Kolkata region, West Bengal circle, having asked the senior superintendent of post offices, East Kolkata division, that is respondent number 4, no action is being taken by the respondent number 4 to settle the matter. Next para. Learned Counsel also places reliance on certain communications in that regard, annexed at pages 52 and 53 of the writ petition, made by the Assistant Director of Postal Services within bracket 2, Kolkata region, to the respondent number 4. So next para, Learned Counsel appearing for the respondent authorities submits that although the accused person was an agent of the post office at the relevant point of time, subsequently she was sacked. Next para, that apart, the matter pertains to criminal investigation and it is doubtful whether the same can be settled mutually between the parties. Next para, upon hearing Learned Counsel, what is evident is that, admittedly, the accused person who misappropriated the money of the petitioners was an agent of the post office at the relevant point of time, hence, the postal authorities cannot disown liability entirely on such score, on the mere ground of pendency of a criminal proceeding. Next para, although the postal authorities have alleged that the relevant documents were forged, the same will only be resolved after the conclusion of the criminal investigation / trial. However, there is no reason why, in the meantime, the communications made by the Assistant Director of Postal Services should not be given effect to by making efforts to resolve the financial issue between the petitioners and the post office by way of mutual settlement of the case.
My lord, kindly also record that whether this criminal offense can be settled, my lord, because
next para,
there is a question.
although the respondents are justified in arguing that allegations of a criminal nature are not always compoundable, insofar as the financial claim of the petitioners are concerned, it is always open to the respondent authorities, particularly keeping in view the financial condition of the petitioners, to make endeavor to resolve the said issue mutually. Next para, hence WPA 6471 of 2023 is disposed of by directing respondent number 4 to give effect to the communications made by the Assistant Director of Postal Services, Kolkata region, as annexed at pages 52 and 53 of the present writ petition, by attempting a mutual settlement of the financial claims of the petitioners on the maturity of their purported accounts. Next para, it is, however, made clear that such mutually settled amount, if a settlement is arrived at, shall be independent and irrespective of the criminal consequences of the criminal trial / investigation going on the basis of the allegations of the petitioners. Next para, it is expected that respondent number 4 shall give an opportunity of hearing to the petitioners and, upon hearing all concerned, resolve the issue as expeditiously as possible, preferably within 1 month from the date preferably within 1 month from date.
Another one thing, my lord, original document should not be annexed, my lord. Original, my lord,
You will give a hearing if necessary. Ask for
original
the-
document is not with them. How can, my lord, that?
No,
be
that's the
accepted?
question.
They are not sacked, but they are also.
See, you don't have a right for issuance of a writ of mandamus for asking someone to settle a matter. Because their internal communication is there, taking advantage of that, the court is directing them to abide by that. But we cannot compel anybody by issuing a rule of mandamus to resolve a dispute between the parties. No.
My lord,
Whereas the original documents are not available.
My lord,
What misappropriation?
misappropriation of investors' money by the agents.
In the hearing, place it before this respondent number 4, which will furnish a fresh cause of action. That will be premature to hold now because at present we cannot go into that. That exercise has not yet been completed. Let it be completed. And the next time when you come up before this court, I hope you won't have to. If you have to come up, please cite this first before making the other arguments. And not after the matter is over.
Item number 11.
11.
Yeah.
Thank you. Yes.
As seeking an indulgence, but
Yes, Mr.
Mukherjee, Prasun Mukherjee, who was not assisting us,
Yes, yes.
but he's lost his mother,
Oh,
and his father is also hospitalized. I was just seeking time till the 8th of August. If that
Definitely.
is
Definitely, absolutely.
Retain its position, nothing more.
What else remains? That's more than disposal. No, this is appearing under what heading?
Lord, it is appearing as I
I'll-
think for
Because
for
on
hearing.
mentioning this has been upgraded.
It will remain as an upgrade, but on the prayer of learned counsel for the DVC. Now, on the prayer made for adjournment on the ground of inconvenience of learned the learned advocate, the learned junior counsel appearing for the DVC, let the matter stand adjourned till August 8, 2023, when it will be listed under the same heading.
Much obliged.
Thank you. সাবধান পড়ে যাবেন এটা।
Item number 12.
Yes, please.
Lord,
You are for different sides or appearing together? You and Mr. Kush? Nothing in your matters.
Lord, I'm so scared with Mr.
Nothing in your
Ghosh
matter.
assisting me.
Cannot be. This combination is very, very lethal.
You have killed me, my lord.
Must be something wrong in your matter. Yes, what is your worst point?
I'll just file the affidavit of service. My lord, I'll be. My lord, I've
Good
served
service
the-
has been effected on all.
Yes, my lord. Only thing is, I've served. My lord, the bank has received. My major grievance is against the bank. My lord, the police authorities, I'm not sure whether they've received or not. I really slightly doubtful on that because there is a speed post which is gone.
What about respondent of 5? Who are they? I mean, are they also involved?
5, my
Yes,
lord, is the person against whom some criminal proceeding has been instituted in Hyderabad.
On which pretext the bank is doing something?
Yes.
Very well. Let's hear you. Yes.
My lord, rather strange facts. I have an account in Calcutta with the concerned state bank. My account is suddenly shown to be on hold. When I inquire from the bank, why have you made it on hold? There is a communication from the bank saying some police station in Hyderabad, some police officer, I'm sorry, my lord, it's difficult to pronounce, my lord, I'll show your lordship the document straight away, has said that under section 91, this account is to be put on hold.
Section 91 of
Oh,
what?
I'm sorry. Code of Criminal Procedure.
Oh, what?
I'm sorry, my lord. Now, lordship is aware under 91 that cannot be done. I'll
No,
come to
not
that.
aware.
Aware. I know you. I know that. My lord, be that as it may, when I write repeatedly, I also write to the RBI saying towards the ombudsman, says no, this can't be done before the ombudsman because the police has initiated. Now, my lord, when I make inquiries and I find there is a criminal complaint against some of the persons who may or may have been connected with the respondent number 5, criminal complaint of trying to forcibly dispossess somebody in Hyderabad. There is no mention of me or my bank account.
You've annexed that.
Yes, all annexed, my lord. Now, my lord, they put my account on hold. What is the connection? There's obviously a connection. My lord, the connection is this. The respondent number 5 was a tenant in respect of a property which I own. During the COVID period, they stopped paying. There's a registered lease deed to that effect. Once they stopped paying, my lord, I had to terminate. I initiated arbitral reference. They refused to appear. There's an award. I've taken possession. There's an award for about 18 lakhs minus the security deposit of 4 lakhs 80,000. So about 14 lakhs and odd, about 15 lakhs, my lord, is due and payable. This is the only connection. And for that, my lord, my account under section 91 has been put on hold.
When payable by him to you.
Yes, my lord. That's the award. I have annexed the
So
award.
how does it involve you in?
I am absolutely, my lord, in the dark. I could not understand why. Nothing, my lord. And the, my lord, the investigation, the FIR doesn't, my lord, relate to me at all. My name is not there. It has nothing to do with my bank account.
So in this matter, the writ petition can be disposed of, but
Correct,
in their
correct.
absence, I don't want to do that because they may have some
I fully appreciate.
only that because affidavit direction is unnecessary.
No, absolutely unnecessary.
And
Absolutely.
if I pass an interim order, Mr. Mittu, that will be tantamount.
Your lordship is absolutely correct, my lord.
It's a very short matter.
It's a very short matter.
Please give a notice to the further notice to the bank. No need of serving a copy. Just a notice to the bank at least.
My lord, notice has been
given already.
And again on 25th of July, this, my lord, lordship will not find in the
Second notice has been given.
Yes. After we mentioned the matter, we had put them on notice again, my lord.
Please show me the complaint, Mr. Mittu.
Yes, my lord. No, complaint made by me or my lord, the complaint.
No, Hyderabad.
Hyderabad.
Yes.
Kindly, my lord, come to page. Yes, kindly, my lord.
You can place from page 185 also.
Yes, but the complaint, lordship, will find that.
No, please start. Let us start from page 185.
Lordship, I'll do that.
Since both of you are here, let us start from page 185.
Yes, my lord. No, I have given translate.
Tell me the language.
I don't know. It's just beyond me, my lord. But fortunately, my lord.
197.
Kindly take, my lord, 197, my lord.
197.
I have given, my lord, the translated copies. In fact, my lord, there was a document where I had marked it. না যেখানে বললো যে কেন 10,000 টাকা নিয়েছে।
Was there any communication by the bank to you?
Nothing. Yes,
No,
yes.
show me that.
Yes. Kindly, my lord, take page 23.
23.
That refers to the
And section 91, my lord, is, I don't know.
Now, have they referred to section? They
Yes,
have
yes,
not
yes.
referred to
Kindly
section.
see, my lord, at page 23.
Yes.
If your lordship sees the before in the first paragraph, my lord, the third last line, order under
like
section
this.
91 CRPC.
Have they given you a copy of the complaint? Oh, that complaint was obtained by from the bank.
No, not from the bank.
That's a very.
I have obtained it separately. Also, my lord, at 25. And 26, my lord, is what perhaps the bank has received from the police authorities.
What could be the worst point against you? I mean, show me that because they are not here.
I was trying to think, if I am not involved, not named, can, my lord, the worst, I'll tell your lordship what the worst possible thing is, that a connection because of the tenancy.
Yes.
That's the worst possible thing.
You obtain an eviction decree, eviction award.
My lord, what happened was during the pendency, before, my lord, the award was passed, an interim application, and I had obtained possession. So the final award records that possession is obtained and therefore not pressed. The balance rent, my lord, is what, my lord, the award has granted.
Aisha Creations was the landlord.
I'm the land. I'm Aisha.
No, Aisha Creation was the landlord,
Yes.
not any. This is a company.
It's a company.
Very well. Yes.
It's a company.
Hmm.
So that, my lord, beyond that, I just couldn't, my lord.
So complaint was lodged by whom? I mean, before the police authorities, by the tenant.
No. My
How
lord,
are you involved here?
I'm not. And my name doesn't appear. My lord, if you see the complaint,
Other matter.
complaint, my lord, is some persons have forcibly taken, they are involved in what is called, my lord, no. Keep my lord again.
So this is all that there is, Mr. Mitra, in this matter.
This is it.
I'll try to find out something against you here. If I find out
Yes, yes.
something, I'll put it as forwarders on some next week someday. Immediately, I'm giving the date. If I have any questions from you, I'll ask you. Otherwise, I'll pass my final orders on this.
My lord, since lordship is keeping on another day, should I put the bank on one more notice?
Do that, Mr. Mitra. Even if I come to some finding,
Yes,
let
yes,
them
my
have
lord.
another notice.
I'll put. My lord, will your lordship indicate the date? Then I'll put.
I'll
the
definitely indicate.
lordship.
Despite several attempts to serve, none appears for the respondents. First up, the affidavit of service and further receipt filed today be kept on record. First up, heard learned counsel for the petitioners extensively. First up, next para, let the matter be listed fairly at the top of the list on August 3, 2023. Another thing to be mentioned for passing orders, full stop, the learned advocate and record for the petitioners is requested to serve a further notice of the next returnable date to the respondent bank. In the meantime,
Well, there's also Reserve Bank who's a party because they are
no, sorry.
so my
Yes.
lord,
On respondent bank na kore,
or
respondent
my lord,
numbers,
respondent number 1, 2, 3, and 4 because that's the
respondent numbers 1 to 4. In the meantime,
grateful, my lord.
এই ফাইলটা পাঠিয়ে দেবেন একটু আমাকে, হ্যাঁ ওইটার সঙ্গে। Thank you.
Just, my lord, saved my day.
No, you have to also explain on the next date why both of you are appearing.
No, I asked him that you please abuse me because if I start the matter, don't get an order, you'll abuse me anyways. You better abuse me in advance. So he said, I'll do it later.
You're sure neither of you drafted anything in that eviction proceeding in Hyderabad?
No, it was in Calcutta.
No, Hyderabad eviction proceeding was in Calcutta. So how does the contempt, the complaint lie in Hyderabad?
No, it's not about the eviction. There's no complaint. As far as I am concerned, there's no complaint against me, my bank account, nothing. Your lordship said, what's the worst that I can think? So I said, that's
Something online you have done. Some fraud or something.
If I tell your lordship,
something fraudulent. Must have duped somebody. Yes.
Item number 13.
Need not. 14 years. Item 14 is not. You are appearing?
Yeah, 13
Yes.
wala I'm for the petition.
Right. State is the main respondent?
Yes. The order impugned is that. That's me bolo.
Yes.
Mala petitioner mala the three mala land selling proceedings was initiated against the mala predecessor in interest of the petitioners. Mala one of that mala my.
That has been settled between you?
No. Mala the one is mala against my father. Mala after the death mala we continued that proceedings. Mala and carried an appeal. Mala that appeal was disposed of in the year 2005.
Proceeding under what act?
Under Land Ceiling and Regulation Act, my lord, in that proceedings, my lord, the land ceiling proceeding was disposed of on the basis of a report filed by the KGU in connection with the my lord, the land ceiling proceedings. What happened, after disposal, now, their, KGO, submitted certain plots, in our allotment, and, they directed to some plots vested, that order was set aside, in the appellate authority. Subsequently, on the basis of subsequent order, we are possessing, some plots of land, but now we applied for report of the the KGO report under RTI Act. That was not submitted, supplied. Then I made appeal, RTI appeal. That was not considered. Then I moved before this honorable court. This honorable court directed, page 62 is the previous order, directed the competent authority to supply the copy. What happened, after this order, communication of this order, they communicated, the record is not traceable. It's my contention is, since
What can be done if the records are not traceable? I mean,
Page 72.
the
Provision for second appeal.
that is not that is not the issue.
45 years old.
This
Last paragraph, your lordship.
what happened, against the land sealing proceedings, an appeal was prepared before the appellate authority. My contention is, the entire record may be lying before the appellate authority. That's the appellate authority is the party, whether the record is lying before them, they can file the report.
they are saying despite sincere and diligent effort,
Is
whatever, the desired report could not be traced out from all available records. Therefore, it may be concluded that the case record pertaining to such and such, more than 45-year-old, has been inadvertently misplaced. So what else can be, what can the court do?
My contention is, there will be a direction upon the appellate authority. Appellate authority is party. An appeal was prepared before the appellate authority order as page 25. The record may be lying, before the appellate authority.
But after Justice Bhattacharya's order, nothing remains in that second appeal. That was virtually decided by Justice Bhattacharya.
His submission is second appeal. I am not on second appeal. My contention, I am seeking the report.
The previous order records,
Yes, ma'am.
Mr. Chaudhary, that since the second appellate authority became defunct in June such and such, prior to that it has been recorded. The petitioner alternatively, you sought an information, alternatively sought authorities to dispose of the second appeal. So second appeal was pending. Since it has not been reconstituted as yet, the WPA was disposed of.
Yes, with
That
the
means the
direction-
second appellate authority's jurisdiction was taken up by this court, decided finally. So they were directed to give information. Up to
Yes.
this, it's all right.
Yes, that's why.
Now they say this.
Now they say this,
They don't have the records. So they have but substantially complied with the order of the
Yes,
court.
but my requirement is not fulfilled. My only contention is, the record may be lying in the appellate authority. Since an appeal was prepared before the appellate authority.
But your lordship, kindly see in 2012 also, in 2012 also, your lordship, kindly see one of the brother that was given. 2012, your lordship, kindly see that. Page 26. One of his brother applied for and the report was. Yes.
The same thing,
Same.
same document.
Same.
I don't know.
Your son will come up and your son will become mature and he will also apply again.
My one partition suit is pending. There the report.
Can a copy of this be handed over and kept on record? This entire thing or the only this copy will do?
No, yes, can be given.
I'll keep this on record, nothing doing.
That is.
Acha, very well. Like a copy piece out.
I'll
take out a
I'll hand
photocopy.
over the fresh copy to your mind.
Give a copy to Mr. Chaudhary also. He'll also.
You got to read it.
But Mr. Chaudhary, no further direction can be given. What can be done? Court cannot monitor the investigation into the report.
My prayer is, the record may be, there may be a direction upon the
There may be several alternatives, but how can we go on that? And what sort of a mandamus are you expecting here?
They are seeking, they are not searching before the appellate authority order. Since an appeal was for paper against the competent.
What is the information sought by you?
The KGU report of the KGU.
How will that help you?
There was a land schedule, which were allowed to retain our predecessor in interest.
You don't have a copy of that?
No, that's why in the partition suit, I can place what are our land schedule. That's why we are
No, I'm sorry. Learned counsel for the petitioner submits that previously the petition had sought an information, comma, which was not given to the petitioner. First up, the matter went up to the second appellate authority. First up, having got no relief there, comma, the petitioner had approached this court under Article 226 of the Constitution of India, comma, giving rise to WPA 1309 of 2023. First up, the said writ petition was disposed of by a coordinate bench with a order dated February 10, 2023, thereby observing that since the second appellate authority became defunct and had not been reconstituted till then, comma, the respondent number 3 therein, that is the subdivisional officer, comma, Uluberia, and competent authority, comma, urban land selling, comma, Howrah, to supply the information sought by the petitioner on March 17, 2022 and April 25, 2022 within a period of 4 weeks from that date. For next para, it is contended that subsequently the concerned respondent therein has taken a plea that the report could not be traced out. Being so aggrieved, comma, the petitioner has preferred the present writ petition. Next para, learned counsel appearing for the respondent authorities submits that the petitioner has a remedy by way of an appeal against the impugned action of the respondent authorities. That apart, comma, it is contended that despite diligent efforts of a search team, comma, the desired report could not be traced out, comma, as intimated to the petitioner. Next para, that apart, comma, the same information had been sought previously by one of the brothers of the petitioner and by a communication dated December 28, 2012, comma, it was intimated by the subdivisional officer, comma, Uluberia, comma, Howrah, and SPIO that there was no inquiry report of case number 327/1976-77 on 2/4/87 by KGO-Roman 1. Next para. Upon hearing learned counsel for the parties, comma, it is evident that a similar information sought previously by the petitioner's brother had been turned down on the same ground that there was no such inquiry report. That apart, comma, the respondent authorities substantially complied with the order of the coordinate bench dated February 10, 2023, comma, inasmuch as the respondent authorities undertook a detailed inquiry and a search for the said report. As indicated in the communication dated March 31, 2023, comma, annexed at page 71 of the writ petition, comma, after sincere and diligent efforts put in by the search team, comma, the desired report could not be traced out from all available records, documents, files in the office of the competent authority, comma, which was intimated to the petitioner. Next para, although it has been argued on behalf of the petitioner that the records might lie before the first appellate authority, comma, the said submission cannot generate a further inquiry, comma, since the statement of the competent authority in its communication to the effect that a diligent effort was made by the search team constituted for such purpose, comma, to find out the document resulted in the report not being traced, comma, there cannot be any further attempts on the part of the competent authority in such regard. Hence, comma, there is no scope of granting any further relief to the petitioner. Accordingly, WPA 16462 of 2023 is disposed of in the light of the above observations, comma, keeping on record the communication dated December 28, 2012, handed over by learned counsel for the respondents.
My lord, this will not prevent the petitioner but to approach the appellate authority, my lord, the copy of.
So nothing in this order, however, shall prevent the petitioner from approaching the first appellate authority and or the second appellate authority for furnishing of the seeking a further search to trace out the document in question before the said authorities and or to apply in due course of law before a competent civil court, if any civil suit is filed in which the documents in question acquire relevance.
Yes,
Either partition or whatever.
yes, yes. Yes.
दीजिए सर अपना नामটা দিয়ে যান item number 14
But I beg to appear on behalf of the petition.
Yes.
Affidavit of service. But here, the petitioner has applied for a connection for a commercial use. Lord, kindly takes.
All have been served, Mr. Mukherjee.
Yes. Yes. My Lavin friend is appearing that he is the main answering respondent.
Yes.
Lord, kindly takes up not my purchase deed. That is not that will start not from page 11 of my lord's brief. Kind.
Time lordship, only small submission can I make before
Yes, Mr.
being
That
exhausted?
can otherwise resolve the issue.
No, that is there. It's similar to whose multi-story building, investigation is going on. And no connection has been given to any of the, and it is yet to be completed. But lordship, I have said, make thorough inquiry whether this could be accommodated or not. They say the multi-story.
He's a particular flat owner.
No, not flat owner
Building.
even.
Now, this is
Not
the condition of the
flat
building
owner even.
where your lordship will found me not in the ground floor. I have purchased one commercial unit.
So they are saying that it should be a common service and everybody should get connection. So if it is given at this stage, that will be difficult. I have said even then you make a thorough inquiry, give a report.
Should I keep it, Mr. Naik?
Lordship,
Tell me.
3-4 days, 1 week, lordship.
Learned counsel for the WBSE DCL.
And Lord, I will request also to give me a photocopy of that. That's a copy if my learned friend provide.
Copy of the photo, not photo.
I shall.
Keep it with you, Mr. Mukherjee. I'm not recording
By the
anything.
order impugn, they have rejected my application. They have rejected my
that they have
application.
Ensure that
Directed me not to take
Mr.
back
Naik's Leonard Jr. takes a snapshot of that in his WhatsApp and communicates to his client outside court. At the outset, Learned Counsel for the WBSCDCL submits that an endeavor is being made to resolve the issue raised in the petition, if possible, to enable Learned Counsel for the WBSCDCL to apprise court on in that regard, on the prayer of the WBSCDCL, the matter is adjourned till August 3, 2023, when it will be listed under the same heading. It is expected that it is expected. It will appear on 3rd August.
I'm extremely grateful, Lord. But I must get the entire picture before making the submission.
Pardon?
I must get the entire report and picture.
Yes, absolutely. Whatever will be.
I'm grateful.
You satisfy yourself, Mr. Naik, first,
Not say
then
that,
come
sir.
back.
I'm grateful.
item number 15
Yes, Mr. Amit, what is the matter? You are for the respondent?
I'm for the West Bengal Pollution Control Board. Your
I'm
Lordship.
for the respondent.
Right.
The service has been effective on all the parties, my lord. In this matter,
What is the matter, Mr. Amit?
the petition, private respondent, my lord, running a poultry farm, my lord, without maintaining any guideline framed by the competent authority. And that too, my lord, the poultry farm has been established, my lord, on the plot earmarked for pond, my lord, without obtaining any order of conversion. And unauthorized construction has been made upon the embankment of the pond, my lord. The several representations have been made to the
So
various
pollution
authorities.
control board, according to you, pollution control boards have not been taken and the construction is also unauthorized.
Lordship, my lord. Already in the earlier officer, my lord, old farm is there and another is added there to my lord. Another building is being constructed for.
You are a neighbor.
I am the neighbor, my lord. Within the locality, my lord, the farm is running, my lord.
Let us hear them. Yes, you first, pollution.
If I may just hand over a copy of the guidelines that are in force. Pursuant to a solemn order passed by the National Green Tribunal, guidelines relating to poultry farms were formulated in the year 2022, that is in force. If your lordship kindly takes the guidelines.
6.0.
The guideline starts from the third page. It is not
Third page,
paginated,
yes.
your lordship.
Very
I'm
well,
sorry.
yes.
At
Do you say these have been complied with in this case?
These are the guidelines that are in place. Your lordship kindly turns over to internal page 6.
Yes, 6.
Clause 4, classification of poultry farms.
Hmm.
The next page, your lordship would find that there are 3 classifications, small, medium, and large. This poultry farm, it falls under the small category.
Hmm.
Because it has been alleged that the capacity is around 7,000 birds at one place. Now your lordship kindly turns over to internal page 12, that the penultimate page of the.
Yes.
Lordship would find the citing criteria.
Hmm.
In the writ petition, it has been alleged that the poultry farm is located a few feet away from the property of the petitioner, but here from the guidelines, it is evident that it has to be 500 meters away from any residential zone and 10 to 15 meters from rural roads.
and all, rural roads and all. Yes.
Also, there's the distance prescribed for the water body.
Their allegation is only regarding this residential zone.
Residential
But
zone
that-
as well as the water body.
Water body is also there.
Yes, water body is also there.
And if
Okay.
your lordship turns over to the last page, this is the regulatory or monitoring mechanism for poultry farms.
Yes.
As per the present classification of categorization of industries, poultry farms, they fall under the green category. And if your lordship takes the third point, poultry farms handling over birds above 25,000 at a single location will have to obtain consent to establish and consent to operate under the relevant acts. However, if your lordship comes to the next clause, with effect from 1st January 2023, that same rule, consent to operate and consent to establish, would be required for farms having a capacity of more than 5,000 birds. So in the present case, if the contention of the petitioner is right, they have 7. So the private respondents would be requiring a consent to operate the farm.
You are for the private respondent? Yes.
In this matter, my lord, my capacity is only 1,600, my lord.
Please take the microphone. Yes. 1,600 birds.
Only 1,600 birds, because, my lord, the area is 2,200 square feet, my lord. And
I'll appoint a special officer. Both of you will be the special officers to count the number of chickens.
Right.
That is the only dispute then.
my lord, basically,
So you count the chickens and if
My lord, I
possible,
have been-
produce some samples in court also.
I have bill, my lord, which shows that I have.
This is
got
the
only
ultimate. I mean, we have to decide on the number of chickens.
My lord, actually, the
Give a
area.
bit better status to
my
you.
lord, actually, the area is required minimum 7,500 square feet.
You are the pollution control board. You hold an inquiry. You send your people to count the chickens, literally.
Lordship may direct the respondent number 8 in that.
Respondent 8. Poor respondent number 8.
The environmental engineer.
The environmental engineer has to do this
My
also.
lord, right now, there is no poultry farm. my lord.
Do you have any document to
my lord.
substantiate a number of chickens?
Yes,
I'll
my
do
lord.
this. I'll direct affidavits to be filed, and Mr. Ahmed, this will appear 2 years after. After all the chickens are.
My lord, already video has been complained, my lord. Kindly have a look, my lord, page 23, my lord. And so far, water body is concerned, my lord. The poultry farm has been constructed on the plot earmarked for pond, my lord. That is not permitted.
Which is the appropriate? Is there any appropriate authority to resolve these issues?
My lord, the district magistrate may be directed to take up the issue. whole issue.
It has other works also.
Consent to operate, if
Yes.
the consent to operate, in case it has been given, that is given by the general manager of the district industry centers of the relevant district. But he is not a party, I believe. In that case, your lordship may be pleased to direct the respondent number 8. He is the competent authority.
8.
8.
Thank you. Then I'll ask for a report from the respondent body.
Whether the private respondent is having the requisite licenses and
Yes, yes, all the relevant documents. And learned counsel for the petitioner alleges that the private respondent is running poultry farms immediately adjacent to the petitioner's residential property, comma, in violation of all pollution norms. Full stop, next para. It is alleged that the number of birds in the said farm ranges around 7,000. Full stop, next para. Learned counsel appearing for the private respondent, comma, however, comma, controverts such submission and argues that the number of the birds in the poultry farm is around 1,800. 1,600, 1,600. Full stop, next para. Learned counsel appearing for the pollution control board places reliance on environmental guidelines for poultry farms issued on in January 2022 by the Central Pollution Control Board, comma, Ministry of Environment, comma, Forest and Climate Change, comma, Government of India. Full stop. By placing reliance on certain provisions of the same, comma, it is submitted that in case of new poultry farms within bracket set up after issuance of guidelines, bracket closed, they should preferably be established 500 meters from residential zone in order to avoid nuisance caused due to odor and flies. Full stop. Moreover, comma, the said farms have also to be set up at least 100 meters away from major water courses like river, comma, lakes, comma, canals, and drinking water sources like wells, comma, summer storage tanks, comma, in order to avoid contamination due to leakage stroke spillage, comma, if any. Full stop. It is further provided there that the farm has to be 10-15 meters away from rural roads, stroke internal roads, stroke village pagdandis. Full stop, next para. That apart, comma, as per clause 8.0 of the said guidelines, comma, it is submitted that as per directions of the National Green Tribunal dated December 10, 2021, passed in OA number 320 of 2021, comma, poultry farms handling above 5,000 birds at a single location shall also obtain consent to establish within bracket CTE, bracket closed, and consent to operate within bracket CTO, bracket closed, under the Water Act, comma, 1974 and Air Act, comma, 1981 from the State Pollution Control Board stroke Pollution Control Committee with effect from January 1, 2023. Full stop. The poultry farms are categorized under green category, comma, therefore validity of consent would be 15 years. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is clear that the only question involved herein is whether the private respondent has complied with the pollution control norms, comma, as embodied in the environmental guidelines for poultry farms. Full stop. Next para. Accordingly, the respondent number 8, that is the environmental engineer, comma, West Bengal Pollution Control Board, shall furnish a report upon holding an inquiry, comma, upon prior notice to the petitioner as well as the private respondent, comma, indicating as to whether all necessary formalities have been complied with by the private respondent number 9 in setting up and operating the poultry farm in question, poultry farm within bracket S in question. Full stop. Such report, what will be a reasonable time for that? 3 weeks?
6 weeks, your lordship.
6 weeks is too.
4 weeks.
4 weeks. Such report shall be filed on the next returnable date. Full stop. The matter shall next be listed on August 28, 2023, under the same heading. Under the same heading.
Grateful.
It will be with a prior notice to both of them so that they can place their cases also. Thank you.
Item number 16.
I'm for the petitioner, my lord. My lord, here the issue is very small. I am a company whose shares are listed on the Bombay Stock Exchange. About 34% shares of my company is held by the respondent number 7, which according to me is a shell company. It was struck off because it was no business, no accounts filed from 2014, no business activity. The only job it was trying to do clandestinely, despite being struck off for last 14 years, was trying to deal with my shares and sold a high quantity on the stock exchange so that my price of my share on the falls. This was happening. My broker informed me from Bombay that somebody is trying to manipulate and deal with the price, your shares so that your price falls. Immediately after coming to know, we wrote to the Register of Companies and the Ministry of Corporate Affairs to take steps and investigate into the matter. The investigation was not done. I've written, that is why this has become 3 volumes. I went on writing complaints. I also filed complaints for the Economic Offence Wing, Bombay. So they passed an order that the demat account of these companies, which are according to me shell companies, including the respondent number 7, be frozen. Demat account was frozen. Despite being frozen, still my shares were sold by them. I don't know how. Now, this serious matter involves the Register of Companies and the Ministry of Corporate Affairs to file a report before this court upon investigation as to what is the actual state of affairs regarding the shell company. Lordship, now the government of India has taken a policy that all the shell companies should be struck off. Now here, a shell company which is struck off for 15 years comes to the NCLT. They get an order of revival because of the negligent conduct of the registrar company, who files a very, very short report of 1 page. Nothing is mentioned about these facts. And because of the failure on the duty of the part of the statutory authorities in filing the appropriate report before the National Company Law Tribunal, that's R7, Respondent 7 has now been revived and the struck off has been cancelled. And when I go to apply before...
It has been revived?
Yes, it has been revived by the order of NCLT on 26 June. I go and apply for intervention. I'm not being heard. They say you're not party. Now this, I'm only making a short prayer. Let the ROC,
Mr. Sharma, what is the scope of inquiry by the writ court here?
My lord, writ
because you have already applied.
My lord, I'm
of the companies, my lord.
My lord, I'm only.
He is the authority. They have filed a writ petition.
That is withdrawn. Bombay High Court withdrawn.
My lord. The issues are already, my lord, over there.
Bombay High Court, we have withdrawn.
And it is written, my lord, criminal writ jurisdiction. They have failed there.
No, we have not been moved. Bombay, that is mentioned in the body. Bombay High Court, we have withdrawn, I mentioned I'm taking steps. Yes, it is stated.
They have stated only that they are taking steps.
Yes, so now we withdrawn after that.
But whatever it may be, my lord, section 252 gives a liberty of 20 years to the creditors. It is not up to me.
I'm not a creditor. This is there. I'm not a creditor.
For offloading of
failure to, I'm only saying that the statutory authority, they have failed to say
what is the sort of relief, Mr. Sharma?
I'm only saying, my lord, let the
kindly see the prayer.
Kindly direct the respondent authorities, who are the respondent numbers 1 to 4, to file an appropriate report before this court after investigating within their powers and rules.
Sharma, you can very well
I've done. I will give.
You have been impeded before the NCLT.
I went. I was not allowed because you're not a party.
Before the enclave, they should have.
I'm not a party. I was not a party.
There.
I was not a party. It was between the ROC and the so-called shareholder of respondent number 7.
Did you formally apply for impediment there?
I applied for impediment and intervention. It was not allowed on the ground that
challenge that, Mr.
Lordship, that is a separate forum, because I'm here I'm approached the Constitutional Court to say that how the respondent authorities have failed to discharge their duties. I cannot urge that before the NCLT. Why are they trying to shield the shell companies? Why is the registrar of companies trying to show that they are very close to the shell companies? They should be transparent. They should be fair. And it is a policy of the union government that all the shell companies will be struck off. And here the ROC acting, they file a very vague report.
What is the proceeding pending before the NCLT? You said?
Now today, no proceeding is pending. No proceeding pending.
So why did you seek to impede yourself?
Mala, we have mentioned that without the order, we have sought to impede that intervention was not allowed.
That was in connection with ROC having revived them.
We after we came to know that the order was passed for we filed intervention, it was not allowed.
No, that was regarding the revival of the
Yes, I wanted to come and object to urge these points. I was not allowed.
But
Now-
Mr. Sharma, you are entitled to file an appeal against that.
Today I was not a party there. If I go to NCLAT and says that you are not a party, why didn't
No,
you?
no, you will challenge that non-impleasement of yours.
I was not a part, under the 252, I'm not supposed to be pleaded in the first place.
That's true.
It is between Lordship C 252. If a Lordship one, I can come back at 2.
Let us continue after 2 years.
Lordship.
I'll look into 252 and see the scope. Thank you.
अच्छा, गोरे के बाद आएंगे।
41 NCFT rules.
Yes.
Lordship, may kindly permit Mr. Banerjee, my lord.
But kindly also permit Mr. Banerjee, my lord.
Yes, definitely.
I'm grateful, my lord, for. Sorry, my lord, I was couldn't come. My lord, I was trying, but then I
No,
saw it
no.
was already 1:15. So, my lord, by the time I came, my lord, had risen. My lord, my lord must have heard already. My lord, the issue, my lord, really is we complain of. My lord, there were a series of, my lord, defunct of shell companies which were, my lord, struck off the register of companies under the power. But 248, my lord, there's power of the register to do that. Then, my lord, there is a provision under the Companies Act, which, my lord, you have to go 252, my lord, where you have to go and then make an application for the purpose of restoration. The register of companies, my lord, report which is called from the register of companies, and the register of companies has to say what is the circumstances and, my lord. Now we find, my lord, I'm a listed company. The petition number 1, my lord, is a listed company. I have, my lord, about, and this is after investigation we found out, because, my lord, one of our shareholders complained that your shares are being sold. And therefore, as a result, my lord, by reason of manipulation of my shares, my share price have really gone down. So, my lord, we made an internal investigation and found out that, my lord, in my shareholding list, there are about 200 companies which are defunct or which have been struck off. And we also found, and, my lord, we also went to NCLT to oppose one instance, which, my lord, we made them a party, that where, my lord, the share trading was done really when, my lord, these companies were struck off. So I, my lord, wrote several letters to several authorities who are all, my lord, investigating authorities, including, my lord, the Economic Offences Wing, the Securities and Exchange Board, and the Register of Companies to say, please investigate. Please investigate and find out what is happening. Now, my lord, to be fair, my lord, Register of Companies initially said that, also wrote letters, my lord, to SEBI and saying that, please also look into this. But thereafter, my lord, we found, and that's why, my lord, we have given an example, my lord, in the writ petition itself of those two companies, that, my lord, when they filed a report before, my lord, the NCLT, nothing is mentioned of this issue and the complaints which we have made. And as a result, what happened, my lord, that company, my lord, got restored. So, my lord, whether, my lord, the company gets restored or not, that is the subject matter of the NCLT proceedings. That, my lord, I'm not, my lord, complaining. I can't complain here. But what I'm on is that the Register of Companies, and, my lord, he also can't resist. If, my lord, there's some kind of case made out, then he will also has the investigative powers, my lord, under section 206 to 210 to investigate into, my lord, what the complaint is. And admittedly, my lord, these are, my lord, all struck off companies. My lord, I'll show, my lord, the list which, my lord, is there. My lord, kindly, my lord, come to, my lord, page, and that is, my lord, our grievance. I'm sorry. My lord, at page P3, which is, my lord, page 40, my lord, this is how, my lord, we were put to notice and we started, my lord, in making inquiries with regard to this. My lord, see the address sale of shares by strike, it should be struck off really. Companies of Crescent Solution, I am Crescent Solution. We are shareholders of your company having invested in shares in January 2022. This is to bring to your notice that we have come across the fact from our Kolkata-based sources that some of the strike off companies by Register of Companies ceased to be private limited companies from date of being struck off have sold offloaded shares of our company in market. As per me, this is unlawful and unethical. We, being the investor shareholder of the company, request to look into the matter urgently. You required steps towards this would be in favor of investor, even as a company, and intimate to me the steps taken by regarding this intimation. Then, my lord, this
petitioners are the company or the shareholders?
To the company, by the shareholder to the company.
The petitioner in the present writ petition is the company.
Yes, yes. Then, my lord, kindly see P4, my lord, is, my lord, the 200 shareholders. My lord, this is, my lord, what the particulars of, my lord, we have given. Page 41 to, my lord, 88 is a list of, my lord, my 200 shareholders, my lord, who are all struck off. Now, my lord, kindly, my lord, straight away come to page 89, my lord, will find. And this was included, my lord, in the list of Register of Companies. Kindly see. Form number STK 7, notice of striking off and dissolution. Page 89. And, my lord, as far back as in 24th August 2018, my lord, they were struck off. And they're being restored now, my lord. I don't know, my lord, what is the connection, my lord, with regard to, my lord, sale of my shares. Kindly see in the matter of Sansach, in the matter of companies at 2013 and 7145 numbers of companies as per list attached as Annexure A. This is with respect to this officer's notice number, event dated, notice is form number STK and dated 28. Notice hereby published that pursuant to subsection 5 of section 248 of the Companies Act 2013, names of 7145 numbers of companies as per list attached as Annexure A have this day, 24th Sansach, been struck off from the list of companies said come and dissolved. Now, this list, my lord, includes 200 of my listed companies or my shareholders, really, my lord, to say.
Yes.
My shareholders, my lord, because I'm a listed company.
Yes.
Then, my lord, I started, and my lord, the list is there, my lord, right up to page 149, really, my lord, the list is there. Then, my lord, sees, my lord, I started, my lord, making complaints from page 177.
Yes.
Kindly similar intimation regarding transaction by struck off companies. And my lord, this is to the regional director.
When were they restored, Mr. Banerjee?
My lord, not all of them are restored.
Achha.
Only, my lord, some of them are restored, my lord, who I actually, my lord, made them a party. My lord will find, my lord, respond number 7 was restored on, my lord, 26th June.
So some of these, the rest are not yet restored.
Not yet restored.
Right.
But our apprehension is, my lord, like, because they all hold shares, what will happen is, my lord, they will all get restored without, my lord, there being any investigation done as to why they're being restored, or, my lord, at least the registrar should be on notice that I've asked for investigation.
Mr. Banerjee, do you have a say in the section 254 proceeding?
My lord, I did go, my lord, in the 252 proceedings. I was, my lord, told that since judgment has been reserved, my lord, I was not entertained.
That is a different point, but
Yes.
otherwise you have a locus.
I may not have a locus. I may not, though, my lord, I know of a judgment, my lord, which in fact, my lord, we had, my lord, argued whether, my lord.
How are you affected?
I am affected because, my lord, my shareholders who are struck off are dealing with shares, because otherwise, my lord, these shares will not be.
The shareholding center balance sheet.
Yes. Because I'm a listed company, and what will happen, my lord? These shareholding, if held by the struck off company, they were being traded, or, my lord, they're being sold off. So that means someone else is really behind the scene. And that is the apprehension, my lord, I've expressed. So it's really, my lord, that 177, my lord, comes to, my lord. I'll show, my lord, just 1 or 2 letters. I won't take, my lord, much time on this. I think, my lord, I've been able to.
Mr. Banerjee, according to you, what is the effect in law if suppose a shareholder is struck off?
My lord,
what happens to the share?
My lord, state, bona vacantia, or, my lord, because otherwise, either it has to be restored. Well, there's a particular period in which 2 years you can come and have it restored.
If it is not restored,
then my lord, it goes to the state.
No objection.
Because in fact, my lord, will remember, my lord, the matter, my lord, which the Investor Education Protection Fund.
Yes, yes.
The shares, my lord, not claim, my lord, for 7 years, it will get transferred.
Right. Okay.
So, my lord, so there is a mechanism. My apprehension is that, my lord, someone today, my lord, is.
But you cannot be affected directly, Mr. Banerjee.
My lord, because, my lord, the share, my lord, I'm supposed to, my lord, my registrar members have to, my lord, supposed to reflect, my lord, the shareholding.
Yes.
It can't be that, my lord, ghost shareholders will be, my lord, then be trading, my lord, in those shares.
There are several other repercussions also on your transaction.
Share price
Share price and everything.
Yes.
Right. Maybe.
My lord,
then you have a look at it to go in. Go and
I have been,
participate.
but my lord, if there are 200 restorations, my lord, I'll have to run in 200. I want, my lord, the registrar of companies, my lord, to take steps to investigate into this, because if there's a report, then, my lord, necessarily that report will be part of all proceedings.
So regarding the already restored companies, Mr. Banerjee,
there is a that, my lord, I'm not. I can't.
very little scope.
Yes.
Yes.
But I'm showing that, my lord, I've included him only to show that this is what is happening. Because the registrar of companies, my lord, the affidavit which they have given, there also, my lord, there's nothing with regard to this asking for investigation. And that report, my lord, is subsequent, my lord, to, my lord, the complaints which we have made. My lord, I can just show 1 or 2, 177, my lord, will find a regional complaint, my lord.
The effect of striking of Mr. Banerjee, please clarify to me. Effect of striking off is they go out of the list, but they remain companies.
No, they get, my lord, that's, my lord, what they say.
I don't know that.
89, my lord, Register of the said company are dissolved.
The companies are dissolved. All right. So they do not exist anymore.
That's right.
All right. Very good.
So at least one of the shares no one can deal with. And that's correct. Sometimes there are reasons why we go back to under 252. We go back to the National Company Law Tribunal now, before it was the High Court also, where we go back and say, look, it got struck off, but there are some properties or there's some reason why we couldn't do it. Please restore the company back to its name.
You cannot espouse your cause of action on restoration in this writ petition.
Absolutely.
There is no scope of that.
There is no scope.
So let us cut that out.
Correct. Correct.
The only scope is whether they should investigate into your existing complaint,
right.
which are regarding some companies of those are not yet.
That's the subject matter.
Very good.
Because I'll just show 206 to 210 where there is under.
Yes, you have to show that.
I'll show that because otherwise,
yes,
I'm
the
just
scope.
showing. I just kindly give me 2 minutes on 177.
Yes, 177.
Just give me the other best letter we have. This will give the gist of what we are complaining of. We, Crescenda Sunset, listed company, our shares are listed in BSE, come to a notice that some of the shares of the company are held by companies whose names are shown as struck off. In MCA portal, list enclosed and marked as Annexure A. It has that 177. As per knowledge and information, if the name of any company is struck off, that company ceased to be in existence, will not be able to carry on activities, operations, assets, and can't be disposed of, diluted, come to stand frozen unless the name of the company has been restored by an order of a company sunset. Accordingly, neither directors nor any officer of the company can deal. Then next, it has come to the notice of the company. It is already read the whole.
No, please.
It has come to the notice of the company that some of these struck off companies, which are shareholders of a company and holding shares, are post struck off disposed of shares. This is what I'm either in part or full held by this company in Crescenda. List in respect with documentary support is enclosed. As per our views, this transaction are barred by law. According to management company view, that should be brought into your knowledge to analyze the situation according to law. Please kindly know information required in regard assistance. This is one
vaguely stated that take note of the above and information, if any, in this regard, and also assistance that you seek from our end. So, where is the scope of issuing a mandamus? I mean, on this.
Investigation.
You have not sought for an investigation.
There is
you have just pointed it out to them.
Kindly,
and please take care of these things. If necessary, I'll assist you.
Kindly come to page 193.
Yes.
And I'll show their letters also where they kindly see 193 at 194. Last paragraph 2.
Yes, right.
Investigate. Then kindly come to 210. 210. Access. Then it is, I think, the second volume. 210 up to 228.
So there are other similar
yes, and then kindly see 213. No, 213 is the letter of EOW. Then give me the register of companies. RT's reply. 230. Kindly see 230. This is the Ministry of Corporate Affairs. This is their letter. I'm saying follow this up. Yes. 230.
Yes.
30th November. The register of companies writes Ministry of Corporate Affairs, Office of Register of Companies. Received a complaint. Enclosed with 2 copies of the letter from Milind Parva on behalf of Crescenda Solutions, which is petition number 1. In this context, state name of the company is struck off for non-filing of statutory returns. This relates to Truthful Wind Trade, which is another company.
So they have written the
register of company. Yes. Then they say further alleged that during the period of strike off, such necessary action steps in your matter.
ROC is taking steps on this.
Yes. This is the letter which they write. So I want them to investigate. So they have also written, but I want further progress. This is lip service. Then there's 316 also another letter from them. December 2022. And kindly just look at The fact is mentioned, my lord, 1, 2, 3, 4, then the 2, 3, 1, 7 at paragraph 5. In view of the above, as per the allegation made by the complaint against the subject companies, as list attached as regards to trading of the shares during the period, request to furnish a list of day-to-day purchase sales of shares done by the companies mentioned in closed list for the period from 2013 to till date to this office within 10 hours. So now what happened, my lord, we don't know. Now, my lord, what we find, and this is surprising because what we find now, my lord, I'll just show. This is, my lord, as on 5th December 2022. Now show me that affidavit which they find, my lord. In 5/20, in the third volume, I'm sorry, my lord. This is as in, my lord, 2023, and that's why, my lord, we have annexed it just to show an example. 520, my lord, is the affidavit which they filed before the National Company Law Tribunal. And now kindly see, my lord, 521. This is, my lord, the affidavit. Then 522. They say there's 3, the company authority has struck off name of petitioner company under section 240 of the company since it had reasonable cause to believe Stream Commercial was not carrying on business on an operation period 2 years and such. Then, my lord, they give all this, my lord, period. Then they say the available records of the office. Then kindly turn over the page, my lord, at 523. Nothing, my lord, there's only paragraph 6, my lord, they say that we are not shareholders, therefore, my lord, they oppose, my lord, the. And then paragraph 7, that in this regard, it is submitted, presently status of the company struck off, company can be allowed to revive. Under sunset of its own merits, on its own merits, directing petitioners to the pending statutory order while the. So I am saying, my lord, that my complaint, my lord, still remains unaddressed. Though 2 letters they have written saying that now give us day-to-day sale purchase, what is happening. But after that, my lord, when it comes to restoration, the same register of companies, my lord, is filing affidavit saying that you decide everything on merits.
So what is exactly the scope of investigation you want? What should they do? Investigate about what?
My lord, investigate, my lord.
About all the 200 shell companies?
Yes, because it's under their purview.
You don't want to go and add yourself to all these restoration applications, but you want them to have a.
My lord, the difficulty is, my lord, that every restoration,
yes,
when I go, if the register of companies says no, there's no problem, then, my lord, I'm out of court anyway.
And you have to keep a watch also which company is
where
seeking restoration and all.
So I'm only saying, and it can't be, my lord, that you will not investigate if such a serious thing has been put on really, my lord, as facts.
So, please show me their duty to investigate. 206 to 2010 as you said.
Yes, my lord, kindly.
210, I'm saying.
206. My lord, yes. Because the striking of, my lord, the restoration shouldn't happen automatically. That's what I'm saying. Where kindly see, my lord, 206.
Yes.
Where on a scrutiny of any document filed by a company or on any information received by him, the registrar is of the opinion that any further information or explanation, any further documents related to the company necessary, he may by written notice require the company. Now, my lord, sees the notice I've shown, my lord, page 316, 317. He's written to other authorities, the SEBI and all that, to say, give me detail with regard to when the sale happened. To furnish in writing such information, explanation, or to produce such documents.
This does not apply to your case.
Yes, information, my lord, that 317, my lord, they had asked for
Not a
information.
scrutiny of any document filed by a company that is regarding your transactions.
Yes, or any information received by him.
So this is on a different inquiry, different investigation you are wanting.
No.
You are asking them to act as an investigating agency and look into this shell company thing, the entire scam.
Who are, my lord, my shareholders.
How does 206 apply?
But where on a scrutiny of any documents filed by a company,
Yes.
or on
mean to
any
say you-
information received by register of the opinion.
Yes.
So, my lord, or any information received by him. So,
That is
information
pertaining to your company. So if you admit that you are also a shell company, I can direct them to you.
pertaining to my company, in where, my lord, shareholders are shell companies. Where my shareholders are shell companies. That is, my lord, also within the jurisdiction of the register of companies. My lord, if I complain about, if someone, my lord, complained about my company, register would have jurisdiction. I am complaining about 200 other companies.
So you say this is an information received by him?
Yes. Because I am giving them information with regard to my shareholders.
All right.
My shareholders, because my lord, that is what my lord, is relevant, because he is also my lord, going and saying that you restore if you want to restore. Then my lord says, on receipt of a notice shall be duty of the company and the officers concerned to furnish. That is, my lord, I am supposed to furnish, my lord, if he asks for anything. Then provided where such information or explanation relates to any past period, office or employment, and so on. Now, my lord, just pausing. Now his duty is to ask all those 200 companies that give us information where, how did you dispose of? Or did you dispose of?
Let me see the inquiry which is to be undertaken for striking off.
Yes, Malad, then Malad, kindly see.
Their responsibility cannot be more than that.
Malad, kindly see, Malad, 207.
207, very well, yes.
I'm sorry, Malad. I'm sorry, Malad. I hurried a little bit, but if 206, Malad, looks at Malad, all these sections, 4 is also important.
Yes.
If the registrar is satisfied on the basis of information available with or furnished to him or on a representation made to him by any person that the business of a company is being carried on for a fraudulent or unlawful purpose. So these are those 200 companies, or not in accordance, fraudulent, unlawful, or not in compliance with provisions of the Act, or if the grievance of investor not being addressed, registrar may, after informing the company of the allegation made against it by written order, call on the company to furnish in writing an information explanation. As then will provide the central government with satisfied circumstance warrant. So warrant direct the registrar or an inspector appointed by it for the purpose to carry out the inquiry under this section. So it is very wide.
Yes.
Then Malad, kindly see provided further where business of a company has been or is being carried on fraudulent or unlawful purpose, every officer of the company is guilty. Then Malad 207 is conduct of inspection and inquiry. Then Malad 208 is Malad inspection made and Malad the report.
These are consequential to the.
Yes, and then Malad kindly also see Malad 210. That is Malad very important.
Yes.
It's very wide pass, Malad 209, 210. Where the central government is of the opinion that it is necessary to investigate into the affairs of a company on the receipt of a report of the registrar inspector under section 208 on the specialization, public intent, may court intention. So, Malad, the registrar then triggers Malad the central government. Now, Malad, I'll show Malad 248. That is Malad the striking of provision. $248. All Malad 234 Malad is notice to be issued. Then 5 Malad is where at the expiry of the time period in the mentioned notice, registrar may, unless cause to the country shown by the company, strike off his name from the register of company, shall publish notice thereof in the official gazette, and on the publication, the company shall stand dissolved. Then Malad 252 and 250 is also Malad very important.
Mr. Banerjee, 248.5.
Yes, Malad.
Isn't 248.5 what you were saying? 248.5. Contrary to your argument regarding 2064, because 248.5 says, not 248.5, I'm sorry, 248.1.
248.1.
Where the registrar has reasonable cause to believe that company has failed to commence business, company is not carrying on its business such and such for a period of such and such.
Yes.
So the entire thing is regarding the company not carrying on its business. But 2064 says, if registrar is satisfied on basis of information that business of a company is being carried on for a fraudulent or unlawful purpose, how can you equate the two?
Well,
I mean, there may be allegations by investors or from other quarters which are affected directly by the functioning of the company.
May I try and Malad explain?
Yes. You are a company of which this company is holding a share.
Yes.
You're not an investor, not anything vis-a-vis this company. Only thing is that your shares are being held by this company.
Any person can complain. My
Complaint any
complaint,
person can
my
make.
complaint has come, my lord, from my investors. That's my lord, I showed page 40.
Regarding
Just-
irregularity, yes.
Yes.
It's functioning.
In the functioning of my shareholding.
But if it's struck off, the striking of ground is basically that there is no functioning of.
Correct.
Yes.
Now, my lord, now it's being restored.
No, restoration is on a different footing. As you
I am
say.
complaining of that. My lord, I am complaining of that these companies which were struck off, which are really, according to me, shell companies.
You're
And that's
trying
what,
to equate the other companies with the restored companies, Mr. Banerjee. Two are different reliefs you're claiming. Regarding the restored companies, your relief lies elsewhere. But regarding non-restored companies, but regarding which out of those 200, regarding which your striking of complaint still remains, the striking of is still there.
yes.
Now, you say those are functioning in a manner and you are invoking, seeking to invoke 2064.
Correct.
How can it be invoked at all? That is, there is no functioning of the company.
Not functioning only because they're selling off the shares.
That's an illegal activity. That's a financial.
Who will, my lord, otherwise, my lord, who will, my lord, investigate into that?
Investigating agencies are there.
My lord, register of companies, my lord, who is, my lord, not opposing the restoration? He's the best person. He should come and say that you could not have traded.
Restoration does not come in the picture. Either restoration comes in and you have a remedy before the appellate authority, or restoration does not come in at
My
all.
lord, may I just show, my lord, why I'm saying restoration comes in? Because, my lord, my apprehension is this. And that's why, my lord, I've given that example. My lord, that is, understand, my lord, I have a group of shareholders. These are 200 companies.
How do you equate the 200 companies? On your apprehension, you are the
No, I've
unifying
given the
factor.
list. My lord, my lord, in 2018,
Yes.
my lord, the register of companies struck off 7145 companies.
True.
In that list, there were 200 of my shareholders. 200 of my shareholders. Out of these 200 shareholders, 2018, my lord, everything is gone, no difficulty. All of a sudden, I find that, my lord, I get a complaint, my lord, from one of my investors saying that, look, you had a list of companies which are all struck off, but now they have been trading shares while they've been struck off. I made an investigation. I find out that is correct. Then, my lord, I found out one of the 200 companies made a restoration application before the Company Law Tribunal. And, my lord, the registrar of companies today filed an affidavit ignoring the complaints which I made to him before. So my cause of action is, my lord, against the union, against the registrar of companies to say, you have not bothered to investigate into the complaint I made with regard to manipulation of my shares or sale of my shares by struck off companies.
Mr. Banerjee, what I am to tell you is that this 7145, either there has to be an inquiry investigation regarding all the 7145, apart from those which have been restored. Restoration is a different thing. Either it has to be regarding all these 7145 minus those restored, or it has to be no investigation at all otherwise. I mean, I say this because out of these 200, the only unifying factor, the platform on which these find identity is you, who is not a relevant factor regarding the striking of at all.
Lord,
So these 200, you are apprehending from your perspective.
Yes.
Your perspective is not the only, I mean, not the relevant perspective.
Lord, it's up
You
to
say 200 of my company, my shareholders were struck off. Out of them, say 10 have been restored. So I apprehend that 190, the rest 190 may also get a restoration. So please have an investigation regarding my shareholder companies which have been struck off. Why are you so special, basically? Why there should be an investigation by the ROC regarding your companies?
Lord, if he wants to investigate, my lord, all his 7145, I have no difficulty.
There,
I'm
Mr.
only
Banerjee,
concerned.
there, Mr. Banerjee, what is how does the law cast a duty even on them to do that on the ROC?
I am concerned because, my lord, my 200 shares will be involved. I'm a listed company. My share price is being manipulated by, my lord, these companies which have been struck off. And, my lord, when my lord says I'm not concerned with the restored companies, that is also not correct.
Achha, have you given specific instances that these are the transactions, these are the shares transacted on such and such date to such and such person? You have to give instances, file a lodge a diary, lodge a complaint, the investigating authority agencies
Lord,
will.
I have done what I've written, my lord, to everyone. I'm, my lord, written to the registrar, I've written to the economic offences wing, I have written, my lord, also.
Well, I'll direct the economic offences wing to look into the matter.
My lord, yes.
Register of companies, I don't find anything in 206 to 210 in this aspect of the matter. They need to do a blanket inquiry investigation. ROC won't have any other duty, other work then. It has to be engaged in these 7145 investigations.
Well,
ROC is not for that exactly, Mr. Banerjee.
Well, otherwise, well, I don't know, well, that's their power as well. to investigate.
06 to 210.
Yes. Well, that's the investigation. Otherwise, well, what will they do? Well, they have a portal where everything is filed. And well, sometimes we have difficulty in that as well. Now with the e-filing, if something goes wrong, you've had it. And if someone forges takes away your signature, then you've had it again. Then the company has 20 old directors, the 10 new directors are sitting outside. So that is the functioning of the rest of companies with the greatest respect. But what I'm saying is, I'm concerned, my cause of action is only I'm concerned with what is happening in the affairs of my company. And that relates to companies which I say was struck off in 2018. Now, even with regard to the restored companies, they're also he's supposed to investigate. Not on the question of restoration.
Previous.
Yes. That how could you really transact while you were not there? And there is also there is in fact there's also a letter which
you are taking a cue from the CBI directions. ROC will become CBI then. My cow is stolen from my backyard and CBI is inquiring.
It's
CBI is doing everything apart from resolving matrimonial disputes up to now. But if it's a high profile matrimonial dispute, probably they will decide that after some time. So you're rendering the ROC to that.
That's the part of the job. That's investigating. And kindly see, then only a prima facie, because they then have to under 210 give it to any central government.
Which would
otherwise, someone has to if my what I say is correct, then there has to be some investigation. And I'm not without basis, because ROC himself says, give me details. That's what I showed at page 316 and 317. Has seen that 5th December.
Everybody loves to brag, Mr. Varens. Everybody loves to brag. Oh. Yes, show me what they do. Whether they have any power, I don't. 2064, yes.
2064, they have power.
There are powers of investigation,
yes,
definitely.
Yes.
What will be the?
No, when required, they investigate.
Yes, that's true. Yes.
Please, I'm sure sometimes we have also come here saying that please ask him not to investigate. There are instances where there's been quite a lot of investigation by the rest of companies.
If there is a provision in law, they are duty bound to.
Yes, and also 213, we also got the
213.
213.
In other cases, all right.
213, I'm sorry, Yes, because the whole lot of companies are there. Someone has to do this. With reference to the this is from the Economic Offences Wing. With reference to the above mentioned subject, this will inform you that there's office forwarded list of names of 55 companies to NSDL, list of names of 100 companies to CSDL, with instructions to communicate further concerned depository participants to
B to 13B. The application made to it by any other person or otherwise satisfied circumstances do this come in fraudulent or
section is looking at. I'm sorry,
section 213.
Oh, I was referring to page 213.
Oh,
I'm so sorry, I'm so sorry.
No, section 213 is better for you.
Oh, section
yes.
I'm not
rather than the page. Yes. It's a Freudian slip.
Yes.
Regarding fraud of companies and all.
This is on the before the tribunal.
Yes.
Oh, I'm sorry.
The tribunal made an application made by not less than 213 A.
A does not come in. B may come in. If that be so, then you have to go to the tribunal also.
No, this is 213 in my.
Why not 213B before the tribunal?
Any person.
Business of the company is conducted by intent to defer. This is perhaps not. This is
that company I could have.
Very costly mistake on the part of the court.
No. 213B is not a totally different issue. Where shareholders apply. And B really says, even no shareholder, but this is investigation regard to affairs of one company. My shareholder can go under 213.
What about B?
Yes, B also. B also, there's a argument with regard to whether A also applies to B or not, but it says any other person. So any person, and there are applications pending before the NCLT where
you are any other person, you may apply before the tribunal.
Then I've
regarding business of the company.
200 applications. I have to buy 200.
Exactly. You cannot avoid that by casting the liability on
No,
the
my lord, I can.
ROC has no duty to do
My lord,
go and
206
investigate.
to 210, what happens? It is my lord, their records.
206 is initiated on the basis of a complaint
Yes, that
or an
complaint is by me.
information. Yes.
Information is by me. And my lord, they did take steps. That's what I'm saying. It's not that my lord, they have my lord, also in page 317, which I showed, they did ask for it. Why is it not being followed?
That is it. Yes.
Page 316 and 317, my lord,
Ask for the lists and all. Yes.
Yes. So why has this thing stopped? There's no explanation, because I don't know, my lord. After that, I only find, my lord, they're quite happy, my lord, with the restoration. I'm on that.
That list seeking was page which was
316, my lord, 5th
316.
December 2022.
Right.
And kindly see, my lord, they written to Bombay Stock Exchange. So investigation has started. Kindly, my lord, see this 316. Subject information regarding trade locks for the selling transfers.
Right.
And they say, along with list of 155 stock of companies were shared. Further, this office has again received another complaint dated 29th November from such and such director on behalf of Crescenda Solution, which is self-explanatory. And my lord, in 213, my lord, will also find.
Yes, 213.
My lord, this is the page 213.
This is the correct 213. Yes.
Yes, my lord, page 2.
From your perspective, yes.
With reference to above mentioned subject, this to inform.
Very intricate question of law, sir.
Well, the investigation, my lord, is. I'm, my lord, just supposed to, my lord, get over, my lord, the, so to say, my lord, the probable watershed, waterfall, my lord. And if that happens, my lord, then. Well, otherwise, my lord, I can't do, my lord.
I'll refer this to a constitutional bench. It's a question of a constitution, of the constitution.
Well, the
Very
registrar of,
intricate question is it.
well, registrar of
Scope of
companies.
investigation by the.
Well, registrar of companies want me to go to the NCLT. My lord doesn't want to entertain me. My lord, what do I do? I've written, my lord, now, my lord, 10 letters. I had some response, my lord, from the registrar of companies at page 316, 317. After that, my lord, again, my lord, suddenly everything stopped.
Well, let me hear Mr. Banerjee then. The other Mr. Banerjee. Yes. Yes, Mr. Banerjee. Investigate. Why sitting idle? After writing the letters, what are you doing?
That is
What is
not
the
my
follow-up
work.
action? Give a report.
That is not my work, my lord. My lord, kindly takes the writ petition prayers once, my lord. What a page. My lord, kindly takes page 32 once, my lord. There is no scope for an interim measure, at least from the prayers. There is no reason why, my lord, my junior had asked for a, my lord, affidavit to be filed, because the facts would come out. And then I'll show, my lord, why. My lord, kindly sees 32. A writ of or in the nature of mandamus do issue commanding the respondent numbers 1 to 4 to call for the records, information for conducting inspection of the books of accounts, other statutory records, dematerialized records of the shareholdings. This is very important. I don't want to say, my lord, what has happened, but I have to say now. This is a classic case, my lord, of my lord, shares are my offloaded and they're not liking it because there's a set of shareholders who are doing this. With deepest of respect, ROC is not the, my lord, agency to look after all this. Share offloading is not what ROC will look into. But kindly see the prayer, my lord, how it is couched, my lord. Shareholdings for the purpose of conducting detailed investigation and inquiry in respect of respondent number 7. Now, my lord, as well as trading of securities at the instance of the respondent number 7 of the shares of the writ petition number 1. Well, this is not what the ROC has to look into.
And 7 has been restored.
Yes. And if it has been restored, then, my lord, kindly sees under, my lord, 421, any person can prefer an appeal. If he is aggrieved, he can prefer an appeal. Kindly sees the language at 421, my lord. The tribunal may, after giving the parties, my lord, I'm sorry.
This is
any
regarding,
person.
regarding regulation. I mean, regarding the restoration.
That's exactly what he's asking for. My lord,
Yes,
any
that
person,
they have a remedy.
but that remedy is there. Any person aggrieved by an order of the tribunal may prefer an appeal to the appellate tribunal, 421. So, my lord, first prayer that he's asking for is something he has got a relief before the appellate tribunal. Why will the writ court exercise jurisdiction? Then, my lord, other than that, there is no other such prayer. My lord,
kindly see is the nature of mandamus to issue directing the respondent numbers 2 and 3 either by itself or strictly, my lord, against shell companies as mentioned. What is the basis? Investigation done by him. Ministry of Corporate Affairs, ROC is not there. A writ of in the mandamus directing, commanding respondent numbers 1 to 4 to quash or set aside or declare illegal and void report filed in CP number. If it is so, respondent number 7, my lord, 421 will again apply. Prayer C. So, my lord, none of these prayers are something which the writ court can attract its jurisdiction, my lord. It's against respondent number 7. So he should, my lord, prefer an appeal. And my lord, kindly see why I am saying this. My lord, kindly takes his main grievance. Kindly, my lord, comes to paragraph. My lord, paragraph 34. This is his grievance, actual grievance. Page 19, paragraph 34. It is submitted that these struck-off shareholder companies are dealing with the securities of the petitioner number 1, not intended to effect transfer of beneficial ownership, but intended only to operate as a device to cause fluctuations in the price of such securities for wrongful gains. It is submitted that these entities have already sold more than 3.25% of the total shares of the petitioner number 1 as follows. Then, my lord, kindly sees 36. It is further submitted that these struck-off shareholder companies collectively hold approximately 34% of the issued equity share capital of the petitioner number 1, and therefore these companies can materially and permanently affect the economic status of the petitioner number 1 by acting in concert. The details. So therefore, my lord, the main grievance is not it is been restored. The main grievance is this offloading. And therefore, my lord, if he is aggrieved by the petition respondent number 7, then, my lord, the remedy is there. And kindly sees, my lord, my learned senior has been saying, my lord, because I've learned everything from him in the morning only, he was telling me. So, my lord,
I said, my lord, everyone who appears against me comes and says whatever they submit, they say, no, we have learned this from him.
I can, my lord, I can, my lord, say this.
That example.
No, I can, my lord, say this with, my lord, some right, because I actually learned it from him. So, my lord, I can take that pleasure. My lord, kindly sees 406 once, my lord. My lord, 206, my lord. Sorry, my lord. My lord, kindly sees this investigation that is being, my lord, shown. This is of a different kind altogether. This is not with regard to, my lord, striking off or anything, my lord. Kindly takes 206 once.
That Mr. Banerjee took a chance.
Huh?
Anyway, Mr. Shatarup Banerjee, please point out to me.
Power to call for information, inspect records and conduct inquiries where on a scrutiny of any document filed by a company or any information received by him, the registrar is of the opinion that any further information or explanation or any further documents relating to the company is necessary, he may by a written notice require the company to furnish writing such information or explanation to produce such documents. This has got nothing to do with striking off. Nothing to do with striking off, my lord. The entire provisions here. And, my lord, rightly, my lord, here also 213 will come into play. Even, my lord, here, he has got a remedy. My lord, kindly reads, my lord, 213A along with, my lord, B. The tribunal may, on an application made by not less than, my lord, 100 number of shares, my lord, now, my lord, B. On an application made by it, by any person, or otherwise, if it is satisfied that there are circumstances suggesting that the business of the company has been conducted with an intent to defraud the creditors, members.
So 200 into 2, 200 applications under section 213 and 200 appeals. No, not yet 200.
Not necessarily. Not necessarily. My learned friend has filed, junior friend has filed one there with all in one application.
How will I find those companies don't exist?
So therefore, my lord,
if
he, I am on his prayer. I am on his prayer. His prayer is respondent number 7. So respondent number 7, my lord, has been allowed. So he is aggrieved. Prayer is 7. Let me, my lord, go by the prayer. I will not say anything beyond the prayer. Prayer is 7. So, my lord, if he is aggrieved, My lord, 213B1 applies. It applies to him. Now, my lord, kindly sees the Bombay writ. This is very interesting. My lord, he has enclosed a copy of the Bombay writ petition, my lord, which is at page 381, which was filed in the criminal appellate jurisdiction, writ petition 226. Now, my lord, kindly comes to the parties at page 383. My lord, kindly sees government and also my lord, Crescenda, such and such solutions. The petitioner has made this application.
Yes.
State of Maharashtra through Inspector in Charge Economic Offense. So that's the wing which should look into. Then, my lord, State of Maharashtra through Ministry of Corporate Affairs, having its office at Nizam Palace, Kolkata. So, my lord, made a party, although, my lord, I don't know, State of Maharashtra through Ministry of Corporate Nizam Palace, how I don't know. But anyway, Regional Director, SEBI, Stock Exchange, Bombay Stock Exchange, Central Depository, National Security Deposit. They are not parties here. And this, my lord, I don't know, now they are saying that they have withdrawn this petition. They could have proceeded with this petition and kindly sees the prayer here. There is no reason to withdraw it. Read petition. Kindly sees the prayer at page, my lord, 394. And this honorable court may be pleased to issue appropriate writ, order and direction directing the respondent number 1 and or either of the respondents to carry out necessary inquiry and investigation in the respect of various complaints made by the petitioner. Same what is being submitted here now. A compilation in respect thereof is being tendered separately before the... So this prayer, they could have pressed it there.
Have you annexed a copy of the withdrawal order, Mr. Banerjee?
No, my lord, it is here.
It is there? Yes.
It is there.
And kindly sees the withdrawal order once.
Yes.
15th of July, my lord, they have filed the petition. 24th, they have withdrawn it. My lord, kindly sees the withdrawal order. Petitioner seeks to leave to withdraw the petition and having regard to ambiguity in the prayers, with liberty to file a fresh petition seeking the same relief. So it's just a chance, my lord, from Bombay to travel back to Kolkata and ask for it. Prayer is, my lord, lordship is seeing it. He is seeking for the same prayer here. Investigation against the inquiry and investigation in respect of complaints made by the petitioner against all respondents. I am also a party there.
There was ambiguity in the prayer.
Yes, ambiguity is that, my lord, Maharashtra Nizam Palace address, I can understand.
How can
the ambiguity that
rest
can
of
be
companies
corrected.
Maharashtra will have
That can be
jurisdiction over
corrected.
Indian
That can be corrected.
over companies will not in West Bengal. That is why my lord
And
it was withdrawn.
my lord kindly sees, my lord, Mr. Banerjee is saying this, kindly sees the withdrawal order once. Having regard to ambiguity in the prayers, doesn't say cause title. Prayers. Prayers, there is no ambiguity. And my lord, moreover, ambiguity, file it before the same court. Why travel to Calcutta and file it? I don't understand why travel to Calcutta and file it. And my lord, be that as it may, my lord, he is asking for a roving inquiry by the ROC which has got no powers. My lord, kindly sees 206 does not give those powers, my lord. And my lord, kindly takes 248 once. My lord, what am I to do for striking off? It's a simple procedure where the registrar has reasonable
Mr.
clause.
Banerjee is saying probably post facto, post striking off. They're dealing with the shares and all these things.
Yes.
So they are functioning after the striking out.
Therefore, my lord, who is to look after it? This not the ROC, but the SABY.
Mr.
SABY
Banerjee
will look
probably
after
cited also 2064 on that.
Yes.
The 2064 gives you the power to look into this.
My lord, 2064,
section 2064.
kindly takes 2064,
Yes.
my lord.
The scenario is they have been struck off. After the striking off, they are doing this illegal activity.
Yes.
So whether you have power under 2064.
My lord, kindly takes 2064 if the registrar is satisfied on the basis of information available with or furnished to him or a representation made to him by any person that the business of the company has been carried on for a fraudulent or unlawful purpose and not in accordance with compliance with the provisions of this act. If the grievances of the investors are not being addressed,
Or if the
or if the grievances of the investors are not being addressed,
So
the
they are covered
registrar
by the
may.
first part, Mr. Banerjee. They
Yes.
can say that they are covered by the first part. This is a representation made by any person that the business of the company, the shell companies, are being carried on for a fraudulent or unlawful purpose or contrary to the act, which
This is for active companies.
apparently yes, but why
This
can't
is for active. No, no, my lord, this is for active companies, not for striked off companies. Striked off, my lord, comes under 248. My lord, these are, my lord, to be very frank, my lord, these are dissolved companies under 250. 248.5. 248.5. Not, my lord, these companies which have been struck off. My lord, then, my lord, it's expanding the provision, my lord, which has been passed on the Companies Act.
So, Mr. Banerjee, according to you, who is the investigating authority? The parties who are imputed
Well,
to the Bombay court, apart from the
Ministry of Finance and SEBI, not ROC. ROC's work is, my lord, restricted under the provisions. There is, my lord, he can complain and my lord, they will obviously have to look into it. It's not that he's remediless.
That's exactly what's happening.
It is not ROC, my lord. Of course, SEBI can look into it. Ministry of Corporate Affairs can look into it. It's not ROC which will look into it, my lord. Because, my lord, the powers under 4064, 2064, my lord, is that for dissolved companies, not for active companies. And, my lord, with regard to 248, I have a very limited scope. If he is not complying, I have to, my lord, strike him off. And, my lord, kindly see the prayer. My lord, this writ, I am going by this writ petition.
Yes.
Prayer is very simple against respondent number 7. Respondent number 7, there is an order passed, he has enclosed it. My lord, he has a remedy, he can go before, my lord, the appellate tribunal under 241. Any person, the word is any person. He has a locus. Any person can go before it. And, my lord, if lordship wants, I can file an affidavit. If lordship wants, my lord, I can file an affidavit. But, my lord, there is no prayer for an interim measure here. 241 is very clear. When any person
will say the same things because you don't have any.
Yes,
report
because
to
I
file.
don't have. I will go by the provisions.
You're going by the law.
Provisions. There is nothing on facts, my lord, because the facts, as I showed, my lord, this is a classic case, my lord, of offloading of shares, which, my lord, ROC doesn't have anything to say, my lord. I'm not going to enter into it, my lord, because that's something he has to complain and he knows where to complain.
Let me have some. Yes,
Yes,
yes, Mr. Banerjee, any reply?
Yes, straight away, this. First of all, so far as the writ is concerned, the state of Maharashtra with the Nizam Palace address will not work because only the register of companies, Calcutta.
You could have amended the cost title.
No, I have to get the register of company because the companies are registered here.
Right.
So I cannot go somewhere else and ask for investigation. If they were Maharashtra registered companies, yes.
True, yes.
I can only come here to have them registered, whoever is registered here. That's one. Second of all, section 213 is not relating to this. It relates to an affairs of a company which is carrying on business. And someone can complain about me. 213 is very clear on that. It's an investigation into the affairs of a company which is already there. 213. 206 doesn't have that limitation.
That applies probably to the entire chapter. Chapter 16.
No, here
companies which are operating.
Yes, but here, what we are on is the fact. What am I aggrieved by?
What is the distinction between 213 and 206 on that? On your present argument?
206.
That this is 213 is regarding operating the functional companies.
No, what I'm on, 213, when I apply.
Then it has to be entire chapter 16.
213, when I apply, I have to apply before the National Company Law Tribunal.
Yes, different forum.
No, I can't file against a non-existent company.
No.
Because when I file, it has to be in the matter of company petition number, in the matter of such and such. In the matter of XYZ company, ABC company. So the company has to be there.
Does the same apply to 206 also?
It doesn't. That's why I'm showing. Yes. 206 is an investigating power of the register of companies. What am I complaining of? My learned friend perhaps misunderstood why respondent number 7's name is there. I am aggrieved by the fact that after receiving all these complaints and after asking for the list of when the shares were sold in respect of all these companies, the register of companies gives a clean chit in the affidavit which he files before the National Company Law Tribunal for restoration of this company. I am aggrieved by that. I am aggrieved by the fact. I am not, my lord, I can't complain about the restoration before my lord. That, my lord, I am taking steps. I am complaining about the non-initiation of investigation, and particularly my learned friend says I have no power. Then how did he, my lord, issue page 316, 317? My lord, if I put my argument in a question form, he had started his investigation. He had written to Bombay Stock Exchange. I did not find, my lord, he's saying that, sorry, that letter is by mistake, and this I'm disowning that letter. It's a letter, my lord, by the Ministry of Corporate Affairs. And, my lord, it is not that, my lord, he will, my lord, conduct and conclude the investigation. His job starts by having a preliminary inquiry or investigation into these affairs to say, my lord, what will be the scope of the inquiry? To say, yes, I correct. And he had only struck off these 200 companies. He will say, yes, I find I had struck off these 200 companies in 2018, but it seems from the records that they have been trading from 218 to 222, or they were trading from 2022. And then give it to the central government to say that please inquire into this. And that is where I'm saying, the fraudulent trading has happened. He's understood the problem because he says, my complaint is with regard to dumping of shares. It is correct. And, my lord, I should have pointed out, my lord, those paragraphs where, my lord, I've given details as well. I've given details with regard to 3.64% has already been dealt with. And I fear that entire 34% is going to be dealt with. I must have, my lord, some remedy somewhere, because when I'm fighting, my lord, even before the National Company Law Tribunal, if the Registrar of Companies comes and says that, sorry, please restore if you want to, what do I say? I can't say anything. I can't then direct, my lord, or ask the National Company Law Tribunal in a 252 jurisdiction to say, no, you direct the Registrar of Companies now to investigate.
Why can't you say that?
I can't, because they don't have the power.
Who doesn't have the power?
The National Company Law Tribunal in a 252. I am here, my lord, on the question, my lord, a statutory dereliction according to me.
Under 252, it has to only see that whether the premise of striking off
Correct.
was correct.
And who will be hurt? The Registrar of Companies. He comes and says, yes, you please restore. All right. I can only come to the writ court to say, Registrar of Companies, my lord, there can't be any, my lord, question with regard to the Registrar of Companies under the jurisdiction of a writ court. If the writ court finds him to have not been doing his duty, then, my lord, at least an explanation can be called for. My complaints have still not been dealt with, my lord. I understand. They say, I'm sorry, we find that your complaints are all rubbish. We have looked into it. Sorry, none of this had happened. Because it's a serious issue.
Mr. Banerjee, can you please ask your learned, whoever is a junior Muslim,
yes,
just to give in a sheet of paper, just to write the page numbers where your complaints are annexed. Only
Yes.
those page numbers.
Very well.
Only that.
I have it, my lord. I'll just give it, my lord.
Just give me the page numbers where the complaints are annexed. I'll just look into the authorities and the nature of the complaint.
Very well. Very well, my lord. I have those pages, my lord. I will just make a formal. So, my lord,
This is an argument of law. I won't direct affidavits in this. I'll close it.
Very well, my lord. I, my lord,
With regard to those documents that Mr. Banerjee is relying upon, of course, my lord, that I have to give a reply, my lord, upon instructions from my client.
No, if actual inquiry is necessary,
I have to, my lord.
I'll have
because
to
I
give you a
can't
right.
take that burden on myself.
So, my lord, I'm
He's relying on those letters, my lord. Then I have.
I'm on the question.
No, not that.
I'm on
the question whether you have a
Power
scope
or
of a
not.
power or
Yes.
not. A scope.
My lord, someone must have, my lord, that power. Because, my lord, why have I come here? My lord, because the jurisdiction, my lord, of the struck off companies is under you. You in 2018 have struck off these companies. Now, you, when you go back and oppose, instead of opposing the restoration, you give them clean chits, so to say. And whereas you have received my complaints, and in the complaint, one of the complaints, at least you have taken step by asking for the details with regard to the share sale.
Mr. Banerjee, there are two aspects of this.
Yes, my lord.
Either the ROC may initiate an investigation.
Yes.
At its own behest, only
Yes.
on your application.
Yes.
Maybe. Or an investigative agency or some other agency initiates an investigation. There, if they seek for some information from the ROC, that can always be given by the ROC if it is within their means.
My lord, here the
you are directing the ROC to start the investigation,
Because-
whether they have the power to do so.
my lord, that's why I'm sure, my lord,
The alternative is always there. Some other
Yes,
investigating agency
yes.
does it and directs the ROC or seeks an information from there. That is always there.
my lord, the ROC also recognizes its power because it asked the Bombay Stock Exchange to give them details.
No, their writing for details, Mr. Banerjee, itself probably does not confer any jurisdiction on them, which they don't have in law.
My lord, 316, my lord, is very
They
clear.
self-arrogated I mean, prerogative to write a
My
letter.
lord, kindly, my lord,
Or
then-
maybe acting on your application, they did it.
My lord,
That does not give them any power to continue the investigation or conduct an investigation.
my lord,
Unless they have it in law,
my
definitely.
lord, 206, my lord, I thought, my lord, was
206, yeah, definitely.
that's, my lord, kindly consider that.
4 is also there.
Yes.
Anything except 213.
No, 213, my lord, my lord, 213, my lord, is a
So
different.
you said that's a different.
Yes, my lord, it is a different section. Because, my lord, what happens in 213, my lord, lot of my shareholders, my lord, comes and either complain, shareholders or any person. Or any person. And we have, my lord, company petitions like that, where, my lord, complaints have been made under 213 with regard to investigation of a company, my lord, which is carrying on business, basically.
My shareholder can come against me.
So, my lord, here, my lord, 206, my lord, we thought, my lord, that the register, my lord, will investigate into something if this is the power given into him. And here I am trying to link it. My lord, absolutely correct. My lord says, why not some other? Yes. But the question is whether he can also or not.
Yes.
It can't be, my lord, that today, my lord, the registrar will say, I have power, but you say you investigate.
No, definitely. They also have power.
Yes,
Definitely
yes,
they have asked
I'm
for
on
the
that.
direction. Why not give
So,
that?
my lord, it's no answer by my learned friend to say, oh, I don't have the power, but someone else will have the power. I'm saying you also have the power. Because at your instance, this got struck off. And they're carrying on business. So, my lord, he can look into, my lord, the records of, my lord, the registrar to see, my lord, when struck off and what is, my lord, their activity they are carrying on. My lord, this 206, my lord, kindly consider that. And, my lord, we'll give those, my lord, complaint, my lord, pages. I'm grateful, my lord. I'm sorry, my lord, though, my lord, did say, my lord, constitutional issues, but I don't think, my lord, it really, my lord, involves that.
Learned Senior Counsel, heard Learned Counsel for the parties, full stop. The plinth of the submissions of the petitioner is that the petitioners seek an investigation into the allegedly unlawful and illegal functioning of certain struck-off companies, who were shareholders of the petitioner company. Full stop, next para. The premise of the defense of the registrar of companies is, primarily that the registrar of companies does not have any jurisdiction or authority to initiate any such investigation. Full stop. Heard, hearing is concluded. Line add kore din. Since the court does not invite the parties to enter, since the court does not choose to enter into a factual disputes raised by the petitioner, no affidavits are being directed to be filed. Full stop. The entire gamut of the consideration in the present matter is revolves around legal questions. Full stop. As such, hearing is concluded and judgment is reserved in the matter.
Grateful. Grateful. Good. Extremely.
Thank you. এটাও পাঠিয়ে দাও। সব ছেড়ে judgment দিয়ে দাও। মাধববাবু আপনাকে ডেকে নিয়ে অর্ডার গুলো দেবো। পল্লব তেনালে সুইসাইড করবে।
তো ফিক্স করে নিচ্ছি। ফিক্স করা ম্যাটার আছে না না আইটেম 22 থাকে না না হবে না এটা পিছন তলায় yes it should be listed
So what is this?
Before my lord takes up any original side matter regarding item number 22, that particular matter which
Item number 20?
22. My lord, I have taken leave on the last occasion, liberty given to me to file afresh.
But I'm for the depend this one number 7, 8 and asset reconstruction. I don't know what is the urgency. He's asking for cancellation of a license of an asset reconstruction company. What force document? 20 years. His father was party to the document.
What are you asking that now?
Why so precedence to this matter? There is no the fraud committed by father was 20 years ago. He had duped the banks and taken money. What is the urgency? There is no urgency.
It has been found out already. The documents have been forged on the basis.
No, it is not.
No, I'm not on the merits.
Clear.
I'm definitely not on the merits, Mr. Bush. I'm not going into the merits. But what is your urgency in the matter? Why can't it wait for some other time? Yes.
Well, I'm not proceeding. It was settled. Where recovery? I've not taken any.
No, it has been included in the list. No upgradation.
There is no urgency.
My lord, extreme urgency, my lord.
There are several other urgent matters also. I am not upgrading any matter. So, almost any matter. I did not upgrade any matter yesterday also, day before yesterday. This week I'm not upgrading any matter. It's not possible unnecessarily. I cannot do it.
Hello, I
Sorry,
will get down to the list, bottom of the.
Well, item number 13, my lord.
Same
Very
answer.
urgent, my lord.
Same
The
answer.
electric connection, my lord. of the
Sorry, no.
petitioner.
Original side, please call the list. Yes.
Any mentioning on original side?
No.
Calling original side, this list item number 1, contempt matter Ashu Dhar versus Santosh
On
Kumar.
12th of July, Lordship has been pleased to direct me to serve upon the alleged contempt. Lordship, it was received by the alleged contempt on
Yes.
14th of
What is the act of contempt, Alice?
Lordship, kindly come to the my Lordship's brief.
Yes.
Kindly come to page number 14, annexure A of your Lordship's brief. Lordship has been pleased to direct the respondent bank to hand over the actual sale consideration along with up-to-date interest by 30th of June 2023.
Has anything come to your knowledge to show that they have filed an appeal or anything?
No.
আপনার কাছে রুলের ফরম্যাট আছে? রুল ইস্যু হয় কন্টেম্পটের রুল? তাহলে আমার অ্যাপিলেট সাইডের যারা আছে তাদের কাছে নিয়ে নেবে, একটু রুল একটা ফরম্যাট আছে। অরিজিনাল সাইডে আলাদা হয় কিনা আমার কোনো আইডিয়া নেই, মোস্ট প্রবলি হয় না। কন্টেম্পট তো আলাদা জুরিসডিকশন, তো আপনি একবার দেখে নেবেন রুলের কপি ওদের কাছে। Despite service of a copy of the contempt application, none appears for the alleged contemptor. Full stop.
I'm preparing.
Why didn't you appear so long? Yes, what is your stand in the matter? Why are you not disbursing?
Lordship, we have already, we intended to.
Please use the microphone. Yes.
We intend to pay the entire amount as your lordship has stated. There are two components to this. First component is the principal amount, which we were ready and willing to pay at that point of time. The draft is also has been accompanied by. I'm here and now paying the interest, the principal component. The interest component, there is a little bit of it's fault on our part. It's we are making the calculations and all. Within a very short period of time, we'll be able to pay the interest part also.
I'll keep it next week. Today, pay that handover. Please do that. Yes. I'll keep it next week for the interest. Yes.
If some amount of compensation should be awarded to the, I leave it to Lordship.
Lordship.
Yes. Hand it over to a learned friend. Yes. I'll record it in my order. Thank you. Yes. Pursuant to prior service, learned counsel appearing for the contemptor, alleged contemptor appears in court and submits that the alleged contemptor has come prepared with a. This is a bank draft, or
yes, your lordship.
With a bank draft for the amount covering the principal, which is due to the petitioner in terms of the order of this court. Full stop. The said draft is, pursuant to the direction of court, handed over to learned counsel appearing for the petitioner for being forwarded to the petitioner. Full stop. Next para. As regards the interest component, learned counsel for the alleged contemptor submits that there was an error on the part of the alleged contemptor in calculating the exact rate of interest. Full stop. However, the interest component shall also be cleared off at the earliest. Full stop. Next para. In order to enable the alleged contemptor to pay the interest component as well to the petitioner, the matter is adjourned till August. When should I keep it? 3rd August? 1 week?
Lordship, 5th, Friday, next Friday, if your lordship.
Next Friday is 4th. Very well. Till August 4, 2023. Full stop. Next para. On the said returnable date, the alleged contemptor, through counsel, shall hand over the interest component by way of a further bank draft to the learned advocate appearing for the petitioner for being further forwarded to the petitioner. Full stop. Next para. Please come back on that date. I'll thank you so much. Yes.
IT paper na bichis. Item number 2, Madhumita Construction Private Limited.
This matter, I appear for the respondent State Bank of India.
Yes.
The grievances are substantial against me. I have been briefed this morning. I request some instructions.
Mr. Pan is with you.
No,
I am for the petition.
Uy.
This is my affidavit of service.
Where you left it? When should I keep it?
any day next week, any day.
The only problem is this, my lord, that my grievance is against the uploading my name in the central fraud registry. Result where my lord.
Mr. Pan, let him take instruction, come back next week. Let us
Okay.
see if it can be resolved. Yes.
My lord, retain this position, my lord, on Monday.
Original said not too many matters. Learned counsel, the affidavit of service filed today be kept on record. Full stop on the prayer of learned counsel for the bank. Which bank?
State Bank of India.
Learned counsel for the State Bank of India, that is respondent number 3, comma. The matter is adjourned till August 2, 2023, when it will be listed fairly at the top of the list.
Great.
Fairly at the top of the list, position as well. Thank you.
Item number 3, OTB Industries Company Limited versus Indian Bank.
Yes, Mr. Dutt.
My lord, kindly pass over this matter. I am for the respondent bank.
You had to continue or you had finished?
No, my lord, this is a new matter, my
Oh,
lord.
this.
Yes, my lord.
Yes.
On behalf of the Indian bank, my lord, kindly pass over the matter.
No, Passover. Passover means nothing. Then I'll take it up tomorrow.
The sale is fixed on 20, day after tomorrow.
Day after tomorrow.
Morning, 11:30. Online sale, your lordship.
No, it's risky. Let him start the matter.
Okay, my lord.
Yes, thank you. Yes, Mr. Yeah.
My lord, the impute notice, my lord, is at page 50.
Yes.
My lord,
You are the borrower, Mr.
yes, my lord, I am the borrower. My principal grievance is this, my lord, the 13-2 notice which says that I have become on NPA on a particular date, my lord. Against that, my lord, I have given an answer to the under 13.3a, where I have indicated that your marking my account as an NPA is in violation of the circulars that were pending, that were floated by the Reserve Bank of India during the COVID times, my lord. It gets hit by the circular straight away. Well, they give a reply, and thereafter, my lord, they don't deal with that. Generally they don't. And thereafter, my lord, the next step they take is this one. And this sale, proposed sale, is on the basis of that declaration of NPA.
Their arguments are over, ma'am.
Actually, Mr. Prusti is on the leg on the just. That's why I'm.
Don't sell the
seeking
property,
for-
give an undertaking to the court that it will not be sold day after tomorrow.
No, without his instruction, I could not say anything, my lord.
Tomorrow, then first matter in the original site, Mr.
Yes, obliged, my lord. Obliged, my lord.
On the prayer of the bank, the matter is adjourned for the day. Full stop. The same will be listed tomorrow at the top of the list of the original site.
Obliged, my lord.
With liberty to mention, because Mr. Bordon is apprehensive of in case
3 o'clock, my lord might have other benches as well.
Yes, I may have other benches. You may have from 2 p.m. there may be something else. Yes.
Because the day after tomorrow, same 11:30 in the morning.
Let us see what happens tomorrow. Tomorrow is another day.
And then we have a liberty to mention in the morning.
Liberty is always there.
No, liberty can't exercise. Has to
After fixing it at the top tomorrow, can I give a liberty, Mr. Bottom? There is no scope of giving any further liberty.
That's what it be understood. In the evening,
Unless it's like Justice Mitra's liberty. Yes.
For hearing item number
What's
4.
that liberty? My lord?
That liberty is above my name. Justice N.K. Mitra.
For hearing item number 4.
Yes.
Deepak Kejriwal.
Yes,
for the state.
respondent.
Lordship, for the petitioner.
I was addressing your lordship now.
Yes.
Lord, I had not submitted. Lord, my first point was that option for renewal has to be consistent with the contract between the parties. That means the lease which has expired. There was a 15-year lease which had a renewal clause. And that renewal clause was to the effect that the lessee will have a right of renewal for the next 15 years, but on terms and conditions to be agreed between the parties. This was the renewal clause. And Lord, the renewal, according to the renewal clause, the parties had to negotiate and come to a settlement. This settlement did not take place because Lord, there were proposal and counter proposals, but no finality with regard to the terms and conditions as regards the rent payable by the parties, that means the lessee, that could not be arrived at. Now, Lord, I had also, Lord, referred to the 2009 judgment, 2009 volume 14, SCC page 451.
Yes.
For the proposition that this enforcement of contract should be, Lord, based on the agreement between the parties. And Lord, I had also cited this, Lord, I had relied upon paragraph 30-31,
yes,
especially, and Lord, also paragraph 39 onwards to say that a mere recommendation between the parties is not binding. And if the parties are not ad idem, that is the end of the negotiation. Then, Lord, they will have to take steps in accordance with law, serve notice of eviction or whatever. And Lord, I had also said that, Lord, this property is governed by the West Bengal, Lord, the Tenancy Regulation Act 1976. I have also handed over, Lord, a judgment, Lord, 2020 volume 17,
yes,
Sona Promoters case, where, Lord, this corporation's property has been held to be, will be governed by the West Bengal Government Premises Tenancy Regulation Act 1976, insofar as the constructed properties are concerned. But so far, if it is vacant land, then it will be guided by that 1962 Act. Now, Lord, with this, Lord, I was just dealing with the valuer's report. Because, Lord, there is one valuer's report which is annexed by them in the writ petition. And, Lord, I have also, Lord, disclosed, Lord, a valuer's report. So far as their valuer's report is concerned, I had shown to your lordships, if you, my lord, kindly come to their valuer's report, Manibroto Mukherjee, that is, my lord, starts at page 105 of the writ petition.
Yes.
Lord, I had shown to your lordships, Lord, I had taken your lordships through the this report. What the valuer has done, please come to page 108.
Yes.
Valuer, Lord, has recorded that, Lord, the area that is occupied is about 3,716 square feet. Has your lordship found that?
Yes.
And, Lord, the rent he is paying is 59,917. That is the next paragraph.
Right.
So, Lord, I have said that if this rent is divided by 3,716 square feet, it comes to about 16.12 per square feet. And, Lord, he has assessed the rent at 12.74. That's the next paragraph. Your lordships will find that he has assessed the rent which is lesser than the rent that they are paying. This is, Lord, absolutely, Lord, he has proceeded. If your lordships your lordship will find from the report that there is no basis. He just says, I would judiciously consider an increase of the monthly lease rent by 10% over the existing monthly lease rent of 11.58. I don't know where he gets this 11.58 because, Lord, his area that the tenant is occupying is, Lord, 3716. It was originally 4865. Part of it they had surrendered, and 3716 square feet they are occupying. Then they are paying the rent of 59,000 and all. So, Lord, it is actually bringing down the rent. 12.74. What he has done is the original rent was on that 4865 square feet.
Yes.
He has taken that as 11.58. But, Lord, 11.58 was never the agreed rent. Even today, it is not the agreed rent. So they are paying 16 rupees per square feet. Now, my lord, the other aspect of the matter is that insofar as the valuer's report of the corporation is concerned, the lordships may kindly, my lord, take the reply, because I was, they have also annexed it. I have annexed it in the opposition. They have also, my lord, annexed it in reply. And in fact, your lordships were marking the pages from the reply. This is, my lord, a firm called RM Engineers. Page 75 onwards, the report starts. Lord, I had taken your lordships through the report. If my lord kindly comes to page kindly give me 1 minute. Page, Lord, page 80. Page 80. If your lordships, Lord, your lordships will find the various components, Lord, which are taken note of by the value. First, your lordships will find guideline rate of the registry office. If your lordship sees on the left-hand side.
Yes, got it.
Yes. Your lordships will find that he has analyzed the various aspects. Then he says assessed adopted rate of valuation. And then, Lord, land value of the estate as per prevailing market rate. Then he says composite rate of building space as per prevailing market rate. And this he finds on the ground floor, Lord, he finds a certain rate. Then he says that above rates are obtained from government website, so and so registration.gov.in. This is, Lord, registration office website. Then, Lord, he says composite rate of building space for similar properties. This is what is considered. Then he says rental rate prevailing in the area as per market rate. This is, Lord, he takes from Magic Bricks. This is from Magic Bricks. But, Lord, he has also taken from the government website. That registration of his website is taken, Magic Brick is also taken. Then, Lord, he says rental rate prevailing in the area. He says the prevailing market rate in the vicinity and in other buildings as per month varies from 60 to rupees 100 per square feet. Depending on the floor location of the unit, air conditioning, lift, and other facilities like parking, upkeep, maintenance, decoration, specifications, common spaces. Then, Lord, please turn the page. He says, kindly see the second column. Therefore, it may be concluded that rupees 12,000 is per square feet rate for similar properties for shop unit and 10,750 per square feet for godown, semi-commercial office unit in upper floors, so and so. Medium separate for setting up small business. This is, Lord, for 99 years. Then, Lord, he goes into the other aspects of the matter, and your lordships will find that he's taken, if your lordships, Lord, come down to the third last column, says for the first floor, they are in the first floor. First floor, therefore, 10,750 equal to annual net income, ANI, that is 8% rate of return for 99 years. And 8% he has taken for 50 years, 30 years, and also 15 years. 15 years is next year. So, Lord, what is happened is that, Lord, he has taken the valuation. This is the value. And then, Lord, return, he has fixed at 8%. And that is how he has arrived at, say, 74 rupees per square feet. That your lordships will find from page 82. Yes. So, Lord, I am restricting myself to 15 years and, Lord, also the first floor. I am not taking your lordships through the other assessment. So, Lord, because they are on the first floor. So, 72 rupees he has fixed on the basis of various data. He has collected from various authorities, including the market rate. He has collected, Lord, from the local authorities. He's taken it from the West Bengal government website. He has taken it from Magic Brick. And ultimately, Lord, he has assessed at 8% as the return. And, Lord, that's how the rate has been fixed at 72 rupees per square feet. Now, my lord, once this valuation was done, there is a valuation committee of the West Bengal Small Industries Development Corporation, because, my lord, they have real estates, my lord, all over the state of West Bengal, which they let out for industrial purpose, office purpose, respectively. So, my lord, this was placed before the valuation committee. Now, my lord, your lordships may kindly take the affidavit in opposition once. Please come to page 30, which is the minutes of the meeting of 5th of May 2022. At the top, your lordships will find the date.
Yes.
And kindly see, Lord, just above the table, the valuation committee gone through the valuation reports of, your lordships may kindly mark the Shilpo Bhavan. We are only concerned with the Shilpo Bhavan. And Lord, second column, second entry is the Shilpo Bhavan. This is, Lord, kindly, Lord, take the rate for 15 years. That is 72 rupees per square feet per monthly rent.
Your property, this property is in industrial park, in the industrial park.
No, it is Shilpo Bhavan, Lord.
Loan itself.
It's a floor. I mean, it's a constructed property. Right. The West Bengal Small Industries Development Corporation has their offices in the same building at the top floor.
Right.
There, I think 2 or 3 floors are let out. One of the office space is let out to the writ petition.
Right.
It is in Blackburn Lane. It is just just behind the
court and all, in
yes,
the middle
yes,
somewhere. Yes.
yes. It is actually it is in the middle of Poddar Court, between Poddar Court and Lord, the next to Lal Bazaar after crossing.
Right.
That is the area. So, Lord, this is first, Lord, the valuation committee goes through it, and valuation committee accepts this. Then, Lord, this is accepted by the board of directors. Kindly, Lord, come to page 33. This is the meeting of the board of directors. Kindly, Lord, see the 22nd July 2022 is the date. And Lord, the page 34, agenda item. Agenda item number 24. Kindly, Lord, turn the
court. Which court? Yes. 33, 34, yes. 32, 30 and 34, respectively, the valuation committee and the board of directors.
Board of directors, ultimately, my lord, board of directors accepts this. Now, my lord, this is the exercise that has been done by the corporation to arrive at a reasonable rate. Now, my lord, what had happened is that their lease had expired, my lord, sometimes in 2015. 2018. And Lord, from 2018 to 2022, Lord, they could not come to terms. In the meantime, the SIDC has continued to accept the rent because they have not disturbed the tenancy as such. But Lord, the attempt was to come to a negotiated settlement which failed. Now, issue is that, Lord, they have moved the court at this juncture. The offer was that 72 rupees, which is not acceptable to them. Now, Lord, they have moved this court, and Lord, kindly see the prayers that is made in the writ petition. This 1st January 2023 is the letter. I must, Lord, show your lordships this 31st January 2023 letter. This is, Lord, at page
71.
Yes, this is at 104, page 104. Page 104. Where, Lord, the offer was that you have to pay 72 rupees and deposit, Lord, some security deposit. This is the letter. Page 104 is the letter. So they are seeking, Lord, a mandamus by which, Lord, this letter should be set aside. So today, my lord, the issue before your lordship is what should be the fair rent?
Mr. Kaur, theoretically, if their writ petition fails, then also you have to take out a proceeding under the government
Yes,
of.
yes.
Very good.
That 76, I have to, my lord, first terminate the tenancy.
Yes,
Because, my lord, they are actually, my lord, they are in holding over because 116 it gives them the protection. I have to first, my lord, terminate the tenancy and then, my lord, initiate proceedings under the 76 Act. That is, I can't just lock, stock and barrel throw them out. So, my lord, that proceedings I have to take. There is no difficulty.
There was a warning. There was a warning in your in a component item 5 of page 104,
Yes.
which says you will have to surrender. So this is not the termination.
This is
Cannot
not-
be
this
because
is-
the negotiations.
this
This is the finality of the.
Absolutely.
Very-
This is not after, not because I tell your lordship, we were not finding a basis because they were suggesting lower rent than the existing rent. They had sent a letter giving a schedule of rent, which was not acceptable to the West Bengal Small Industries Development Corporation. At the same time, Lord, we could not offer them a figure which was wholly irrational. Therefore, Lord, this exercise had to be taken. And in the process, Lord, 4 years have gone by. COVID time was there. So 4 years have gone by. And now, once we have got the figure, then, Lord, we have offered.
Definitely, yes.
And, Lord, I have also shown that renewal means grant of a fresh lease. I have cited a judgment, Lord, I think 2015 volume 8 SCC.
Right.
They have, Lord, this judgment was cited by me.
Yes.
This is there's a distinction between extension of lease and grant of a fresh lease.
Right.
The contract between the parties is for grant of a fresh lease. So therefore, Lord, I mean renewal. So
Renewal.
renewal means, Lord, grant of a fresh lease. Therefore, Lord, what is said that you'll have to surrender your original lease document in respect of commercial complex. You'll have to execute and register the lease deed with effect from 11th August 2022. Lord, if they don't agree to execute it from 11th August 2022, Lord, I have to look forward. I just can't, Lord, go behind because I have accepted rent for this period. Therefore, I cannot insist that he has. So if there is meeting of mind, that's another thing. That's another question. So, Lord, this is not the termination letter at all. This is what I wanted to tell your lordship, that parties were negotiating. So therefore, there is no question of any termination. We have not yet taken any steps with regard to termination. Now, my lord, with this background, Lord, that I have already, my lord, covered in that 2015 volume 8, that even if I accept rent, post expiry, it's at the highest a case of holding over. And that holding over, my lord, I can terminate. It's not that I have created any right in so far as the, and after all, this is governed either by the West Bengal Government Premises Tenancy Regulation Act 1976, it is. And my lord, lease, so far as the lease is concerned, that is under the Transfer of Property Act. So, my lord, there is no question of any statutory tenancy coming in. And in any event, the rent that they are paying is above, my lord, 10,000. So there's no question of statutory tenancy.
Yes.
Now, my lord, only, my lord, I raise the point with regard to the judicial review. Because, my lord, this is a commercial contract.
Yes.
This is a commercial contract. They are given, my lord, a commercial space for the purpose of carrying out their activities, which is a commercial activity. They are having their office, and, my lord, they are also doing some commercial activity at the place. Now, the issue is that the terms and conditions are governed by a contract. So, my lord, whether, my lord, a writ petition should lie in such circumstances, and what are the parameters, even if it lies. My lord, I concede to this effect that if an action is palpably hit by Article 14, it would lie. I don't shy away, and I don't say a blanket argument. I don't put forward that under no circumstances, because if your lordship finds that there is a violation of Article 14,
It's a small window actually, Malaf. It is
very small,
arbitrariness, section 14.
very small
Yes,
window.
right.
Otherwise, it's a hands-off approach. Basically, Lord, it's not that the writ court doesn't have jurisdiction. Writ court has every jurisdiction, but Lord, normally the issue is left open for the parties to pursue in an appropriate fora. Because, Lord, whether the assessment of rent made by the valuers is proper or improper, and what would be the fair rent, what would be the return on the investment. These are issues, my lord, I don't think writ court should at all, my lord, endeavor to go into. Now, my lord, in so far as that judgment is concerned, that Joshi technology, my lord, your lordships must have dealt with it many a times. 2015, volume 7, SCC 728. Lord, I just give your lordships the paragraph.
Yes, please.
Paragraphs 55, 56, 61, 68, 69, and 70. These are the paragraphs, my lord, I want to rely on. May I take your lordship straight to paragraph 55 first? The law in this aspect has developed through catena of judgments of this court, and from the reading of these judgments, it would follow that in pure contractual matters, the extraordinary remedy of writ under Article 226 or Article 32 of the Constitution cannot be invoked. However, in a limited sphere, such remedies are available only when the non-government contracting party is able to demonstrate that it is a public law remedy which such party seeks to invoke in contradistinction to the private law remedy simpliciter under the contract. Some of the case laws to bring home these cardinal principles is taken note of hereinafter. Then Lord Sadguru and all these judgments kindly come to paragraph 61. A preliminary objection was taken by the appellant to the maintainability of the writ petition on the ground that claim of the respondent flows from the terms of the lease, and such contractual rights and obligations can only be enforced in a civil court. This preliminary objection was overruled by the High Court, which proceeds to hear the matter and allowed the writ petition of the respondent company. In appeal by the appellant to this court, the decision of the High Court was reversed, holding the writ was not maintainable. The following observations may be useful by quoted in Vishwanath T. So and so. Then, Lord, I skip this because I'm sure, Lord, this judgment has been placed before your lordship. Kindly, my lord, come to paragraph 69 and 70. The position thus summarized in the aforesaid principle has to be understood in the context of discussion and preceded with which we have pointed out above. As per this, no doubt, there is no absolute bar to the maintainability of the writ petition even in contractual matters, where there are disputed questions of fact or even when monetary claim is raised. At the same time, discretion lies with the High Court, which under certain circumstances it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise such a discretion. Then, Lord, the circumstances are mentioned. Your lordships may kindly come to paragraph 70. Further, the legal position which emerges from various judgments of this court dealing with different situations, aspects, and relating to contracts entered into by state, public authority with private parties can be summarized as under. Lord, kindly see 70.6. Ordinarily, where a breach of contract is complained of, the party complaining of such breach may sue for specific performance of the contract if contract is capable of being specifically performed. Otherwise, the party may sue for damages. These are not the well-known principles. I don't have to take your lordship. But Lord, what I wanted to show to your lordship is this, that there is no violation of any right so far as the petitioners are concerned. Article 14 is not, Lord, open to them to take. After all, this is arising out of a contractual dispute. And Lord, I have tried, Lord, my level best. I means, Lord, the respondent has tried their level best to bring about a agreed, Lord, figure in the matter. And that is the reason why it has taken, Lord, about 3-4 years, initially by negotiation, then, Lord, on the process of valuation. Okay. And Lord, after valuation, this figure has been fixed. Whether the valuer has taken the correct measure or not, that can come out in the cross-examination or, Lord, in the other process.
It is a fact, yes.
These are not, Lord, to be gone into in a writ petition. So these are my, Lord, humble submissions.
Yes, in reply.
Lordship, I'm being led by Mr. Rupak Ghosh in this matter. We'd take time on his grounds, his personal grounds, as he's on his legs, and perhaps come back
tomorrow.
next day.
Tomorrow. Hard in
Much
court,
obliged.
but for the hearing tomorrow, yes.
tomorrow, my lord, kindly excuse me in case, my lord, I
Yes,
can't
I'll just conclude the hearing of Mr. Ghosh and just
much of that.
Item number 5, Otibir Industries Company Limited versus SBI.
Lordship, I'm appearing for the respondent bank. I'm led by Mr. Joy Shah. I'm seeking for a short passover, Lordship.
no short possible. You start the matter.
Lordship, I'm debriefed in this matter. He's appearing senior counsel, Lordship. That ground.
Yes, Mr. Chair.
Can it be on Friday? Not
An adjournment is sought on behalf of the respondent. Let the matter stand adjourned till July 28, 2023, Friday.
Grateful, Lordship.
Item number 6, Alpha Stitchart Private Limited.
Please, Your Lordship.
Yes, Mr. Kar.
In this matter, I hope to come within the very small window of, my lord, arbitrariness of, my lord, the Small Industries Development Corporation. This matter has a checkered history, my lord.
Copies have been served.
Yes, yes. Ready for hearing, my lord. Affidavits are complete.
Right.
Matter has a checkered history, my lord. My predecessor in interest, Sona Industries, Sona Promoters was allotted a plot in this industrial park by the respondent number 1. The allotment was cancelled. It was unsuccessfully assailed till the Supreme Court by the respondent. Ultimately, the allotment was confirmed and Sona Promoters came. During this time, my lord, Sona Promoters entered into a scheme of amalgamation with the petitioner. The shareholders and directors of both these entities are common. There is no dispute on that. That Sona Promoters and they are the same group companies controlled by the same promoters. They entered into a scheme of amalgamation, pursuant to which, my lord, this leasehold interest of Sona Promoters stood transferred to the petitioner number 1. The petitioner number 1 applied to the respondent corporation for recording the name of the petitioner number 1 as the lessee in place and stead of Sona Promoters. The respondent, my lord, demanded a payment of 18 lakh rupees. Whereas the position, according to the respondent, is from the papers which have now come to light and which have been disclosed very fairly by the respondent, the position is that if it is a transfer by way of amalgamation between the same promoters, that is the entity, the human agency which controls these companies remains the same. That is the directors, shareholders remain the same. Then it will be a transfer, but it will be charged. The name change will be charged at 10,000 rupees. That is the policy of the respondent. Now it was rejected.
So you are piercing your own corporate veil and showing that.
Yes, and it is an admitted position because they sought these documents from me. Right. They sought these documents from me. Otherwise, right, they might have a right to reject.
Yes.
They might have a right to reject because it amounts to a transfer which I may or may not accept. I gave it to X, seeing Y behind X. Now I don't allow Z.
But they're accepting that.
They are accepting that. Now they wish to penalize me by charging 18 lakhs, which is payable only if there's a transfer of entity.
Third party.
If a third party right is created.
Right.
Now it seems, my lord, that the stand of the respondent that fees are chargeable at 18 lakhs and not 10,000 was pursuant to a legal opinion, which the respondent obtained. I sought copies of that opinion. I was not provided. Now, when this matter was initially taken up, it appears that the tenor of I'll take your lordship to the documents. I'm just giving an overview because this matter was heard earlier when directions were given. It seems that the tenor of the respondent's argument is that this transfer by amalgamation of lease is a transfer. And they perhaps seem to rely on General Radio versus Abdul Qadir and that line of Singer. They've not cited, but I would think that they would rely on Singer, General Radio, Cox and Kings, this whole line of Supreme Court decisions in the rent control legislation, which says that transfer of tenancy by way of amalgamation amounts to subletting. Therefore, the tenant, the transferee company is liable to be evicted. It ceases to be a tenancy. Now, those cases, yes, those cases may not apply in this case by reason of the respondent's own policy, that if the transfer is inter se two companies, by way of amalgamation, the transfer is inter se two companies which are in the same management and control, then the fee charged is only 10,000.
You are on the fees only.
I'm only on the fees.
Whatever may be the quality or nature of the transfer, I mean, you are on the fees.
That is immaterial, because general radio is correct. In it says that it is a
Yes,
transfer. Therefore, it is a ground for eviction, but we are
Transfer is not disputed.
It is not disputed. My right to transfer is not disputed, my lord. What is disputed is whether I am liable to pay 10,000 or I am liable to pay 18 lakhs. Now, my lord, the ground which was initially taken is that this is a transfer. Therefore, you are liable to pay 18 lakhs. Overlooking the own documents which they required from me to show that this is the same management and control. I gave all those documents. There's not a whisper that these documents are not correct, because these are, my lord, official records from the registrar of companies, and what they required was a chartered accountant certificate. They require a chartered accountant certificate that your chartered accountant has to satisfy, the statutory auditor has to satisfy. So, my lord,
The controlling interest is the same regarding that.
yes, that there is no controlling interest is the same. So, my lord, when I gave those documents, they don't come back saying that no, the controlling interest is not the same, therefore 18 lakhs. They say, no, this is a transfer, therefore 18 lakhs. Now, the stand taken in the opposition, now that the reason which was given then cannot stand. Now, the stand taken in the opposition is this, that no, if you had to take advantage of this 10,000 fee transfer, inter se the same ownership, then you ought to have applied for permission before entering into the amalgamation. This is now the new stand taken in the affidavit on opposition, which was.
We have to look into the clause. What is
We have to see the clause A, my lord, and there, my lord, I would submit respectfully that if this is the stand now taken, A, it was not a stand taken when the demand was raised. It was not a stand expressed at that day as being the decision which led to this charge on me of 18 lakhs. The demand was on the ground that this is a transfer, and therefore you have to pay 18 lakhs.
It's entirely on the interpretation, Mr. Thakur. Even if they don't take the stand specifically.
Please, my lord. Now
the interpretation boils down to that, then
now, my lord, the only reason there is then that now they say in the affidavit in opposition that because you did not take permission prior
or post, that has to be seen.
Prior or post. Now, and then also, my lord, then your lordship will kindly test it on the, my lord, doctrine of reasonableness, my lord, or Wednesbury unreasonableness, doctrine of proportionality, whether 10,000 has whether when the fixed fee is 10,000, whether my not taking a permission earlier can saddle me with consequences of 10,000 to 18 lakhs. Now, may I just, in this context, conspects of the facts, my lord, these facts are, my lord, I would say uncontroversial, my lord. I have tried to keep the facts as uncontroversial as they can be. Kindly see, my lord. Page 82, my lord, is the order of amalgamation. P4 is the order of amalgamation.
Right.
I'm not troubling your lordship with the Supreme Court decision in my favor or in the favor of my predecessor interest. Page 82 is the order of amalgamation.
Yes.
In the matter of your lordship, we'll see Alpha Stitch Art, which is the transferee company, and the rest are the, my lord, transferor companies. And Sona Promoters, my lord, will find at page 85.
Right.
Sona Promoters, to whom this lease was granted, my lord. It is described as a transferor company number 5 at page 87. And I am, my lord, the present petitioner, described as a transferee company, paragraph 2 at page 87. Now, my lord, I write to them at page P5 at page 98. This is my first intimation to them, 15 July 2020. All this while the matter was pending in the Supreme Court and was finally disposed of by an order of 18th March 2020. That order is also annexed, my lord, if your lordship just wants a reference.
18 March 2020.
Yes, it's P3, my lord, at page 62. The eviction proceeding was held to be bad and quashed. The order starts at page 62.
This is the same judgment which said that the Act of 76 will apply where there is a construction, but if it is vacant land, it will 62 Act will apply. And Lord, the judgment held that this was a vacant land, therefore the proceedings under 76 could not, Lord, be maintained. That is this judgment.
So, my lord, this was decided in favor of my predecessor in interest. The eviction proceedings were quashed. Now, this happened, my lord, kindly, the date is of some significance, my lord. This was the order dated 18th March 2020. The order of amalgamation, my lord, was made on 17th March 2020, which my lord will find at page 96 bottom, my lord. I'm sorry, 5th March 2020 at page 82 is the order of amalgamation.
Right.
So the amalgamation was, my lord, during the pendency of the appeal. Now, my lord, I write to them on 15 July, by the judgment and order dated 18th March 2020, the Apex Court had dismissed the SLP filed by the Small Industries Development Corporation and observed that the eviction proceedings initiated under the Government Premises Regulation Act was illegal. Having decided so, the order passed by the Honorable High Court is now upheld. Therefore, the natural conclusion is that the fact finding by the Honorable High Court while disposing of the writ petition stands affirmed. Copy of the judgment so and so. Sona Promoters is now at their liberty to proceed with construction process which remained held up for 6 years due to the legal suit at plot number so-and-so at Tangra. That is the proceeding instituted by them alone. In this connection, we would inform you that by the order of the NCLT dated 5th March 2020, Sona Promoters has been amalgamated with Alpha Stitch. We are attaching here the order of the NCLT dated so-and-so along with copy of the MCA depicting the present status as amalgamated. We would request you to henceforth all the matters relating to Sona Promoters may be transferred, recorded in the name and account of Alpha Stage and all communications. So, Malad, this is the intimation. Now, Malad, from these dates, the question of taking any prior permission prior to entering into the scheme of amalgamation not arise because the matter was assailed by them before the Supreme Court. So, Malad, before the Supreme Court order finally came in my favor, question of taking any prior permission would not arise. Now, Malad, kindly see the response. P6 at page 100. Please refer to the above so-and-so. You are requested to submit the following documents. Present shareholding pattern before and after amalgamation, memorandum and articles of association of both the companies and MGT 7, returns submitted to the ROC, names of all directors and shareholders with percentage before and after amalgamation, ID proof of all directors, shareholders and company PAN. Your prayer will be processed after receiving the documents. I reply, my lord, by page 101, by which I give them the documents which they are required, which is required of me. Now, my lord, kindly see the reference at reply at P8 at 102. They call me for a meeting. Now, my lord, pursuant to that meeting, I reply to them on 9th December. The meeting is held on 8th December. I write to them on the very next day on 9th December at page 103. Please refer to the above and the discussion in the meeting held on 8th December in your chamber in presence of your company secretary, manager, and our representative. As discussed, we are submitting shareholding pattern on Demri Finvest Private Limited before amalgamation with Alpha Stitchart Private Limited. This was one of the transfer companies. For what they sought, I don't know, but they sought this also. The land was allotted to Sona, but they sought the shareholding pattern of Demri. Further, we would refer to a letter dated so-and-so where we have submitted all relevant documents as asked for. We date your letter number so-and-so dated 29 September. Please find copies of public notice issued in popular English and Bengali daily in compliance with the NCLT directions in connection with the amalgamation. Please take necessary action so that the amendment could take place in your record post the amalgamation. I'm going to kindly have the next volume, please. Well, the documents are there.
Yes.
In the next volume, I need not trouble your lordship with, these are undisputed. There is no controversy that the management is the same. Now, your lordship kindly sees the third volume, please, my lord.
Yes.
Till page 297 are all the documents, my lord. Now comes 298, please, my lord.
Yes.
On the basis of your prayer dated 5th October 2020 and 9 December 2020 for the proposal of amalgamation of Messrs. Shona with Messrs. Alpha in respect of plot number so-and-so may be considered as treated as transfer case as per norms of this corporation, subject to fulfillment of the following terms and conditions. That you will have to pay rupees 18,76,000 only towards transfer charges. Well, kindly make a note, towards transfer charges, and 3,37,000 towards GST. Then the lease will be transferred, etc., etc. Well, the rest is their standard clauses, my lord, with which I have no grievance. My only contention is with apropos serial 1. Now, my lord, kindly come to my response at page 12. I say, my lord, in this letter, after receipt of their letter, I say that in paragraph 3, as the instant case is a matter of amalgamation and not transfer, only service charge of rupees 10,000 will be applicable. So I say this is not a transfer. Now, my lord, my stand here may not be strictly correct in light of the Supreme Court decisions, but I'm not on the nomenclature because I'm showing your lordship, my lord, on the terms of their documents.
Right.
Now, I sent a reminder at page 302, my lord.
This amalgamation and transfer referred to their clauses.
Yes, their clause.
Not transfer as per you.
Transfer as in the, as is considered by the Supreme Court. Now, my lord, kindly see, just for the sake of, my lord, page 303, once if your lordship sees,
yes,
the commonality of the shareholding patterns post and pre-merger and the list of directors is also given, because we are stressing our point that the directors remain the same.
Yes.
Now, 304 is from where I come to learn that the basis of their decision is on the basis of a legal opinion. They write to me saying that no, all this has been considered in a legal opinion which we have obtained, and so we treat this as a transfer. Therefore, my lord, I request them to share a copy of the legal opinion, and at 305, I request them for a copy of the legal opinion as also, my lord, their norms, because they refer to their norms pertaining to cases of transfer. At 305, my lord.
Yes, yes.
Because I need their regulations, my lord. Now, my lord, kindly come to, I make a, my lord, RTI application with them, to which the response is at page 307. Kindly come to serial 4.
Yes.
I'm sorry, may I place from the beginning, my lord, with reference to your letter, that is to state that due to some legal bindings, we cannot provide the copy of opinion given by learned senior advocate. Regarding the norms of WBSIDC pertaining the case of transfer of lease, salient points are placed hereunder for your perusal. Kindly come to, in case of transfer of ownership, that is serial 2.
Yes.
In case of transfer of ownership, shifting of major share with the family, parents, spouse, children, SIDCL releases a bare minimum service charge and not the transfer fee. Then kindly see 4. Merger arrangement and amalgamation of the lessee within its group company or any other corporate action which does not lead to change in control are not considered as transfer. Though in such cases, certificate from CA is required, the other cases where the change of major shareholding in any company or firm takes place or some other entity comes to have the lease for the remaining period for the earlier company, firm is treated as transfer of lease. So they themselves say that this is not a transfer by way of amalgamation. So, my lord, I write to them again at 308, 309. I'm not troubling your lordship with, my lord, the CA certificate is at 310. We certify that Shona Promoters has been amalgamated with its group company Alpha. We further certify there's no transfer of ownership to any outside body and full control of the company has remained under the same management.
The certificate was handed over to them at any point of time, or you have annexed to the petition? Undoubtedly, you have it because you have annexed.
Yes, it has, my lord. On 23rd August, page 303, P18, the last paragraph of the letter. As desired by you, we are enclosing a certificate. I'm sorry, my lord. 308, I'm so sorry. 308, not 303. Numbering is 308, bottom, my lord, last paragraph. The CA certificate was provided to them. They sought a CA certificate. I provided the CA certificate. I called upon them to do the needful, but their stand remains the same, my lord, at page 311. So, my lord, their norms was not provided to me. They said that they gave the gist of their norms, but very fairly, my lord, they have now provided their norms in the affidavit in opposition. Now, if your lordship kindly has the affidavit in opposition and the supplementary filed by the corporation, my lord. Kindly come straight to, my lord, the document which is there at page, annexure A at page 18. This is the agenda for the 353rd meeting of the corporation. Kindly see page 19, please, my lord, agenda item number 19.
Yes.
To decide the parameters and fees to be adopted. To decide the parameters and fees to be adopted in case of transfer of lease and surrender of lease. Recently, BCC and I, that is perhaps the Bengal or Bharat Chamber of Commerce and Industries, one of the two, and this is a solicitor firm, my lord, have given their recommendation regarding transfer and surrender of lease. They suggested that the following may not be considered to be transferred by the lessor only upon examination of the applications for prior intimation. Now, my lord, kindly see, this is where the first time prior comes in, my lord. Prior intimation made to the lessor for the same by the lessee. And this is, my lord, I fall in serial 4 at page 20. Merger arrangement and amalgamation of the lessee within its group company. And 5, also any other corporate action which does not lead to change in control. A certificate from a chartered accounting certifying whether any transfer is a transfer or not. Transfer shall not be allowed, etc. Then, my lord, are the fees to be taken here? So they say, my lord, this is not a transfer. Then, my lord, kindly see page 21. Under the circumstances, proposals of the management of SIDCL are placed hereunder. We may follow the recommendation of BCC and I and Aquila in the cases which may not be considered as transfer. In case of change in constitution or merger arrangement and amalgamation of the lease within its group company, major share must be retained by the original lessee. In these cases, my lord, kindly see, WBSIDCL shall realize the prevailing service charges. Only service charge, my lord, nothing else. Then, my lord, kindly come to the next meeting at page 23, please, my lord. This was the agenda. Now, my lord, kindly see the minutes. Minutes of the 353rd meeting. That was the agenda, my lord.
Yes.
And if your lordship kindly turns to agenda item number 19 at page 24, my lord, 19-353.
Yes.
To decide the parameters and fees to be adopted in case of transfer of lease and surrender of lease. Now that all this discussion takes place, my lord, I'm not troubling your lordship with the discussion. Kindly come to page 26.
Right.
General policy for transfer of lease. The WBSIDCL allows transfer of lease subject to obtaining prior approval in writing from WBSIDCL. No transfer of allotment or leasehold right is allowed within 5 years from the date of issue of normal transfer offer so-and-so. The transferor and the transferee, kindly see, the transferor and the transferee shall make an application in the prescribed format of SIDCL for seeking prior approval for such transfer upon payment of rupees 2,000 to be deposited by the transferor as application of processing fees. Prior to giving the approval of such transfer, the lessor to ascertain that there is no outstanding dues to the lessor by the lessee. So, prior approval, 10,000. The following cases are not considered to be transferred by the lessor only upon examination of the applicants. Again, for prior intimation made to the lessor for the same by the lessee. And then I fall in, again, serial 4 at page 27. Merger, arrangement and amalgamation of the lessee within its group company. And then, kindly see, in these cases, transferor and transferee, about 2 paragraphs after that.
Yes.
And the requirement is the certificate from a chartered accountant,
Right.
which also has been provided. Now, in these cases, transferor and the transferee shall make an application in the prescribed format of SIDCL for seeking prior approval for such transfer upon payment of rupees 10,000 as application processing fee. Prior to giving the approval of such transfer, the lessor to ascertain that there is no outstanding dues to the lessor by the lessee. And this is approved, my lord, at page 28. The recommendations of these after discussion, your lordship sees the second paragraph at 28 top.
Yes.
After discussion, the board of directors approved the proposals of the management as follows. The recommendations of so-and-so in the cases which may not be considered as transfer will be followed. Now, in case of any change in constitution of or merger, arrangement and amalgamation within its group company, major share must be retained by the original allottee. In these cases, SIDCL shall release the prevailing service charges. In the rest of the cases, the application will be done at this rate which is given there. My lord, the transfer fee is given in the proposed fee structure. And this is the fee now which is being charged from me, my lord, 15%. The rest is not relevant, my lord. Now,
Your impediment is that prior approval.
prior approval is the only stumbling block. Kindly see now, my lord, page. They have now disclosed by obtaining leave from your lordship, they filed a supplementary affidavit. A supplementary affidavit to bring on record the board meeting of the 364th minute. That was 353rd.
Yes.
Now, by the 364th minute, this was according to them, my lord. But what they've annexed is again 353, and it is the same document, my lord, I find. Because
Yes.
at page 7, it reads minutes of the 353rd meeting held on 3rd June 2019, which is the same document, my lord, which I just placed before your lordship, my lord, at page 23 of the opposition. I'm not so concerned with the 364th, my lord, because the 353rd adopts the resolution. The only issue now is, my lord, should I be penalized from 10,000, which I am otherwise there's no dispute, which I am entitled to, and should I be penalized from 10,000 to 18 lakhs for not taking prior approval? I have a twofold answer, my lord. Question of taking a prior approval in the facts of this case did not arise because the amalgamation took place during the pendency of the litigation between the parties, whether the lease would survive or not. If their contention was to be upheld by the Supreme Court, then the lease would stand, my lord, terminated. And the eviction proceedings were...
Can you please give me the dates again once?
Yeah, yes, my lord. The judgment of the Supreme Court, my lord, is dated 18th. Can you give me a minute?
Yes, take your time.
18th of March 2020 is the judgment of the Supreme Court by which the eviction proceedings were squashed. The order of amalgamation, my lord, by which the lease stood transferred to me by operation of law is 5th of March 2020.
Yes.
So, my lord, the transfer takes place by operation law only on 5th of March. The process is instituted prior. The scheme of amalgamation, my lord, your lordship has seen is a composite scheme in which there are as many as 5 transferor companies. The transferor companies and the transferee company belonging to the same group, my lord, they rearrange their affairs, and to do so, they enter into the scheme of amalgamation, which is recognized in law as a means for companies to rearrange their affairs. When this application was made, my lord, there was already a litigation between Sona, and by which the lease to terminated eviction proceedings had been instituted. So at that stage, my lord, when the transfer in law took place, there was no question of taking prior approval because there was, in the eyes of the, according to the respondent, there was no lease in subsistence. Making an application to them for prior approval would be an idle and empty formality. Because in spite of the order of the Honorable Division Bench of our court, my lord, quashing the proceeding, they preferred an SLP, which was then pending, disposed of only. So that is one, my lord. Prior approval would not have, my lord, in this case, facts of this case. Then the question may arise that you should have waited. If you were so.
Mr. Thakur, please just clarify me on the proceeding once again. The scope of that proceeding, which was
the scope was an amalgamation.
Yes.
My lord, the transfer of the lease
went up to the SC ultimately, to the Supreme Court ultimately.
Oh, my lord,
Yes.
that was if your lordship kindly takes the order once of the Supreme Court.
Yes.
The government had started, my lord, eviction proceedings against me under the Act of 76.
Yes.
Kindly see page 65. Paragraph 8, my lord, the facts are summed up by the Supreme Court. On an application by the respondent number 1, the corporation executed a first lease deed dated 14 December 7 in favor of the respondent in these plots of land. The possession was handed over on 17 January 28. A lease deed was executed on 4th March in respect of plot 8. Now, my lord, on 10th October 2012, the corporation issued a notice calling upon the respondent to show cause as to why the tenancy should not be terminated for violation of the lease. This notice was issued invoking clause 3. I replied, my lord, predecessor in interest replied, since nothing was done, well, kindly see 66. Since nothing was done.
You can give me just the dates of the first order of eviction High Court order and then the
Yes.
relevant dates is.
Yes. Now, my lord, the lease was terminated on 9th November 2013.
Yes.
And I was directed to vacate the premises.
Right. Right.
And then, my lord, I filed the writ petition for quashing the termination notice. And 16th January 2014, the appellate authority, my lord, upheld the order of, my lord, termination. And I was called upon to vacate the plots in question. Then I filed, my lord, the writ petition assailing the order of 16 January 2014.
Yes.
So the order of by 16 January 2014, my lord, in the eyes of the respondent corporation, my lease stood terminated. If my lease stood terminated, then I asked myself this question, my lord, where's the question of applying to them for prior permission when I'm entering into the scheme of amalgamation?
Now, amalgamation was entered later.
Amalgamation was much later.
So what happened before the single judge?
Single judge granted me interim protection, my lord. Paragraph 13 allowed me interim protection. A sale before the division bench.
Interim protection means stay of that order.
Stay of the order.
Date?
Well, that order date.
Anyway, when was that was assailed before the Supreme Court?
That was assailed before the division bench unsuccessfully. That was assailed before the division bench. The division bench disposed of the appeal as well as the writ petition that the premises is not government premises and Act did not apply. So, my lord, at the appeal stage, writ petition was allowed. From that final order, my lord, the appeal went, the SLP went up.
Can you give me the date of the division bench?
Just give me a minute. Yes. 19 September 2014.
Thank you.
The order is not annexed, my lord. I've created.
Need not. I just
19 September 2014.
If it is stated somewhere, that will do.
Yes, paragraph 11, my lord, of my writ petition.
Right.
19 September 2014. The civil leave appeal was, my lord, 2201 of 2020.
Is that the Supreme Court was
Rejected.
moved?
Yes.
18th of March. That was affirmed, brother.
That was, my lord, it was the division bench order was affirmed.
Yes.
The special leave petition.
Division bench was affirmed, right?
Yes, division bench was affirmed, my lord. So, my lord, from
Division bench was not affirmed. There was division bench judgment has not been affirmed.
Division bench had allowed the writ petition.
Allowed the writ petition, holding the entire proceedings to be not this 76 Act does not apply. That was the finding. Not which was varied by the Supreme Court to the effect that 76 Act will apply only in respect of properties which are constructed. If it is vacant land, it would not apply. This was the distinction that the Supreme Court has drawn.
No, but that eviction order was virtually set aside by the Supreme Court. By the
eviction-
paragraph 33, if my lordship,
just
paragraph 33 at page 80 of the Supreme Court order. I was not there at that stage, so my learned friend will correct.
But what had happened
The
is,
High Court in the concluding paragraph of the impugned judgment has held the High Court in the concluding paragraph, that is the R division bench, my lord, paragraph 33 of the Supreme Court order at page 80. The High Court in the concluding paragraph of the impugned judgment has held that the corporation has to seek eviction of respondent number 1 from the premises in question under the provision of the West Bengal Public Land Act of 62. We are entirely in agreement with this view of the High Court. So not under the Act of 76, my lord, not under the Premises Act, but under the Land Act of 62. To conclude, while upholding that the appellant corporation is a government undertaking within the meaning of 2B, we further hold that the premises in question does not come within the definition of 2A, reserving liberty to the appellants to seek eviction of respondent numbers 1 and 2 from the land in question under the Public Land Act. We dismiss this appeal. So this is of 18th March 2020.
So the effect of the division bench order was upheld by the Supreme Court,
Yes,
which
please.
was that that eviction order goes.
Eviction order goes.
Right, yes.
So, my lord, now the eviction order and the order, my lord, terminating my lease. Yes.
Rather, yes.
Yes. They are terminating my lease. So, my lord, the lease, as your lordship has seen, was determined by a notice of November 9, 2013. The proceedings on that attained finality only by this order of the Supreme Court of 18th, this order of 2020.
18th March 2020.
18th March 20. Now, in the interregnum, my lord, any application for transfer of lease does not arise.
But as on March 5th of March 2020, it may be argued, Mr. Thakur, that as on that date, the division bench order was prevailing, which is that the termination had been set aside. So there was a lease.
So there was a lease. Yes, my lord, by playing the devil's advocate, yes.
Yes.
My lord, I'll just check whether there's no question of stay here because
No scope of stay. Yes.
yes, your lordship is right
It
to
would
that.
tantamount to
Yes.
allowing this.
So the interregnum between, yes, your lordship is right. The interregnum between the order of the division bench,
Yes. And the Supreme Court.
yes,
So
2014 and Supreme Court, yes. To that extent, your lordship is right that I could have, but they would still have refused. Because they would have said, yes, my lord, kindly see, it would have been an
it was
exercise.
sub judice at least.
It was an exercise in futility. Even if I took advantage of the division bench order and approached them, when I know that they made an appeal before the Supreme Court, the result would have been a resounding no. Now, my lord, what fell from your lordship, my lord, of the gap, my lord, is not a stand taken in the opposition. The stand taken in the opposition is, my lord, now the stand which comes in the opposition is that you did not take prior permission. Now, this is, my lord, this is perhaps, my lord, with the greatest of respect, an argument in desperation, because now that they see that everything is in order, now they take this stand. My lord, kindly come to paragraph 18, please, my lord, at page 11 of the opposition. And my lord, kindly also consider paragraph 15, where there is a kind of a veiled threat at page 10.
Yes.
In the facts and circumstances, there were two options open to the respondent: either to initiate proceedings for eviction against the writ petitioner who was a trespasser in respect of the government land, or to accept transfer and the transfer fee, thereby accepting the petitioner as a lessee by transfer assignment of the lease instead and place of the. This, my lord, gives the flavor of
the interregnum. Yes.
No, my lord, this does not take. This is the flavor of general radio, because their lordship kindly see.
Right.
This paragraph 14, 13, these are all, my lord, relating to clauses of the lease deed. They rely on prohibiting transfer and parting with possession. So till paragraph, my lord, 14 is general radio. 15 is the veiled threat that I could have evicted you. But I am being nice to you. I'm taking the transfer fee at 15.
This takes care of the interregnum for you. The interregnum between the High Court division bench order and the Supreme Court order. The question which I posed to you.
Yes.
So that period, regarding that period, you said that it would be futile, even if you applied. So that stand is rather vindicated.
Paragraph 15, yes.
Maybe.
Yes. Could be, my lord.
So if that is their stand, then that would be a futile exercise.
Yes. And now, my lord, kindly see now how the stand changes, my lord.
Yes.
Now, kindly see how the stand changes. Kindly now see paragraph 18 at page 11.
Yes.
The writ petitioners in the present writ petition, to support their contention, have also relied upon a reply dated so-and-so issued by the SPIO of the respondent number 1 under the...
Should I release the other matters? I think.
Please, my lord, yes.
Other matters are released. Yes. Including Mr. Chatterjee's order. Yes. And his entire gang. Yes. Yes, Mr. Thakkar, I'm sorry. Please continue with para 18. Yes.
It's good to see Mr. Chatterjee back in court, my lord.
Mr. Chatterjee is sitting there with his gang. Literally a gang. Just see, look behind you.
I've been hounded. They thought the next matter was say hounded. Not going. It's trying to sleep, but I couldn't.
Anyway, Mr. Thakkar, please continue.
Yes. My lord, kindly come to paragraph 19 now, my lord. This is the reply which I showed your lordship, my lord.
Yes.
And kindly see paragraph 19. The letter dated so-and-so issued by the SPIO is based on the general policy of transfer of claim by the board of directors for the respondent number 1 as recorded in the minutes of the so-and-so meeting. And then they give me a copy of the minutes. Now kindly see paragraph 20. The general policy for transfer of land is based on a precondition of obtaining of prior approval in writing from SIDC. The said policy has no manner of application in the facts and circumstances of the present case. Since no prior approval from the respondent number 1 was obtained by Shona promoters prior to its amalgamation with the petitioner number 1 company, the writ petitioners cannot take advantage of the said clause. The purported amalgamation done without prior transfer consent. Now, kindly see, the purported amalgamation done without prior consent is a voluntary transfer without permission of the lessor. Thus, the petitioners are liable to pay transfer fee at the rates and on terms and conditions as more fully stated.
Mr. Thakkar, when you were arguing this point, you started arguing this point, you said there are 2 points. You will be distinguishing on 2 grounds, that prior point, prior approval point. One is this, that it could not have been possible to do it prior. Is there something else on
The
prior?
second is the unreasonableness of the demand. Second is the unreasonableness.
So you will elaborate on that also.
On the unreasonable. Now I'm showing your lordship how the stand changes. Till 14 is the stand that this is a transfer in terms of General Radio Abdul Qadir, and you are liable to be evicted, which is contrary to their own policy. Cannot be evicted. It is now prior and post. Prior approval and post facto.
Yes.
Now comes the post facto approval point. They say no prior approval taken. Then the purported amalgamation done without prior consent is a voluntary transfer without permission of the licensor. Lessor. In case the petitioner is not willing to accept the said offer, now kindly see, the stand is perhaps a bit unfair from a government undertaking who has gone up till the Supreme Court. Kindly see the last but one sentence of paragraph 21. In case the petitioner is not willing to accept the said offer, the respondent is ready and willing to withdraw its offer and proceed for eviction of the writ petitioner. The writ petitioner has occupied and so on. This is where I have some difficulty. On reasonableness, may I place 2010 6 SCC 614.
Yes.
Can you see paragraph 22 onwards, where there's a discussion, elaborate discussion on this. This is not Justice Sinha's judgment, but it's written in that manner.
No, that's Radhakrishnan.
Yes, I just checked because of the elaborate.
Yes, right.
All the English decisions are noted. Well, the judicial review conventionally is concerned with the question of jurisdiction, and natural justice court is not much concerned with the merits of the decision, but how the decision was reached. In the Council of so-and-so, the House of Lords rationalized the grounds of judicial review and ruled that the basis of judicial review could be highlighted under 3 principal heads, namely illegality, procedural impropriety, and irrationality. Illegality as a ground of review means that the decision maker must understand correctly the law that regulates his decision-making powers and must give effect to it. Grounds such as acting ultra-virus, etc. I'm not troubling your lordship with 22. Then this is where it starts. Well, kindly see 23. The ground of irrationality. Ground of irrationality takes in Wednesbury unreasonableness propounded in so-and-so, wherein Lord Green, Master of Rolls, alluded to the grounds of attack which could be made against the decision, citing unreasonableness as an umbrella concept which covers the major heads of review, and pointed out that the court can interfere with a decision if it is so absurd that no reasonable decision maker would in law come to it. In so-and-so case, Lord Diplock fashioned the principle of unreasonableness and preferred to use the term irrationality as follows. By irrationality, I mean what can by now be succinctly referred to as Wednesbury unreasonableness. It applies to a decision which is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. In R versus Secretary Home so-and-so, the House of Lords re-examined the reasonableness of the exercise of the Home Secretary's discretion to issue a notice banning the transmission of speech by representatives of the Irish Republican Army and its political party, Sinn Féin. The court ruled that exercise of the Home Secretary's powers did not amount to an unreasonable exercise of discretion, despite the issue involving a denial of freedom of speech or expression. The House of Lords, however,
you may not read the entire.
I need not read
Wednesbury entirely.
Yes. This is entirely on Wednesbury. Kindly come to a minute.
Until Justice SB has been named.
No, SB is there. He's there.
Since they have been a favorite of Justice Radhakrishnan.
Yes, 31.
So your hunch is absolutely right.
Yes, I was just thinking that how can we miss him in a decision like that. 31. Then your lordship sees 36. Wednesbury applies to a decision. Kindly see 36. Placitum D.
Yes.
Wednesbury applies to a decision. There's some discussion on Wednesbury and proportionality. And then the court sums it up, Wednesbury applies to decision which is so reprehensible in its defiance of logic or have accepted morals or so and so that no sensible person who had applied his mind to the issue to be decided could have arrived at it. Proportionality as a legal test is capable of being more precise and fastidious than a reasonable test, as well as requiring a more intrusive review of a decision made by a public authority, which requires the courts to assess the balance or equation struck by the decision maker. Proportionality test in some jurisdictions is also described as the least injurious means or minimal impairment test, so as to safeguard the fundamental rights of citizens and to ensure a fair balance between individual rights and public interest. Suffice it to say that there has been an overlapping of all these tests in its content and structure. It is difficult to compartmentalize or lay down a straitjacket formula, and to say that Wednesbury has met with its death knell is too tall a statement. Let us, however, recognize the fact current trend seems to favor proportionality test, but Wednesbury has not met with its judicial burial. State burial with full honors is surely not to happen in the near future. Then comes the proportionality. Kindly see 37. Proportionality requires the court to judge whether the action taken was really needed, as well as whether it was within the range of courses of action which could reasonably be followed. Proportionality is more concerned with the aims and intentions of the decision maker and whether the decision maker has achieved more or less the correct balance or equilibrium. The court entrusted with the task of judicial review has to examine whether the decision taken by the authority is proportionate, that is well balanced and harmonious. To this extent, the court may indulge in a merit review, and if the court finds that the decision is proportionate, it seldom interferes with the decision taken. And if it finds that the decision is disproportionate, that is, if the court feels that it is not well balanced or harmonious and does not stand to reason, it may tend to interfere.
Court feels is a keyword.
Court feels, yes.
It is.
So both, they in this.
Ultimately boils down to that in everything.
Well, I don't know,
I
have not.
Principles of law, Mr. Thakur, boil down to that.
Yes. What is it? The eyes of the court. What is in the mind of the judge? This is, all this sums it up. Applications of principles of.
Basically reasonableness and proportionality.
Yes.
Right.
42 is where it sums it up. Now, so in my respectful submission, and I will also sum up my submissions.
There is no summing up in this judgment, Mr. Thakur.
Yes, so I'll sum it up with this. It's entirely disproportionate and unreasonable in the facts of this case. Grateful.
Thank you. Yes, Mr.
Look, 4 companies have merged into the petitioner. One of them is Sona Promoters. Look, I had a contract with Sona Promoters. I had let out the land in one of the industrial estate on certain terms and conditions. There are 2 plots of land which were leased out on the basis of registered indenture of lease. Now, Lord, one of the condition was that within a period of 3 months, they have to start constructing the factory shed or their whatever office or factory shed, whatever they were constructing. This condition was violated. As a result, the lease was terminated. The termination of lease was only on this condition that they did not commence construction within the time stipulated or within the extended time also. Now, Lord, this was challenged on a small ground that this power can't be exercised under the 76 Act because there is no construction. Now, Lord, on that, the first day they obtained the order of injunction was, Lord, on January 2014. Date ta dao, ekkuni to chilo ei order. This is the Supreme Court judgment. Can you give me 1 minute? No, you gave me the date.
16 January, probably.
16 January 2014.
Yes, Mr. Thakur gave that.
That interim order.
Oh, interim order?
Yes.
No.
I'll give you a
That is not the interim order date. 16 January is the appellate court's upheld, yes.
Just give your lordship.
Must be immediately after that.
Lord, paragraph 12, 29th of January 2014.
Right.
If your lordships may kindly take that Sona Promoters judgment, kindly come to paragraph 12. Your lordship will get it from there. I'll just give your lordship an overview today because, Lord, obviously I have to come back. So
Let us then come back, Mr. Kaur, because
I tell your lordship, my
Yes, yes, you can, please.
basic contention is, I'll come back, obviously.
yes,
Basic contention is that if they say today that because of the termination, the lease, we could not take a decision on the lease. Lord, when an amalgamation order is passed, it's based on a scheme. In the scheme, one has to claim that these are my assets. On amalgamation, these assets will vest in company X. And Lord, they treated this lease as their asset for the being transferred in favor of company X. If they say today that termination, I was uncertain, I didn't know whether this lease should be mine or somebody else's, then Lord, their scheme will disprove them. Today, the stand they are taking is contrary to their scheme. This asset must have been shown in the scheme. Otherwise, Lord, the petitioner before your lordship could not have claimed this as their asset.
even if it was shown in the scheme, Mr. Kaur, how does that
Lord, this is the shown is obviously
to be shown? Yes.
that is based on the interim order. Therefore, Lord, they proceeded on the basis that there was no termination of lease. That is what I want to say. Nothing more. So, Lord, this bogey that has been raised today, that there was termination, so uncertainty, etc. There was no doubt in their mind that there is no termination. Lord, could I come back, Lord, on Friday instead of tomorrow?
Whenever. Lord, heard in part for further hearing on 28th, July 28th.
Lord, my lord, regarding item number 4, my lord, is kept tomorrow, my lord, can even Friday, my lord, we need some time, my lord.
Keep somebody tomorrow, renew the same prayer. I'll pass that order.
I'm grateful.
Not at this hour when nobody else is there.
Mr. Kaur is the other
Mr.
side.
Kaur is for the other side.
Yes. I very Friday.
Just renew the prayer through somebody tomorrow. I'll
Yes,
tell
I'm grateful. I'm grateful. So, calculate time.